family history, I'm very much interested in this topic, and I think it's very important. It's very important that this is discussed. That this is discussed in an historical and important institution like ours. And it's important that European people keep thinking of this. This is, one of the things on which we found really the foundation of our society cannot avoid thinking of these processes. And I'm sure that this is an opportunity for you to develop new idea, to share experience. And every time there is this meeting of ideas, of different experiences, always something good happens. So this is what I wish you, to come up with something.
Prof. È iniziata anche la... Prof, mi sente?
Yes.
Damiano.
Ok.
È iniziato il broadcast su YouTube e l'ho mandato il link.
He wants to say that it's going on YouTube in the same time, so you can follow this, and whoever wants to follow on the YouTube, and probably we will be able to to keep it on YouTube for those who were not able to follow at this time. I'm sorry, Professor. I'm sorry, Rector, for this. I think that Damiano maybe didn't realize that you were you were just talking and delivered this inauguration.
No, it's not a problem at all. Anyway, I was basically done. I just conclude saying that I'm really sorry that I cannot attend the day because I had other commitments. But this is a good news, the fact that this will be available afterwards, such that even people like me that are interested, even if cannot participate to the discussion, will be able to catch up later on. And again, congratulations for this. I wish you all the best for this work, and I'm looking forward to knowing what are the ideas that will be developed during this meeting. Thank you very much, and all the best.
Thank you very much, our Vice Rector, for those kind words. Thank you very much. We are really delighted that you were able to make and introduce this event. So thank you for coming, for those warm words, and I hope that we will have very fruitful day today. So thank you again. Right, now thank you very much to all. I just would like to say that how did we organize this event, and what sort of planning we have today. So we looked at vulnerability from the position and from the definition which we have in the SIA system. Then we might consider that the UN Convention on Disability, or the general definition of disability, might have some differences in this, and this would be a very interesting topic to explore. We also considered this topic from multidisciplinary perspective. So we have here some historians, we have political scientists, lawyers, who approach this topic from different perspectives. So there is absolutely nothing wrong, and that provides more details and more ideas to protection of vulnerable group. I should say that first of all, so let's introduce our first speaker. I'm really delighted that we have some representatives at the national Red Cross at national level, and this was also a very important element of our Jean Monnet activity, to incorporate in our work NGOs, local NGOs, national NGOs, and to exactly discuss things in practice. I also saw Dr. Federica Baltasari will present vulnerable groups in the migration routes, separated families and missing persons. And I think that this is a very, very interesting contribution, because finally we have not seen, we divided the definition in several ways, but we have not considered this. So you were the only one talking about separate family and missing persons, and this is a very important topic. So thank you very much for being here, for being enthusiastic about the event and accepting our invitation. So Dr. Baltasari, the floor is yours. Do you know how to share the screen if you have PowerPoint?
No, I will speak.
You don't have any PowerPoint. Okay.
Yeah, thank you.
No problem whatsoever. Okay, so the floor is yours.
Thank you. Good morning, everybody. I'm Federica Bellassai. I know that my surname sometimes is difficult, but it's Bellassai from the Migration Department of the Italian Red Cross. Firstly, let me thank Mrs. Gromek for this invitation, because for us it's a pleasure and an honor to be here today with you to discuss about these important topics for us, because the support to the family members of those missing, for the Italian Red Cross and for the movement of the Red Cross and Red Crescents is crucial and is central for us, for our intervene, especially in the framework of migration. That is one of the major challenge that the Italian Red Cross is facing in these years. In the context of migration, the Italian Red Cross supports people during the journey thanks to the capillarity of the International Red Cross and Red Crescent movement. Especially in Italy, the assistance to the migrants is provided during the presence in the country, and specifically, the Italian Red Cross assists people upon their arrival by sea, in the border, and in the transit areas, as well as in the reception facilities. A mention should be made with reference to people on the move, assisted by the Italian Red Cross through the humanitarian service point in different locations of Italy. When we speak about assistance to migrants, we talk about a comprehensive approach, comprehensive protection approach customized to the specific vulnerabilities and need, regardless the legal status of the people, of the migrants, that for us is really important to underline. With regard to the mentioned protection approach, we have to take into consideration the vision of the International Red Cross and the Red Crescent movement as a whole. Alleviating the suffering of the vulnerable is indeed part of the humanitarian mandate of the Italian Red Cross, in compliance with some international strategies. One of these is in particular the International Federation of the Red Cross Global Strategy on Migration 2018-2022, reducing vulnerability, enhancing resilience. It includes a definition of migrants as a person who leave or flee the habitual residence to go to new places, usually abroad, to seek opportunities, safer and better prospects. This includes migrant workers, stateless migrants, migrants deemed irregular by public authorities, as well as asylum seeker and refugee. In this framework, we move to the concept that we adopt in terms of vulnerability. Vulnerabilities as expressed in the IFRC migration policies and as reflected in 10 points and 10 principal mentions is a concept very, very particular and that influence our activities with people, especially with migrants. In this humanitarian approach, all the action are undertaken based on migrants' needs and vulnerabilities, regardless the legal status. Among these principles, of course, it's relevant for us to mention the special focus on the needs and vulnerability of migrants, as well as the support to their rights, for example, the humanitarian advocacy, and the action aimed at alleviating the pressures sometimes in the country of origin and the communities of origin. Vulnerability in this context can be defined as the diminished capacity of an individual or a group to anticipate, to cope with, resist, and recover from the impact of a natural or man-made hazard. The concept is really dynamic and also relative. Vulnerability sometimes is often is sometimes associated with poverty, but it can also arise when people are isolated, insecure, defenseless in the face of risk, shock, or stress. In line of this vision, the Italian Red Cross considers the separated families and the families of those missing as people in a particular vulnerable condition. Assistance and protection to those vulnerable is ensured thanks service, an international worldwide service that is called Restoring Family Links. The RFL service works worldwide to prevent separation, help families to restore and maintain the contact with their loved one, as well as support family reunification, clarify the fate and the whereabouts of the missing. In this framework, for us, it's really relevant also mention the Geneva Convention, specifically the first protocol, the first additional protocol to the Geneva Convention on the protection of victims of international armed conflict. Because in that protocol is established a general principle: all parties involved should be prompted mainly by the right of families to know the fate of their relatives. This principle guides the action of the Italian Red Cross as part of international movement. Also, the concept of missing person is really important for our mandate and all the action we do in our territory and in our services, because a missing person is the person whose whereabouts are unknown to the relatives or to the families, or sometimes based on reliable information has been reported missing in accordance with the national legislation in connection with an international or non-international armed conflict, a situation sometimes of an internal violence, natural catastrophes, but especially including, and this is for us important to underline, any other situation that may require the intervention of a competent state authority. If the disappearance affects many dimensions of the society, especially in the context of migration, this is really important because migrants are one of the most affected by separation from their family members. In 2003, a conference of experts convened by the ICRC Red Cross, the International Committee of the Red Cross, identified several specific needs on the basis of the experiences of families of missing persons. Those needs continue to be actual within the experience of the Italian Red Cross in the framework of migration and according to our experience. Among those needs, we can mention a lot of different needs we collected in these years. For example, the need of the family to know, to ensure commemorative rituals, to receive legal, administrative, economic, and also psychosocial support. When it comes to mention specific vulnerables potentially in need of assistance, we have to refer, for example, to migrants arriving by sea. I don't know if probably you know that the Italian Red Cross this year is also present during on the quarantine boat due to the COVID-19 pandemic, or for example, the unaccompanied minor assistance to them is provided according to the law and according to the different need they have and they present, as well as the potential victim of trafficking, because with them we meet different challenges in our action. They require attention to protect them from the risk to be reumatized, but sometimes also re-trafficked. Go to the challenges. The Italian Red Cross is facing several challenges while assisting separated families and families of people missing in the Mediterranean Sea in particular. First of all, assuring protection means also protection of personal data of people in need, especially for the principle do not harm, inspiring all the action we do to protect people, especially in consideration of the migration phenomenon, that itself means to assist worldwide families through the Family Links network by sharing personal data of both migrants, inquirers, and their missing loved one that we don't know about their whereabouts. Secondly, also families need assistance to clarify the whereabouts of their family members, and sometimes is really important to facilitate the dialogue with all the competent authorities, especially in the framework of the identification procedure for migrants victims of shipwreck that occur in the Mediterranean Sea. The fragmentation of the legal framework is a challenge, and especially the different practices adopted in the field to recover and manage the bodies of migrants that for us represent an additional element that should be taken into consideration. We can say that together with the fact that in most of the cases, families separated are abroad, all these elements in a certain way increase the state of vulnerability of the people. Also the concept that sometimes influence the family member that are waiting for answers in the country of origin. We can talk about also on the concept of ambiguous loss and all the related aspects that are linked with the ambiguous loss. For example, the psychosocial support and also the accompaniment of the family members during all the procedure that involve the clarify the whereabouts of their family. Particular mention also to the victim of shipwrecks, especially in the Mediterranean Sea, because our country is really affected by these tragedies and these critical events. The mention of the migrant surviving shipwrecks is fundamental in the sense of considering their vulnerabilities and their vulnerabilities as well as the importance to involve them in the process aimed to clarify the fate of the missing person of that particular incident, for example. On one end, the Italian Red Cross is working to assist separated family by collecting data as part of the effort aimed at clarify the fate and the whereabouts of the missing. But in the other end, it should always take into strong consideration the specific vulnerabilities also of the witnesses of this tragic event occurred in the sea. sea. In particular, we refer to the risk of traumatization to live again that memories, as well as the need of a target psychosocial support. To conclude, all the diversity of need due to the disappearance and its related challenges require an holistic approach, and this is really crucial for us. It should include action taken to all the levels and by several stakeholders. For example, the accompaniment of the family of missing during the identification procedure, the facilitation of the contact with the competent authority, and also the role of the forensic, especially when it comes to procedure aimed at comparing the DNA of the families and the bodies. The Italian Red Cross is working on this sensitive file in order to provide response to the family of the migrants to whom they have been separated due to the several reasons, as well as to provide and to give dignity to the body of the migrants that died trying to cross the Mediterranean Sea. This is our experience, and I hope it was interesting for us to understand a little bit our framework and our scenarios. And thank you very much again.
Thank you very much. Did I mispronounce your name, Balasai, at the beginning? Maybe the accent was wrong. So
don't worry.
Right. So thank you ever so much. This was extremely insightful and very interesting talk. I would have several questions and maybe several points that we might discuss or develop further on. For instance, exactly this vulnerability in the rescue operations, which at one point was even my talk somewhere. Also, well, exactly what sort of support is missing. So this would be also my question. But first, I will open the floor for other questions. So any questions? Anybody has a question? So please, because I'm sure that well, we could collect different talks and do questions later on, but I know that people are busy, so they want to do different things. So any questions? Anybody wants to ask the question? It's too early. Can you hear me? Yeah?
Yes. Ciao. Hi.
Oh, hello, hello, hello. So any questions?
Nothing.
You have one?
No.
No, so I have those questions. So what do you think for these vulnerable groups? What could we do more? I know that my question is maybe too general. So maybe because you were mentioning in rescue operations. So what sort of support we need to have to be more effective? So, well, as I said, in rescue operation, this could be at the national level, but also at the European level. So what sort of laws, what sort of improvements we could make to this?
We can say that for the Italian Red Cross, for example, especially because we are not involved in the rescue operation, but we are involved in the period of quarantine of those arrive in Italy.
This is very, very sort of up-to-date topic. So, okay, so yes.
Yeah, but we can say that in a certain way is the same, because the period from the rescue and the period of quarantine is really in the framework of the time is really small, because people are rescued sometimes in the sea and then they move on the quarantine boat, for example. And what we do as a Red Cross in terms to support and protect the people and to prevent the separation is the Restoring Family Link service. So what we do is firstly collect all the cases of separation among family members. Of course, separation, as already said, could be mean a different option. We can have people that probably are separated during the journey from the country of origin, or sometimes it could also happen that people are separated on different quarantine boat or different reception center. So as Italian Red Cross, we collect all the information from the people in order to support them in the reestablishment of the contacts. So this is one of the activities we do. Sometimes, as already mentioned, people is missing because probably is died in the Mediterranean Sea. And this is something that unfortunately we collected a lot of times. What we do is to support all the family member in the procedure that could be that is involved in the identification procedure. So we when the situation is possible, we speak with all the people to collect some information, first of all. So we try to understand in that specific circumstance who were on board of that small boat, to understand if the person was trying to cross the border, or if the person, for example, is still in Libya, because sometimes we don't know, because around the missing of a person, we don't know how many aspects are there, because sometimes the family member in the country of origin do not know about their loved ones for many reasons, because the connection is not like in Italy, is not like in Europe. The telephone mobile is broken, there is no Wi-Fi, the person are in jail, or sometimes the person are arrived in Italy, but they do not know how to restore the contact. But especially in case of missing in terms of victims of shipwreck, we collaborate also with some forensic institute to accompany the family members to the collection of DNA sometimes, when of course we can compare the DNA. So is really interesting, but at the same time really challenging, because as you may imagine, during a shipwreck, sometimes the body is not, there is not the body, for many reasons, because sometimes the body is not recovered, or because the sea totally destroyed the body of the person. So you can imagine how it's difficult for a family members to accept that they will never know if the body of a loved one is died or not. That's why for us these topics of missing person is extremely crucial, because it's extremely difficult also to support in the whole procedure the family members since the beginning. So since the collection of the bad news, I don't know if my family is alive or not, till the end, that sometimes at the end we are able to provide an answer, but sometimes no. So it's really important to provide the right psychosocial support to that person or to that family. So I don't know if I gave a proper answer to your question.
Absolutely,
but...
absolutely. wait 1 second, because maybe some other participants academics, NGOs, they have some questions. I was hoping that I have another one if nobody comes forward, but I really want somebody to come forward maybe, and some other questions. So I'm sure that there is, well, the next speaker is a professor from York who is, no, we don't, just I'm only telling that he is, well, he advocates and he works as a human rights defensor and so on. But his recent research was about exactly COVID-19 in the area, in this area. So I have a short question. So how about the vaccines? Would they be vaccine? Well, do you know something about it? Yes, I'm talking about migrants. I'm talking about, yes, because you were talking that you were saying that you deal very much with the quarantine. So I'm sure that this discussion is on. So how about vaccination? Well, I believe that it would start with vulnerable groups, but in general, the vaccination of migrants.
Up to date, we don't have information about the vaccination of migrants. I think that this is included in a bigger program because in Italy in this moment we have like different categories of people that are receiving the vaccine based on the priority and on the specific health condition. In this moment, we registered that in any case, all the migrants arriving, the percentage of people with COVID is not too high. And in all the cases, they do not have any symptoms. So I think that this is a first important point in to imagine a priority to provide vaccine in this moment. So I think, but it's a decision of the upper level. So I really don't know in this moment, but for sure in this moment what we are providing is the period of observation to understand if per person arrived are positive or not through the quarantine. But I don't have any information in this moment about the vaccine of the migrant people.
Okay, just another thing, and if you could say something about the quarantine and separated families, because how it happens. I think that this
of course
what you mentioned that you deal with this. So separation, well, in the time of quarantine, one is positive, another is not.
Of course. We adopted, we can say, guidelines specifically on the period of quarantine to maintain the family unity. In particular, for those arrive on the quarantine boat, but in general for the quarantine, because sometimes it's possible to do the quarantine also on the land, so not only on the boat. And not only for migrants, because this is really important to underline. The Italian Red Cross provide to all the Italian Red Cross volunteers specific guidelines to maintain the family unity in the context not only of migration, but in general for those, for example, are in the hospital, or for those are not able to maintain the contact with family members that are isolated due to the COVID. But in particular, to go back to your question, in the quarantine boat, we collect all the information from migrants, inform them to the possibility to approach the Italian Red Cross to restore or maintain the contact with all the people that traveled with them during the journey. Of course, it depends on the circumstance of separation, because we have different tools. But for example, the simplest example I can provide is, for example, as you mentioned, if family members are arrived in different boats, so we have special staff dedicated for the restoring family links in each boat. So they speak each other, and it's possible for us, for example, to locate one family member in a place, one family member in the other boat, and at the end of the quarantine, we are able to restore the contact and to facilitate, for example, the reunification. But sometimes also during the permanence on the boat, we try to collect information to understand if among the people on the boat there are family members that during the first registration they do not inform us of the family of the familiarity, and then they also understanding that Italian Red Cross is there for them, so to support their family unity, we day by day we are able to collect, to understand if there are some family ties to restore or to facilitate in the reunification.
Any other questions? I'm sure that there are some questions. Maybe I'm not waiting enough for those questions. Because I have another one. I have my question is, how it is decided who has a quarantine on the boat and who has a quarantine on land? So how is decided? Who decides this? And what's the percentage?
In this moment, we can say that there are some specific condition of health that does
vulnerable groups should be.
We can say that in the big framework of vulnerability linked with migration, because of course each of those persons are vulnerable, because the journey is an experience that of course expose the people to a vulnerable condition. But among of them, there are some specific categories that do the quarantine on the land. For example, the pregnant woman, or the unaccompanied foreign minors, or all those people who have specific vulnerabilities that suggest the permanence in a different situation, like for example to stay on the land. But in any case, is an official document that the Italian Red Cross and the ministry, the government decide. So it's not there is not discretionality in this. There are specific rules for those with particular needs and particular health condition.
Excellent. So any other questions? I think that this is very interesting, and I think that, you know, in the morning maybe they are all very shy. because in the afternoon, you know, it always comes a little bit more lively. There are too many questions, but in the morning, so nobody has a question. So only me. I'm sorry, because, you know, just like I'm monopolizing this platform and I shouldn't really be doing this. So who has some questions? Well, so I would just explore, I would love to explore this more, but obviously I cannot, I'm still waiting. It may be maybe somebody will come forward. No? Right, so this is exactly exploring vulnerability during the quarantine time is really interesting, because here we can see that it's sort of ad hoc situation, because, well, we could not be really prepared. Maybe 1 year later now, we are a little bit more prepared now than we have been, but we were not prepared to this pandemic. So I think that this vulnerability and the issues should appear even more sort of acute in this situation, because well, probably vulnerable groups did not get at the start what they should be they should be getting. Anyway, Dr. Belasai.
Yeah, it's right, correct.
So thank you very much. It was very interesting. It was a little bit, this is what we said, it's really interdisciplinary. We really want to have the practical views, the problems that maybe we simply do not realize in our academic life. And now, and then stay with us if you can, join us later on if you can, and please do stay in contact and collaborate with us.
Of course. Thank you again, and good luck for the next interviews.
Thank you very much, and our next speaker is Professor Martin Jones. He is from the Center of Applied Human Rights. He is a very active activist, if I can say, and human rights defender, and he will talk about vulnerability within refugee recognition. Hello? Ah, yes. No, I was afraid that something got wrong. So vulnerability within refugee recognition regime outside of the EU, the case study of UN High Commissioner for Refugees. As we said, this, although it's in the framework of Jean Monnet, but we know very well that we really don't limit our research or our discussion to the EU. Rather, we place it we place it in context. And
perché ora lo faccio online dal 12 aprile con Marziale, l'avevo vinto.
Antonina,
ho la borsa prima che me la...
Antonina, we can't, I cannot go with the presentation, right? So so the issue is that this is a very important subject, and I think that we also really, maybe we don't put enough emphasis on refugees, because we always consider that they are finally among the migrants, the most privileged group. So, Professor Martin Jones, have I introduced you enough?
Yeah, I think that's plenty, Katarzyna. Thank you very much.
Thank you very much for being with us, and I know that you are very busy, so we are delighted.
No, it's a pleasure to be here and to see all these, to meet some new colleagues. So it's wonderful. I mean, I guess I should say at the outset, I'm going to be talking, as Katarzyna says, looking at how UNHCR, both from a policy point of view as well as operationally, deals with or confronts the issue of vulnerability, obviously dealing with the population of concern that it deals predominantly with, which is refugees. And so it's kind of a case study of UNHCR, necessarily, other than its policy interventions, obviously outside of the European Union. So I'm going to give you a little bit of background on myself, I suppose, and where I'm coming from in making this intervention, and then provide a little bit of history about UNHCR's policymaking on vulnerability, look a little bit at its operational practice with respect to what I call its role in the refugee recognition regime, and I'll unpack exactly what I mean by refugee recognition regime later. And then close with a few comments. As Katarzyna said, I've been working with some civil society organizations, predominantly legal aid organizations, to adjust their practices to respond to the pandemic, both in terms of their own services, but also to better support the populations that they serve, the asylum seekers and refugees, predominantly in the global south that they're dealing with. So I'll close with a few words, just reflecting upon the topic of vulnerability in light of the current situation. I suppose the first thing to say is that my work generally, I'm a lawyer by background. I did some, I came to academia after a history of practice in the Canadian refugee status determination system. And so I have some experience of how that system began to understand and respond to particular vulnerability within a national asylum system, particularly how it began to deal with gender-related issues and claims in the early to mid-90s. But more of my academic work, and certainly my recent practical work, has been working with, as I said earlier, legal aid organizations in the global south, mainly in the MENA region, so Middle East and North Africa, but also in South Asia and Southeast Asia. And so I come to this talk kind of engaged in jurisdictions which aren't known for, I mean, not putting Canada aside for a moment, aren't known for having national asylum systems, where UNHCR is basically a surrogate state and providing for refugees, including performing in most of these cases the key role of refugee status determination. And so one of the things I want to look at is how UNHCR responds to assessing vulnerability within that process. I suppose for those of you working within the European Union context, I guess I have to defend my choice of case study a bit. And it's just to say that UNHCR is obviously a significant actor. It performs roughly 10% down a bit now, but I think it's 5% in the most recent numbers, but like on average, historically, anywhere from kind of about 8 to 12% of that receives that number of new asylum applications every year as a global percentage of the new asylum applications. And plus or minus, it makes that a similar range of the decisions and outcomes. It has an operational mandate to perform refugee status determination in a shrinking number of states, but it's still now performing RSD in about 60 states, a little bit more than that. And obviously beyond that, it plays an active role in influencing, or trying to influence, I guess I should say, both national and regional policy development. And so every time the European Union, various institutions within it come up with new proposals, the UNHCR is intervening, as well as obviously taking a fairly active role in some of the recent jurisprudence coming out of the European Union judicial institutions. It has recognized that in the context that I'm talking about, it struggles with vulnerability and with, I mean, as it says, more kind of euphemistically, ensuring comprehensive refugee protection and robust and long-lasting solutions for refugees. Yeah, so it recognizes that in the places that I'm talking about, there is no perfect, and it's trying to make it better or at least good, rather than the best. I guess the opening thing to say about the policy context is, well, I suppose it's background on this idea of vulnerable asylum seeker, vulnerable refugee. The first, I guess, is to say that similar to migrant, perhaps, there is a certain concept of vulnerability embedded within the category, right? So refugees are singled out both because for the same grounds as migrants, they are not nationals of the state that they're in, and so therefore seen as needing particular attention because the legal frameworks and practices and policies may otherwise exclude them, for example. But also in the case of refugee, there's a particular vulnerability, obviously, that arises specifically out of their risk of refoulement, out of the risk of persecution that gave rise to their flight, or at least that maintains their exile. The second thing, I guess, is to say it's a relative term when we're talking about vulnerability. And I think Federica made this point as well. We're talking about individuals as a population, and a group of people who as a population, as I said a moment ago, are identified as being at risk or suffering from particular obstacles to their enjoyment of their rights. And so when we're talking about vulnerability within this population, we're talking about a relatively higher level of risk or vulnerability. And then I guess the final thing is that and I think some of the later presentations probably will better deal with this, but I guess just to acknowledge that, as I said at the start, I come to this from work on other topics, not directly working on vulnerability, but that I struggle with the kind of conceptual distinction between labeling people as vulnerable individuals and rather approaching it as individuals in a situation that makes them vulnerable. I think for all sorts of broader kind of ideological reasons, the latter is probably the preferable way of approaching this topic. And yet my sense is from the policy review I'm about to go over with you, let alone the operational approaches, that is often the former approach that we're implementing. And so I guess recognizing at the outset that both I find some of the language a bit difficult, as well as some of the concepts a bit loaded. I guess the first thing to say is that there's no policy on vulnerability per se, although if we look at UNHCR's primary policy mechanism, it's conclusions on international protection, which are produced on an annual basis by its executive committee and have been produced probably for the last close to 50 years of its existence. So there's no individual executive committee conclusion that addresses comprehensively vulnerability. But it is used, it is a frequent term. It's used in 32 times in probably about half as many executive committee conclusions. So it is one of the drivers of its interventions in international policymaking. When we look at within the usage of vulnerability, what types of people, what categories of individuals are categorized as vulnerable, there's probably not a huge surprise, and this probably maps relatively closely to some of the, well, certainly you'll see a repetition between the lists I'm about to give and the European Union's, for example, definition. But women, children, and more recently youth, so kind of a broader category, including young adults. The elderly, shockingly recently, I mean, it technically dates back to the 80s, but only in very passing references, only really seriously paid attention to much more recently, although probably not that surprising in line with international human rights law, very belated kind of attention to the elderly. In particular, for a long time, and probably the most mentioned group is victims of either sexual abuse and exploitation or trauma and torture. So broadly speaking, the category of victims of torture, sometimes lumped in with women and girls at risk, but more recently separated out. At various points in time, other categories have been identified, and tying back to Federica's presentation, I mean, stowaways, individuals in maritime rescue situations have been recognized as being particularly vulnerable. And similarly, those who have been intercepted at sea, I mean, it's a similar kind of situation, have also been recognized as vulnerable. While most of these categories are in the policy documents framed in fairly static terms, I mean, there are a couple of mentions of note which recognize the dynamism within the categories. So recognize that, for example, vulnerability can be created, for example, through poor reception arrangements. And this is in a context where UNHCR is itself managing many of the reception arrangements, but also over time through protracted refugee situations, particularly in camp-based situations. And both of those recognitions of the kind of the dynamism of the category are more recent. Interestingly, at least in the high-level policy documents, there's no mention of vulnerability linked to sexual orientation and gender identity, which I think says something about the international politics of the executive committee, which is a state body. Although in much of the operational guidance, particularly the recent operational guidance, including in regions where sexual orientation is still controversial as a issue. For example, in the vulnerability assessment framework in Jordan, they specifically single out SOGI issues, broadly speaking, as producing vulnerability. Once vulnerability is identified by the policy guidance, I mean, there is a question about what to do about it. And I guess there's 4 different ways that the documents suggest that are the responses, either four different domains. One is in relation to reception arrangements, recognizing that there's a linkage between vulnerability and potential sexual and gender-based violence within the reception arrangements, produced by bad reception arrangements. Secondly is in registration, or what they call documentation. The third is in refugee status determination, and the fourth is in resettlement. And so that will be what I would talk about for the rest of my presentation. I mean, and I guess together those 3, the documentation, refugee status determination, and resettlement, are what I call the refugee recognition regime, borrowing the term from Catherine Costello. These are the 3 domains where UNHCR, in a sense, labels or allows access to the label of refugee and brings people and communities within its protective mandate. And I think more traditionally we'd focus just on refugee status determination, but the broader idea of refugee recognition acknowledges that actually it's not just through formal individualized status determination anymore that UNHCR is designating individuals and communities as peoples of concern, but it's through this broader range of labeling activities that give access to various types of protection. I guess, whereas it's easier, although I gave a bit of a whistle-stop tour through it, it's easier to identify what international policy is when it comes to its operational practices in those 3 domains. In the refugee recognition regime aspect of UNHCR, it's much harder, largely because those operations are developed at a much more local level. So there's not even really regional approaches with respect to each of these. The standard operating procedures are usually developed at, if not a country, even a sub-country local field office level. So it's much harder to try and make general comments about how vulnerability is approached, other than to say that the guidance that UNHCR does produce for its global refugee recognition activities does say that the procedures should be in place to identify and assist vulnerable asylum seekers. Yeah. So it acknowledges that, even as it leaves to the particular field offices flexibility in figuring out exactly what that would look like. The operational guidance also does acknowledge that the ways in which vulnerability is identified or not identified and is accommodated, mitigated, can result in, have other consequences for the legitimacy or the integrity of the refugee recognition regime. So there's a recognition that this is important not just for the individuals, but actually for the system that UNHCR is developing. In terms of the policy guidance about how the standard operating procedures should occur, it's basically there's a few specific ways of responding to vulnerability that are identified. The first is in trying to create processes to identify vulnerability. I'll come back to this particularly in relation to COVID, because that's messed up, I think, quite a lot of the normal processes for identifying vulnerability within the intake processes. The second is the special training of staff to identify and to better accommodate the particular needs and situations and signpost to services of particular vulnerable groups. And the third is the provision of additional services to vulnerable groups that may in some way be able to mitigate their vulnerability. And the archetype of this is counseling to survivors of trauma, or shelter and some form of sheltered accommodation to unaccompanied minors, trying to somehow address to the extent that UNHCR is operationally able to, the core, one of the core dimensions of the vulnerability or impacts of the vulnerability. Within UNHCR's refugee recognition regime, there is a role for civil society in addressing and advocating for vulnerable individuals. And this largely comes down to assisting UNHCR in the identification of vulnerable individuals. So in most standard operating procedures, there are mechanisms whereby civil society organizations, service providers can inform UNHCR of having identified a particularly vulnerable individual or family. And then that will then produce the various kinds of priority processing or access to resettlement or whatever the local particular remedy suggests for that particular vulnerability. Having said that, obviously, civil society often suffers from the same cultural and structural biases that that UNHCR suffers from. So it doesn't necessarily help do the identification and referral process very much, as much as it probably should. And the classic, the recently kind of pointed out example of this is in relation to sexual minorities. I mean, individuals with you know, individuals who have risks and often claims related to their sexual orientation or gender identity. And recent work by organizations like ORAM has suggested that part of the problem in relying upon civil society to advocate for these individuals and identify these individuals is that civil society has the same kinds of, for example, homophobia, the same kinds of biases within a particular operational context that both UNHCR as well as the host community might. And so simply creating mechanisms for civil society to help UNHCR identify individuals who are in vulnerable situations won't necessarily do anything to meaningfully address the problem. I'll say a few words about resettlement before closing on saying a few closing comments about the impact of COVID. I guess resettlement is that third element of this refugee recognition regime. It is where not only UNHCR typically, but also a third country, a resettlement country, a European country, America, Canada, Australia, New Zealand, and a range of other countries also recognize somebody as a refugee and move that person from a country of first asylum or asylum at least, typically in the global south, to somewhere else. Again, typically in the global north. It is a durable solution in UNHCR's language. It is the least practiced durable solution, with less than 1% of refugees having access to it, and in practice actually a lot less than 1% of refugees having access to it. It obviously, as a durable solution and as the least practiced one, only occurs after there is no prospect of voluntary repatriation or local integration. It typically happens in places where even where refugee status brings irregularity, you know. And the interesting thing when we talk about vulnerability to look at resettlement and how that works is that it's almost all vulnerability linked. So all of the categories that we'll see in a moment, the generic categories, but also the country-specific categories are linked to vulnerability. There's 5 big categories, and I'll just go through them quickly. The first is legal and physical protection needs. These are individuals at heightened risk of arrest or deportation. These are sometimes individuals who have already been arrested or have had a history of arrest, individuals who in a sense are facing problems either within the country of asylum or they risk being expelled from the country of asylum. Survivors of violence and torture, obviously, and individuals with medical needs that cannot be met in the country of asylum. And then women at risk, so who have protection problems particular to gender and lack effective protection, normally provided by male family members, to use UNHCR's formal definition. And then finally, individuals who are vulnerable and who require family reunification. And this, I think, ties in a bit with what Federico was saying about the IRC's role in some of its operations. Here, the vulnerability arises out of the dependency relationship, which often involves children, but can also involve older members of the family as well. And UNHCR interestingly flags this as its area of resettlement where there's the most common, most commonly worries about fraud. I think the worry with UNHCR is that there's not necessarily in many cases definitive documentation about who's a member of a family, and so it is open to abuse by individuals seeking resettlement to reunite with fictitious family members. Ironically, I think in practice, actually, some of the fraud problems come about because of some of the restrictions on access even to registration within the refugee recognition regime, which then produce stories at that end of the refugee recognition regime that then catch up with people by the time they get to the resettlement. But I can say more about that in the questions. Children, adolescents, and elderly are not per se recognized, but obviously they can be considered under other categories, most obviously under the family reunification category. And as I said earlier, I mean, in a sense, vulnerability is a requirement for all 5 categories because all of these individuals must somehow be unable to locally integrate. So there must be some sort of legal, social, cultural, linguistic, economic vulnerability. You know. So finally, I guess, as Katarzyna said at the start, and as I mentioned, I've been doing some work with legal aid organizations trying to think about what the pandemic has done to their operations and the communities that they serve. The first thing I suppose to observe is it's not an egalitarian pandemic, and perhaps there's no such thing as an egalitarian pandemic, but I think all of us can very immediately understand that the pandemic has exacerbated inequality. And I mean that far beyond the migration field, I mean across society more generally. Yeah. The second thing is obviously that non-nationals have been particularly deeply affected. The closure of borders, preventing mobility, reunion, but also from their exclusion from national responses. I mean, many national response frameworks take no account of non-nationals. And even if they do, they face cultural, geographic, linguistic barriers to access. Beyond that, obviously, in many contexts, migrants and refugees and asylum seekers are now seen as increasingly in some of the popular discourse as vectors of disease. I mean, this has long been a discourse. This is not new, but as populations have been locked down, these individuals who are seen as less controllable or having been less controlled are seen as bringing with them risk. And so many countries during the pandemic, they have been targeted, making things worse. I mean, from a pandemic point of view, in a kind of an anti-public health way, but that's just the reality. In the refugee recognition context, I mean, the pandemic has also altered the way that refugees access protection through UNHCR and created new barriers to identifying vulnerability. So physical interviews, for example, have disappeared. UNHCR has closed many of its operations. There's no in-person interviews. Much more is done by paper, by telephone, and occasionally now they've started up some video processes. But all of these prevent many of the ways in which vulnerability is identified from happening. One of the ways that UNHCR in its guidance suggests that, for example, women at risk be identified is through signs of domestic violence. I mean, which probably is not the best way of identifying victims of domestic violence generally, but to take that just one example, that is no longer even possible with offices being closed and no in-person interviews and video interviews not being used, let alone the fact that men control telephone access and because of that will be present during any time that a female refugee claimant is using the telephone to talk to UNHCR. So, I mean, all of these types of changes in how UNHCR is practicing its and delivering its services are affecting how vulnerability is screened. Yeah. It has also obviously exacerbated existing vulnerabilities. So this goes back to the point about vulnerability being dynamic. As I said kind of earlier, some of the ways in which UNHCR probably fairly ineffectively identifies women at risk have been disrupted. But beyond that, there has been heightened risk of women and girls generally. There's been kind of an epidemic along with the pandemic of domestic violence that's been reported. So so there's increased vulnerability there. The elderly, because of the pandemic, are more at risk. The learning disabled, I mean, as we're going through this pandemic, we're realizing purely from a medical point of view that there are new segments of the population that may be at risk, who may have already been at risk in different kinds of ways, but who are at increased risk because of the pandemic. And it's also created new vulnerabilities. Suddenly, individuals who are employed in particular occupations, service delivery occupations, are more at risk, for example, of the pandemic. There are particular sectors that have been closed down, where if a refugee or asylum seeker is employed in that sector, suddenly they will be without a job, typically without access to any of the furlough schemes or whatnot that happen, and because of that, thrown into poverty. So I don't have any answer here. It's just a comment that I think one of the troubling aspects of the moment is the way in which the pandemic has disrupted our ability to respond to vulnerability, and has also created new vulnerabilities which we have yet to catch up with. Yeah, and thank you for your patience. That's it. Thanks.
Thank you ever so much, Professor Jones. Thank you so much for this very insightful talk. I just would like you to ask the question, because obviously I have many, but I will just wait. And yes, Giuseppe Romero, one small second. How you have to, your microphone is down, so you have to, yes. Yes, please, with the great...
I just want, excuse me, I just wanted to applaud to Professor Jones. It just was an applause, not a...
right.
I was not raising my hand.
Oh, sorry, I thought it was a hand. I thought it was a hand.
No, it was just my clap.
Okay, so it's my mistake, because I don't recognize the sound of this new way of intervening. Okay, thank you very much. Anybody wants to ask the question? Carola, Professor Ricci, absolutely, Professor Ricci.
Sorry, first of all, thanks both to Katarzyna for organizing the event. It's very interesting for me. And both to Federica and Martin, thanks, especially for your intervention and mostly for what you do, I mean, every day. So, and second, maybe the question, it's not probably a question, it's a curiosity, because I totally agree with Professor Jones when he's saying that we should need a more robust, long-lasting solution for refugees. And to this extent, knowing also your experience in the Canadian environment, knowing kind of well let's say the experience of the private sponsorship model that actually worked kind of well in the Canadian, that's in Canada, maybe in the 60s, now still continuing. But I don't know if you know that in Italy, 5 years ago, they started applying this model to a new project that it's an hybrid project. It's an hybrid convention agreement, I would say, having from one side the NGOs you were referring to, but they're mostly religious NGOs. So about the bias you were referring, there are some. But at least they were the one, and they are the one who are sponsoring the coming of legally income of families and I would say vulnerable people. But the definition of vulnerability actually is found not in international law. So the reference is not general to international law or UNCHR guidelines, but they do define themselves in order also to apply the same practice and knowledge they are developed in camps, mostly I would say in Lebanon and Eritrea. And now the numbers after a few years they are kind of high. I mean, considering that it's just one initiative, there are 3,000 people who reached Italy till last year. With COVID, everything changed, as you were saying. But the point is that they had difficulties in applying existing law to help these people, because they were coming from Lebanon, the first 2000, and they foreseen as a legal basis to come in an LTV visa, so a temporary visa with a territorial limitation. Contrary to what happened for the Canadian, they didn't have this definition. So they could enter the Italian, and only Italy actually, the Italian territory. And once there, they had been helped by legal practitioners and other associations, not only the religious one, those who actually joined the project, asking for protection. And then there's the bias, because sometimes the two categories doesn't coincide. And the point is also that after the case law delivered by the European Court of the European Court of Justice in X versus X and X versus Belgium, where actually they said that states they are not obliged to let people come in through LTV visa, because actually the only vulnerable people covered there are those who are going to stay for 90 days or at least in a period of 180 days, meaning that the long-lasting protection is not foreseen. And so my question is also looking at the future and what they are developing at the EU level, but also asking to practitioners and those who really know the situation. Do you think that such a model, so the private sponsorship, could be functioning also at the European level? I do believe that's a very good one, at least one of the possible legal entry for vulnerable people in general. Not limiting it to those that are covered by the Geneva Convention, but not only those, also those covered by the directive that never was applied in the past for big fluxes in case of emergency. That I know, as far as I know, they are rephrasing, but still now there's no legal framework for this, unless the states do ask for the application of humanitarian law and discretionary power in order to determine whether they want to help or not. This is something that still now is possible, so the states are called upon it to declare that they want to help, and they cannot be sheltered by EU law, not even by EU charter, because the charter cannot be applied if EU law doesn't exist. But still we have the European Convention of Human Rights imposing states to do that. In my vision, people that are asking help to a diplomatic, for example, premise in Lebanon or wherever, actually are subject of the jurisdiction of a state, and such state has to apply the standards of protection provided for example, by European Convention of Human Rights, namely Protocol 4, imposing the non-refoulement. So I'm very, very happy if you could give me your ideas, also to Federica if she has time, but I don't want to, again, I wanted to ask before, but since I wanted the students to raise hands, so I don't know, maybe Katarzyna, you can still open the questions to the students and then leave this as a last response. I don't know.
Well, just yes. So let's wait. Let's wait if somebody. You're absolutely right, because we also. It's very important that exactly our students are here and they follow the debate, because it's a very important not only problem, but it's an important element of any course on migration. So, do I have any students? They are too shy. It's probably too early, but let's wait. So, will I have somebody who is less shy? Let's wait. Maybe do I see them all? If you see, yes, no. No, I thought that I have seen somebody, but no. Here, no hands. So Martin, go ahead, and then I have some, but I don't want really to monopolize this. You know, the platform. There is only me asking questions. So I just address Professor Ricci's comments, and I will have some questions, unless students will have some. So I will give my, my question, my time to them. Okay.
No, Carola, I mean, wonderful question. And the short answer is I don't know. So, I mean, I think kind of if these are these conversations where if any of us had kind of a complete answer, the world would be a much better place. But inevitably things don't have quite a simple or succinct answer. And I guess I can share with you my experience and reflections on, for example, the Canadian resettlement process, and you can maybe take whatever of that is useful and apply it to the EU context, about which I'm a lot less aware than you are. Canada does like to and has been very actively in recent years, probably the last 10 years or so, has been promoting its private sponsorship model. And as a Canadian, putting aside my practice as a refugee lawyer there, it is a big part of the national identity since the Indo-Chinese crisis, and I think it is actually genuinely something that works. I mean, the story. I don't want to use up Katarzyna's time or the students' time, but the story I always say is that my parents live in a very remote part of Canada, on a small island, which is predominantly white and has been settled by, I mean, for want of a better term, ex-hippies since the 60s. So a progressive community, but a fairly insular one, and a very old one. I mean, the average age on the island, I mean, is, yeah. Let's just say they're getting the vaccine right now, thankfully. So, they sponsored, during the Syrian crisis, they sponsored a family of refugees. I mean, out of the blue, just they thought it was a good thing to do. They got involved, and I mean, God help the Syrian family that landed on this white Christian island, with filled with grandparents, as opposed to other children. But it is that kind of grassroots engagement with refugee production, which I think has been a key part of its success. It is even in Canada, though, to this day, predominantly. I mean, there's a couple of elements to the private sponsorship program. There's the so-called groups of five, which is the way my parents' island organized. It's kind of a spontaneous group of 5 permanent residents or citizens that can sponsor a refugee family as long as they indicate that they have an integration plan. The large, well, probably the bigger part, it's a little bit more than half usually, is a so-called sponsorship agreement holders, who are the more professional organizations that bring in on a regular basis a quota. Everyone's given a quota under their particular sponsorship agreement. Those are predominantly religious-based organizations, even if some of them aren't overtly religious-based, but they've come out of particular communities, religious faith communities. So even if their current incarnation doesn't look like it's religious, everybody within it is an Anglican or a Mennonite or whatever the particular faith history of that group has been. So there is a big part of that. I mean, and that obviously has a lot to do with the linkage between the ideas of sanctuary and faith, across the big faiths of the world. I don't think it's a particularly Christian aspect, although in Canada that's the way it plays out and has the same kind of biases. There are still access problems. So Canada changed its rules so that UNHCR, refugees who resettle now have to have recognition as such by UNHCR, which means that if you're from a place where UNHCR doesn't or isn't allowed to recognize refugees, or has a quota placed upon, or an ethnic distinction put upon it by the host country, that those individuals actually, there's ways around that rule, but those individuals struggle to get sponsored. So and the reason they did that is exactly, it ties in, and the reason I mention that is because it ties into what you said about the idea of kind of asylum on diplomatic premises. The immigration officials in Ottawa were worried that if they get they recognize that if they got UNHCR to recognize individuals, they had some control, because they have quite a bit of control on UNHCR. Whereas if they allow anybody to file an application with the local embassy, they have much less control. So it was a very deliberate policy change. I mean, it resulted from some litigation I was involved in kind of a backlash kind of effect to the litigation that we won. Yeah, there's aspects of the program that are less open and welcoming and more controlling than you'd think from afar. I guess the only final thing to say is that Canada doesn't have all refugees who are resettled who arrive in Canada upon their arrival become permanent residents. So there's none of this kind of in between short-term visa categories generally. Obviously, asylum seekers who spontaneously arrive and go through the asylum system are in this short-term category, but otherwise they then transition to permanent residence, which in Canada effectively means that you're both temporally as well as practically, for most respects, equivalent to becoming a citizen. Canada is considering introducing basically, I think, what in the European context you call a humanitarian visa. I mean, so it'll be interesting to see how they then struggle and try and draw lessons from the EU about exactly what the problem is that you're saying about the mismatch between the criteria for the shorter term category and the criteria for the longer term category, and worries about people switching and wanting to encourage or discourage switching between the categories. And so one of the things that Canada right now is reviewing as part of another policy that has to do with human rights offenders is the introduction of a humanitarian visa. So they're about to confront the part of the problem that the EU is trying to get over shortly. Yeah. And I think that was everything I have to add, other than to say, yeah, I don't have a simple answer to how the EU can launch a resettlement program, other than to say, obviously, the numbers of refugees resettled to the EU have dramatically increased over the last decade and a half, and that's been a very impressive response. I'm not sure UNHCR has quite met its 20,000 by 2020 target, which was its kind of advocacy campaign for a number of years, but it must be close. I mean, 2020 obviously is a bad year to nail your flag to in retrospect, but the numbers across the board were down last year. So, but yeah, no, that's been an improvement, and perhaps with some sort of private sponsorship model, there'll be more room for a bigger increase in the numbers.
Thank you very much, Professor Jones. Well, I will ask the questions, but because we are 10 minutes late, so maybe the answer we will just consider later after Professor Nath talk, because if we don't manage, we don't manage, but we need to carry on. So my questions are, so I think that that international perspective is extremely relevant for the EU. I think that we cannot talk about EU ideas without international law. So every time you tell me, well, this is not the EU, it doesn't matter, because we really needed to see it in context. Then definition, I thought that what's very important about the definition, it's not what is in it in the EU definition, but what is not. So this is you underlined in your talk. You talk about a new vulnerability, unemployment, poverty, and so on. So this is a very interesting issue as well. And the last issue, I just would like to know how during the COVID time you do the interviews and all this stuff related to refugee status determination. So is it, well, shall we say that it's obviously slower, but is it not impacting on asylum seekers and on their situation? But okay, this is what I don't want to answer now, because we need to go ahead with Professor Na, who is also a member of Center of Applied Human Rights defender, and she had collected millions of grants. I really don't know how she's doing, so she's very, very successful in the new areas related to her projects, her teams, and so on. So she is going to talk about protection of vulnerable groups in migration through alternatives to detention advocacy. Another very interesting topic. So the floor is yours, Professor Na.
Thank you very much, Dr. Katarzyna. So it's a pleasure to be here with you today. I'm going to share my screen because I've got some slides to go through with you. So I hope you see them fine. And I just want to say that actually James Lewis, who I wrote this paper with, is actually on the call as well. So James, I also welcome your thoughts as we, sort of respond to any of the questions. So this research came out of a question posed by the International Detention Coalition, which is an international network of organizations that have been advocating to limit and to end immigration detention globally. And actually the IDC has been at the forefront of advocating for alternatives to detention. And over the past 10 years, they've seen evolutions and patterns that have become worrying. Although they are one of the main proponents of alternatives to detention, they also realize that they realize some of the issues around the use of this advocacy and the unintended effects that it has been created. So they got James and I to work on this piece for them to really look at what it means, what are the issues with alternatives, and what are the arguments for alternatives, as well as some of the criticisms. Yeah. So this is what I'll cover in the conversation today. Really have a look at what the definition of alternatives to detention mean. And some of the issues around, the way it's conceptualized, some of the arguments for, as well as criticisms of alternatives to detention. So I think that the first thing is that there isn't one particular established legal term that's used. The IDC, this is one that its members uses, which is any legislation, policy, or practice, whether formal or informal, aimed at preventing the unnecessary detention of people for reasons relating to their migration status. So captured here globally would include migrants as well as refugees in contexts where refugees and asylum seekers are detained. In a lot of places they're not, but for some people, especially as their asylum claims are being determined, some of them are held in detention. The European Alternatives to Detention Network draws upon the IDC's definition and simplifies it to this definition. Yeah. The aim of the IDC was, as I mentioned, really to reduce the use of immigration detention. So in its early days, when it put this definition forward, its aim was really to look at non-custodial approaches. Yeah. Since then, the European Commission has also come up with a definition. So it uses a narrower, more specific definition. So a non-custodial measure used to monitor and or limit the movement of third country nationals in advance of forced return or deciding on the individual's right to remain in the member state. Yeah? And it gives some examples such as reporting, the surrender of financial guarantees or travel documents or electronic monitoring. I'll come to this definition again later because you'll see, as I mentioned, that there's a diversity of practices considered alternatives to detention, some more progressive than others. In the US, the Immigration Department there defines alternatives as mechanisms to ensure compliance and move immigrants through the immigration court proceeding without detaining them inside detention centers. So you'll see the first two definitions I gave in the earlier slide were a civil society perspective. In a sense, more progressive, more about liberty. Whereas the European Commission and the US Department Immigration and Customs Enforcement definitions focus still on monitoring people and limiting their movement. Yeah. So what you see when you look at alternatives to detention, actually you're referring to a diversity of practices, some of which are more enforcement oriented, so that impose specific restrictions, particularly on the liberty and movement on people, such as frequent reporting. So, you have to come and report yourself every week, let's say, to the police or, to a designated office, or, in some circumstances, even the use of electronic tagging, right? Others, and this is more the civil society's option, focus more on engagement and case management. So they advocate alternatives to detention that focus on, close working with the migrant and refugee, on looking at their cases, interacting with them, helping them to understand what's happening with their cases, and placing people in community accommodation instead of custodial, or detention facilities. Yeah. So these are just some examples that have been listed by the Steering Committee for Human Rights. Some alternatives to detention could be registration with the authorities, temporary residence, case management, some with case management support, caseworker support, alternative family-based accommodation, residential accommodation, shelters, yeah, open reporting, designated residences, having a bail bond or a guarantor, or electronic monitoring as well. So I think one of the major arguments, that civil society actors, but state actors have also put forward that, in favor of alternatives to detention, first of all, is the cost savings. Yeah. And this is actually a really persuasive argument, because there is, obviously detention is very, very expensive. And several studies, like the ones listed here, say that, in some cases, the savings, De Bruycker and colleagues, for example, say that in Australia, you save up to 86% of costs. The European Migration Network in Belgium estimates that the savings could be 53%. Alice Edwards, highlights savings of 93% in Canada, 76% in the United States, even up to 98% in Australia. And Ariatani, in her review of pilots in Europe, said that, the cost per day of ATD pilots were even as little as, 3 to 4 euros in Bulgaria, So the costs of alternatives can be quite significantly different, yeah. But it's not just the cost of running or managing individuals. There are also other costs associated with detaining individuals in detention facilities. So in the EU, escorted deportations can cost states, about 1,500 euros per person. Assisted voluntary departures can cost around 300 to 600 euros. There's also savings to be made in alternative ways. For example, when there's litigation for wrongful detention, the litigation and compensation can be quite expensive when states are found in error of detaining someone wrongfully. And Ward estimates that the lifetime health costs of long-term detention could be even up to 15,000 euros per person. But of course, what is of greatest concern to civil society organizations is the human cost of detention, right? And there's so many repeated studies that show that the negative impact of detention on an individual's person's physical or mental health are quite tremendous, with long-lasting effects, especially for children who are detained. No, so it's really trying to avoid the human cost of detention that civil society groups have been advocating for alternatives to detention, rather than necessarily the financial cost savings, which is what convinces states. So what civil society groups have been saying is that it's really more humane and effective. Sorry, someone's phone is ringing. So it's more humane and effective. So, Otani, in her assessment of alternatives to detention pilots in Bulgaria, Cyprus, and Egypt, found that actually most of them still were engaged with immigration procedures, because that's the other fear of states, that, if we release people into the communities, they will just abscond, they'll just run away. So how do we actually know that they will we'll be able to maintain contact with them and be able to work through case resolution with them? Yeah. So she found that actually most people remained engaged, 86%, 25% achieved case resolution, and only 12% absconded. And then 2% in the end were removed, yeah, because their cases were rejected. Cases for protection were rejected. But what she definitely found was that if you did case management effectively, the beneficiaries themselves would also contribute positively to the resolution of their cases. Yeah. But she emphasized quite strongly that you have to treat the beneficiaries with respect and dignity. If you don't do that, then you know the trust that's necessary for beneficiaries to really fully disclose their circumstances isn't there. And so the trust is a very crucial factor.
No, se noi lo dirà la fai. Ma non c'è una cura che si può fare al fegato.
I think somebody needs to mute, yeah, the mic.
Yes, this is exactly what I'm looking for.
Yeah, so she was saying actually in her review of case management approaches to alternatives, she was saying that it's really important to empower beneficiaries to stay active, to keep them informed, ensure they have access to competent legal assistance, but also often when they're dealing with the immigration situation, they have other practical problems they need to solve while they're waiting in the community. So actually the caseworkers also in the end have to end up helping them on issues such as, accommodation, healthcare, education. And as they accompany these beneficiaries on these issues, it helps to build their resilience as well. And she also noted that this case management approach can be adapted to other contexts and situations. Yeah. So it's actually a flexible method. It can be adapted to different situations. As I mentioned, one of the key concerns for states is the compliance rates with migrants. Yeah. So, actually several studies show that there is relatively high compliance rates between 84 to 99%. And other studies show it as well between 77 to 96%. Yeah. So yes, it's not a perfect 100%, but it's pretty high. There also have been criticisms to the use of alternatives to detention approaches. And the first thing is what I mentioned earlier, that there's no universal or consistent definition of alternatives to detention. So Bothworth, for example,
la bimba dovrebbe darti più stimolo
sorry, I think
in teoria, no?
Someone's mic is not muted. So there's no universal definition. So there's little consistency in the rationale or even the application or the design of alternatives to detention programs. And it actually can be counterproductive to the goal of ending immigration detention. So Michael Flynn, who's been quite critical of the use of alternatives to detention arguments and programs, has said, states have exploited the paradox of alternatives to detention by developing alternatives that fail to move policy and practice away from detention. So there's actually a concern that alternatives to detention could be alternative forms of detention. Yeah. So Ms. Mack, who looks at these practices in Indonesia, say, what you call alternatives actually serve containment purposes. Yeah. And in the US, a network there says it can be another route to restrict and surveil immigrants and further alienate immigrant communities. So really the concern is that alternatives can increase the detention estate rather than reduce it. And some critical, observers say, well, actually, you haven't actually reduced the number of people in detention. What you've done is actually increase surveillance of people and increase restrictions on migrants. You haven't actually reduced the total number of people in detention, if that was your original purpose of advocating for alternatives. So Bloomfield, observes that, alternatives alone can't be effective by themselves, but what you really need to look at is the rationalization and humanization of the migration system. And you must also have increased transparency of detention practices alongside advocating for alternatives. Yeah. I mentioned just now that some of the more enforcement-based approaches focus on restrictions. And these are some restrictions that the UK government, for example, imposes on those who are given immigration detention bail. Yeah. So even if you're granted bail, you are subject to one of these restrictions, either regular reporting or attending an appointment or hearing. There are restrictions on where you can live. Sometimes you may have an electronic tag placed on you. You could have restrictions on your work or your studies, or you have to obey whatever other condition and that is decided by the person granting your bail. So just some thoughts to offer.
Sì,
on-
diciamo che non lo sai,
on
non lo puoi
use of
sapere però
alternatives.
questo, cioè non sei uno
Eh,
psicologo infantile, quindi che decidi
Carissimi,
che è meglio che
mettete
muore
giù il
adesso per il
microfono.
bene di tua figlia, non lo puoi sapere.
Aspetta, Gina, se vai su participant in
Ah,
alto,
sì.
trovi mute all.
Ah, ma dopo come faccio?
No, dopo loro si possono riprendere la parola quando vogliono.
No, ma non trovo quello. Professor Ricci, sono tutti, ma forse adesso ha fatto, ah sì, disattiva audio.
Ecco.
Ok. Non lo so se l'ho fatto. Ok, Professor, no, I'm sorry for interrupting. I'm sorry.
No, not at all. So this is just my last slide, really. So I think just in summary, over the last 5 to 10 years, we have seen that there is definitely potential for alternatives to detention to reduce the harms associated with custodial detention. Yeah. But the reality is that they won't fix all the flaws in a migration system. So if you've got a very flawed system anyway, that unnecessarily detains people, then it's not going to fix that problem. What civil society groups have found is that advocacy on alternatives to detention have opened up spaces for dialogue with state authorities about immigration detention practices that didn't exist before. Because what often happens is that there's such opposing views on immigration detention that actually the space for dialogue and conversation isn't there. But advocacy on alternatives have opened up these spaces. Unfortunately, the merits and the demerits.
La prima dose di vaccino che mi ha fatto malissimo, in verità.
No,
Ancora mi sto riprendendo. Come sì, no,
Professoressa Caruso, dovrebbe chiudere l'audio.
muscolari, ossei, articolari, come quando c'hai la febbre a 40. Però in realtà la febbre non ha superato i 30, 38 forse durante la prima notte, poi non ci ho più avuta.
Zina, is there a way of muting all participants?
I don't know, I'm trying to do it, but apparently, can you hear me?
Il giorno dopo mi sono
I can hear you, but I don't think the person who's speaking can.
Come una drogata.
I need to...
Beh, non ero in grado di fare nulla adesso. Da sabato sto meglio, però insomma ancora più dolore.
Professoressa Fulvia Caruso?
Sì?
Scusi, deve silenziare il suo microfono.
Oh cazzo. Scusate.
Okay, it's done now. Should be done.
Okay. I just don't know how. I simply tried, but it didn't come. I tried and then okay, Alice, terribly sorry.
Okay, no. I just wanted to end with these last thoughts. Yeah. So really, when we assess alternatives to detention, we can't just jump on the bandwagon and say that it's definitely a good thing. It is something that can be a positive advocacy method, but only if it actually fulfills the human rights of migrants. And there are pros and there are cons for how we assess alternatives to detention, and we really need to focus on how it affects the rights of migrants. It's an obvious thing, to say when you say it, but then actually there have been, when we talk, I think one of the challenges is that there are many definitions of alternatives to detention. So sometimes you say something, but actually you're meaning something else, even as you use that term. I think the final 2 points really are that advocacy concerning alternatives to detention tend to focus on the concerns of states. So when civil society groups have said, look, it's cheaper, it's more cost effective, you won't have, you have pretty high compliance rates, people don't abscond as much as you think they were. Really, these are all concerns of states. And what there's a worry about is actually that states then say, well, if alternatives is very progressive and we know that it serves the human rights of migrants, then we will use it. But then that term gets co-opted by states and becomes used as a positive example of what they're doing for the human rights of migrants, when actually the impact on migrants is still negative. ostensibly it looks like they're doing something positive, but actually in reality they're doing something negative. So there's also the last point is just that there continues to be debate about whether civil society groups should campaign for the abolition of immigration detention, even as they advocate for alternatives to detention. I think if you speak to lots of civil society groups, they're very, very concerned about the use of immigration detention at all. And ATDs are just an interim way of saying, okay, hang on, let's really rethink these practices. You know, if you truly are very committed to immigration detention, can we look at least at alternatives, ways of, you know, not holding people within 4 walls? Are there alternatives to such practices? But some groups are saying, well, really, we should, even as we advocate for alternatives, we should always bear in mind that the abolition of immigration detention is what we are aiming for. But some groups say, well, if you start with that, you know, if you even raise that in the room, governments will just disengage. So should we even call for abolition or not? Yeah, so that remains an outstanding debate among civil society groups. So that's it from me. It's still a very early stage of analysis, so I welcome any thoughts or criticisms. And also, James, I welcome you to join in the conversation as well. Thank you for the work that you've been doing on this topic.
So first of all, I should say thank you very much for the very interesting topic, and it's that really you have wonderful ideas, because the project is really interesting and somehow addresses many issues. But first, let me see if we have any questions from the audience. Anybody from the audience?
I have a question.
Yes. Dottore, professore, I don't know.
Doctor, not
okay. Yes, absolutely.
Yes. This is not a real question. I just wanted to say how much I appreciated your speech, and that I fully agree with your position, because you said that we have to avoid center of detention, and by doing that we can ensure the cooperation of migrants for investigation and for proceedings against the traffickers, against the people who smuggled or trafficked those migrants. So I think that this is very, very important for the positive outcomes or possible trials against those trafficking, because even if a possible criticism may be that among those people there are also the traffickers, so by allowing them to stay outside, we can facilitate their escape or to run away. But on the other hand, treating them with a more human way, we can ensure the cooperation of migrants doing both at the investigative and at the trial level. Because if we can engage them during the investigative level, but we don't ensure their cooperation even at the moment of the trials, then we cannot use the evidence that we gathered at the investigative moment during the proceedings. So I really think that this can be a very effective mean of ensuring and engaging with the migrants and ensuring their cooperation, which is at this stage very, very, very important.
Yeah. No, that's a really good point, Dr. Giuseppe, because as the studies also show that the trust is so important, and when you're holding people in incarcerated effectively within 4 walls, the level of trust is very low. But if you do case management approaches where you're responding to the specific needs and the feedback of people who are, in communities, there's less pressure on them, and they're more willing and able to share, what they're going through and the struggles that they're having. So then, their participation in court proceedings hopefully will also strengthen. No? So yeah, thank you for your comments.
Thank you very much.
I just wanted to welcome also Professor, I don't know you, but James Lewis for participation and for joining us and for being with Alice. Let's see, maybe we have some other questions from the audience, because I have many, but I shouldn't monopolize this platform. So any questions? Academic students, Jean Monnet platform. I will explain what I mean by Jean Monnet platform later on, but so any questions? No questions? Oh, one second, maybe I don't see on all pages. No.
Good morning, I have a question.
Yes. Benedetta, yeah. Benedetta, yes. Absolutely, Benedetta is my student, a very bright student, so absolutely, Benedetta, the floor is yours.
So I have a question for each one of the three panelists that spoke so far. One for Professor Na, and I'd like to ask if you can clarify the point where you say that those practices can be co-opted by states, and also if by saying that you think that those alternatives to detention cannot be seen as durable solutions and practices to detention. So yeah, just if you can clarify the last point and the last thoughts of your presentation. And then I have another question for Professor Jones. And you have shown in your presentation that there are many categories that UNHCR has to describe the population of refugees. And I was thinking if the those categories that are considered vulnerable by the UNHCR do not risk to create some sort of hierarchy and further differentiate the group of refugees, for instance, those coming to Europe, and therefore also influence their access to services, facilities within the hosting society, and it somehow bias their integration process. And then I have one last question for Federica Bellassai. Who are the partners or institutions that the IRC could further improve its relationship with in order to facilitate the dialogue with migrants and better protect and assist them? Thank you very much.
Sure. Absolutely no problem. Yes, Federica, I was just worried if.
Yeah, I'm here.
Absolutely. So we go ahead with this question, absolutely, because we said we need to give the floor to our students. I'm very, very grateful. But if there are too many questions, maybe we can place them afterwards, because I believe that the other speakers would be delayed. Okay, but with this one, we are going.
So thank you so much, Benedetta, for your question. James, would you like to respond to her question?
Yes. So when we talk about the idea that alternatives to detention are being co-opted, this kind of really begins with the idea that because there is such a vague definition, or not a universally agreed definition of alternatives to detention, and then within that, when you have so many different policies which are classed as alternatives to detention, what the risk is there is that we may say, as advocates, we fully support these certain aspects of it. So, for example, a study by Amaral in 2013 interviewed 25 people who had experienced alternatives to detention in Europe. So, for example, those who were in Belgium, they were placed into community housing and had a designated case manager. So what we would argue that, yes, that is a good definition and good practice of alternatives to detention. Whereas those people who were placed in the United Kingdom they were placed on electronic tagging. So despite the fact that both of these are alternatives to detention, we as advocates are much more likely to be promoting the idea of access to community housing, access to case managers, and despite the fact that electronic tagging is technically an alternative to detention because you're not in detention, it is still an alternative form of detention because it limits your freedom of movement. So when we talk about, the idea of being co-opted, this is what we're talking about, how a state may promote itself as being more progressive in its detention management and policies, despite the fact it may actually be promoting alternative forms of detention. And another example, and I don't have a source for this, but having spoken to some people who kind of work on alternative detention, someone gave an example that I believe it was in Malaysia, whereby a state-funded detention centre they increased the services that they provide to children in detention, and they class this as an alternative detention. So despite the fact that it is promoting and actually continuing the detention of children, they phrased it as alternatives to detention. What was the second part of your question, sorry?
No, the second part was that in the last part of the presentation, Professor Na said that ATDs are a way to say that let's rethink the practices that are considered as alternative to detention. And so in this way, like, are they considered in the end as durable solutions, like those alternatives to detention that have high compliance rates and that are cost effective, like if they can be seen and intended as durable solutions?
Okay, yeah. I mean, personally, I believe that when the alternative detention that we see that have high compliance rates, the ones that are, as I think Alice mentioned, like human focused, ensuring that they have access to services, access to mental health services as well. These ones, and also being much more cost effective, these ones I believe are very, very durable. But then the risk obviously is if a state wanted to, they could, for example, a state could purposely delay the process of people who are in alternative detention, maybe to purposely increase the cost of these policies. Again, I haven't seen evidence of this happening, but if a state wanted to try and discredit alternative detention, that is a possible solution that they could go for. So I think, yes, to answer your question, I think they are very durable solutions. I mean, again, they're better for the actual person. You're gonna not have as many limitations on the person, and as well as being more cost effective. I think in the long run, if states were to go down the route of following these good practices, I think you would see very good solutions to this.
I think just one last comment to add to what James has said. When we talk about the durability of the solution, a lot of the alternatives to detention, they are in pilot phases run by NGOs, So the case management is actually done by NGOs, and I think really and funded by philanthropic organizations. So really to make them in their more durable form, they need to either be funded by states or run by states. And therein lies the issue, whether migrants themselves would trust state authorities in the same way as they trust NGO organizations or not. And I think that needs to be considered.
Thank you very much.
Yeah, it was a question. Well, if it's okay, if you remember your questions, that we could do a little bit later. Federica, is that okay?
Yeah.
Okay, Martin, because otherwise, sometimes people, they have something else. So if we run 2 hours later, you understand, they might have to teach or something. Well, just 2 things that I don't forget for Alice. I just would like to address finances. So how much does it cost? And especially this was one of my issues also about vulnerable groups. Yes, it's good to provide special assistance, but how much it would cost? What sort of finance? Poverty, alienation. So this is what then you said, this is a little bit like we in COVID situation, more restriction. So finally we are trying to do better, but finally we introduce more restrictions. And the last thing in the concept, in the context of EU, you know that we have return directive and we have this forced returns, like for instance towards Afghanistan, and now the issue is, how would you organize this? Well, Salvini, Minister Salvini at one time, he wanted to empty one camp and he just provided buses, but the migrants were not there anymore. So when the buses came, because it was, when the buses came, there was nobody to take on those buses because, well, they didn't want to be allocated or, and so on. So they disappeared. So this is it not true, Professor Ricci, that it was just like this, what I remember, but maybe not now. So how would you do it such a situation? Because we need to go to our following speaker. Thank you very much, Dr. Romeo, that I made a mistake. I do apologize. So this was a conference in Messina that provided me some excellent ideas for speakers. So Professor Dr. Giuseppe Romeo from Messina is going to talk about transnational criminal organizations and migrants, torturers and victims of illegal trafficking of persons. So vulnerability in form of victims and oppressors. So Dr. Romeo, sorry, like Romeo and Juliet. Okay, so I just now remember now forever.
Exactly. Okay. Thank you very much, Professor Gromek, for inviting me today and giving me the opportunity to add a piece to this very interesting debate. I remember very happily the Congress of Messina in 2019, where we first met. So I'm very glad to be here. Well, my discussion, my speech will focus on the main subjects of the main actors of international trafficking of persons. In other words, the traffickers, the criminal organizations on one hand, and migrants. So in order to better understand the phenomenon and to reflect on the most effective tools for tackling this transnational crime on one hand, and for protecting the victims on the other hand. As we know, the world population is growing every year, and so is the volume of trade. The increase of such commercial exchanges was also driven by the increase in the last 25 years of migratory flows. In this context, criminal organizations have been able to create a real illicit market capable of recruiting, subjugating, transporting, and eventually exploiting migrants in a plurality of illegal activities. This is the so-called international trafficking of persons. Italy, in particular, placing itself at the crossroads of numerous of migratory routes, has found itself particularly exposed to this phenomenon. But what are the main causes of this phenomenon? We can remember three of them. The three main causes are the growing gap between industrialized and developing countries, the mood of growing political and religious instability in certain areas of the globe, and to climate change. We know that because of climate change, a lot of people are escaping from their countries of origin. So the need to combat this new transnational crime raises multiple questions on the two subjective poles of this crime, which are the criminal organization, in order to understand the transnational nature of them, of those organizations, and of the migrant, who has to be seen as a real and effective victim of the international trafficking of persons, who deserves adequate protection in the difficult and subtle distinction between trafficking in person and smuggling of human beings, and smuggling of migrants and trafficking in human beings. With the reference to the first profile, the profile of criminal organization, the phenomenon first of all, of being for acquiring a transnational nature has a nature of organized crime, which requires diversification of roles and a structure. Moreover, organized crime related to smuggling and trafficking has undergone a progressive internationalization that has favored its expansion beyond national borders. The causes can be found, among others, in the intrinsic nature of the goods exchanged. The migrant, of course, come from a different country from that of destination, and to globalization of economy. Organized crime, therefore, taking advantage of the existence of larger holes in international communications and exchanges, has been able to cross national borders much more easily. Therefore, it emerged the real transnational nature of organized crime in this context. And with this expression, we allude to the cooperation that different criminal groups have established among themselves to manage more effectively this illicit market. Due to the strictly transnational nature of this crime, the presence of roles which requires a much more independence than the past led to an increasing demand of outsourcing of certain illegal activities. And this is another main feature of these new groups. They are therefore distinguished by a much more fluidity and flexibility. Traditionally, in fact, organized crime groups were characterized by hierarchical and territorial organizations. In this context, on the other hand, the new groups, without completely depriving themselves of forms of vertical control, are characterized by a looser network organization. It follows a greater attention and focus on the activity rather than on the group, whose components become interchangeable, and the same groups, if neutralized, are quickly replaced by new ones. This is the first subjective pole of transnational trafficking in person, and the other subjective poles which have to be analyzed as well from a criminological and legal point of view is the migrant. In order to identify the most effective tools for protection of its fundamental rights seriously damaged by criminal conducts of extremely offensiveness and cruelty. First of all, we have to make a change of perspective, because often the migrants are not seen as a victim to be protected, but rather as a foreigner to be expelled and to be rejected. So in order to avoid the risk of disinterest towards migrants and to creating a category of second-rank victim, we have to switch from a view of the migrant as a foreigner and illegal foreigner to be expelled to a victim, a real victim to be protected. That being said, the migrant is treated in a radically different way, depending on whether he is subject to one of the two offenses of trafficking in persons, of illegal trafficking in persons, which are the smuggling of migrants, as we said, and trafficking in human beings. Because the status of migrants identifies himself with that one of the victim of the crime to be protected only in case of trafficking, not in case of smuggling in human beings as well, where the migrant is seen as an illegal immigrant to be expelled. This is because in the case of trafficking, the migrant passively undergoes trafficking as he is believed to be recruited without his consent through force and violence, or in the presence of a consent extorted with a deceptive conduct. In the second case, instead, it is the migrant who requests the irregular transport, placing himself almost as a partner in crime of the trafficker, who merely satisfies a demand coming from the former. So we can see the difference from a definitional point of view between those two offenses. Smuggling of migrants punishes the illegal transportation of migrants from a country to another country with the consent of the migrant for the purpose of profit. Trafficking in human beings, on the other hand, punishes the illegal transportation of migrants without their consent or with a flawed consent of migrants with the purpose of their exploitation at the end of the journey. Therefore, the interests protected in the two cases, in the two offenses, are different. The smuggling of migrants protects a collective interest, that is the interest to protect national borders and to manage migratory flows. On the other hand, trafficking in persons is intended to protect an individual interest, that is the interest of the migrant, which is seen, as we said, as the real victim, as stated by its systematic placement in the Italian criminal code among crimes against the individual. From this difference, we can notice the different role of the migrant. In case of smuggling, the migrant is a mere object of the conduct. He is neither co-perpetrator nor victim of the illicit conduct, and his irregular status is a mere precondition of the unlawfulness of the conduct of those who allows or facilitate their entry or stay. The role of victim is instead undisputed in cases of trafficking, since the migrant holds the position of the offended person. This is not a mere descriptive distinction, since the measures for protecting fundamental rights of migrants are only provided for in case of trafficking in persons. So the differences are very important from this point of view, from the point of view of emphasizing specific measures for protection of the migrant, which are provided for only in case of trafficking and not in case of smuggling of migrants. But this overview is the result of an abstract and legal analysis, since there is no general consensus among national and international doctrine with reference to the exclusion of the role of victim towards the smuggled migrants. Indeed, in practice, the difference between those two conducts are much more blurry than from a definitional point of view. Let's think of the cases where the migrant is subjected to a position of slavery by the trafficker because the trafficker wants to subjugate the migrant in order to ensure the payment of the cost of the transportation. Or, for example, the migrant cannot pay for its transportation, so he can be exploited at the end of the transportation. In this case, we notice a merge between the two conducts, because the trip begins with a demand coming from the migrant, as stated by the definition of smuggling, but it ends with the purpose of exploitation, which is a character, a feature, a specific feature of trafficking in human beings. So the difference from a factual and concrete point of view are not so specific as from an abstract point of view, and there is a close link between those two conducts. There is, moreover, evidence of the torture, violence, and abuse to which migrants are subjected during the journey, so that we can say that smuggled migrants have undergo a position of vulnerability very close to the one of trafficked migrants. In fact, the statement according to which the individual voluntarily undergoes migration at the cost of his own life, it's not true. Indeed, the migrant is forced to go abroad, to go in another country, because of extremely poor conditions, conditional poverty or serious danger for his own safety. Hence, as a forced migrant, he deserves protection as well as trafficked migrant. This notwithstanding, on an international level, the migrant is considered as a real victim of in case of smuggling. Let's think of the United Nations Convention Against Transnational Organized Crime, the Convention of Palermo, which establishes a means of protection of the migrant only in the trafficking protocol and not in the smuggling protocol as well. In the smuggling protocol, while providing that migrants shall not be prosecuted for the illegal journey, it does not recognize them the status of victim, consequently ruling out the related protection measures. Hence, we need to extend the status of victim to smuggling migrants as well, since there isn't any significant significant difference between the vulnerable condition of the smuggled migrants and the vulnerable condition of the trafficked migrant. The smuggled migrant, in fact, has no real acceptable alternatives rather than submitting himself to the abuses in question. Once established that we need to extend the status of victim to smuggled migrants and not only to trafficked migrants, we have to reflect on what are those protection tools. And we can link to what we said before with Ms. Na. Indeed, the fight against international trafficking of persons can be said truly effective without the provision of instruments for the protection of the victims. The willingness, in fact, the willingness of trafficked persons to cooperate with the authorities depends on the existence or not of protection measures, of legal and social assistance, on the risk of being prosecuted for the illegal journey or for related crime, or of being expelled, as well on the respect of their privacy. To that end, the identification of the effective or the potential victims is a crucial moment. And I need to focus on I want to, how can I say, stress out the expression of potential victims, which are people, migrants, who are not, but maybe in the future be exploited. So the identification of both of those figures is very, very important. Indeed, a correct approach towards them can avoid the risks of negative outcomes of criminal proceedings against trafficking due to the limited availability of evidence, because of the reason we talked about before during my intervention to Ms. Na's speech. The trafficking protocols, in fact, provides for specific form of assistance of a procedural and social nature. Among the former, we can mention the need to guarantee confidentiality in the identity of the victims, provision of legal assistance so that the victim can express his views and concerns during the criminal trials against the traffickers, and compensatory measures for the suffered pain. Among the forms of social assistance, we can mention adequate accommodation opportunities, medical, psychological, and material assistance, employment opportunities, education, and mental assistance. Only through these protection tools, we can ensure the cooperation of the migrant not only for protecting their fundamental rights, but to ensure their cooperation even in order to obtain the conviction of traffickers during criminal proceedings. In the context of the European Union, with regard to this context, the main act is EU Directive number 36 of 2011. This directive, after establishing specific criminalization duties for member states, provides for numerous of protection measures for migrants who are victims of trafficking. But these are mainly overlapped to those provisions established in the trafficking protocol of United Nations Convention against Transnational Criminal Organization. But there are some news. For example, the need to adopt preventive measures of secondary victimizations of migrants in order to avoid unnecessary repetition of hearings during investigation and criminal proceedings, to avoid eye contact with the defendant, which is normally the trafficker, avoid public hearings or irrelevant questions about private life. At the national level, the main legal act is Legislative Decree number 24 of 2014, which implements the EU Directive number 36 of 2011. For this reason, its provisions are mainly overlapped to that in the EU Directive that we just mentioned, even if it has some omissions, relevant omissions, such as the provisions for preventive measures of secondary victimization, which do not find place in this legislative decree. In conclusion, an holistic approach to illegal migration, which aims to tackle the illicit trafficking of migrants, need to take into consideration legal and criminological analysis of its two main actors, transnational criminal organization and the victims. And by victims, we mean both smuggled and trafficked migrants. The study of the former, so of the criminal organization, allows us to understand how the most effective weapons against trafficking do not have to address neither the individual nor the group, but rather the illicit profits, because of the economic nature of this crime. So we need a suitable mechanism to identify, freeze, and seize the illicit capital managed and accumulated by those groups. And for example, at the EU level, we have the EU Directive number 42 of 2014, which provided for specific seizure measures against organized crime, for example. On the other hand, we have to reduce pull factors of irregular migration by implementing measures, economic and geopolitical measures, in order to reduce the demand of irregular migration. The study of the migrant allows them to identify the most effective ways of approaching them in order to ensure their investigative procedural cooperation, as well as identifying the most appropriate tools for assistance, bearing in mind the serious violation of fundamental rights they suffered during their journey. Thank you.
Thank you ever so much. Thank you for this very interesting talk. I have some comments, but first the floor. And also I would like to ask if Federica is here, because maybe we can answer the Benedetta question, because otherwise we will never be able to answer the questions which were interesting.
I'm here.
Yeah. Any questions for Dr. Giuseppe? Giuseppe, how Alice is calling Dr. Giuseppe. Dr. Giuseppe, any questions? Benedetta has a question for Dr. Giuseppe? No. Dr. Any questions? So your argument is, I always comment something. So your argument is extended vulnerability for smugglers. As we know, the definition of smuggling people, they have a part of their own responsibility what happens to them. So again, not to be tacky, but I think that the question is how your ex-minister Salvini, nothing wrong, would have taken that. Already he got a headache with children as vulnerable groups that need to be protected. So if we extend in addition, smuggling people into the definition of vulnerability, so we would need to provide them special protection. So I don't know how it would be accommodated. It could have been accommodated in the time of Salvini, but the time is changing. Another issue on this, it would be how this. First of all, what sort of data we have during the pandemic crisis on smuggling? Has it been a little bit lower than normal, or completely pandemic does not influence this at all?
Well, I believe that during the pandemic times period, the data are a bit lower than before, because of every kind of journey has been stopped. But I don't think that he completely stopped the phenomenon of irregular transportation of migrants. With reference to your first question, I think that the issue is the status of vulnerability of the migrant. This is not a matter of whether the demand of migration comes from the migrant or not, which is the difference between migration and trafficking. The matter is if the migrant deserves protection because he's in a vulnerable position. So even if it's a woman, even if it's a child, or a smuggled or trafficked migrant. In the cases they are in a vulnerable position, they require adequate means and adequate ways of protection of their fundamental rights. Of course, maybe if they do not have the right to remain, to stay in the state of destination, maybe they can be expelled, but not before recognizing them the obvious means of protection of their fundamental rights, because of the sorrow they underwent during their trip. So I think this is a matter of, and this is a thing that a fil rouge of all those interventions that we're going to have today. This is on the basis of whether there is a vulnerable position or not of the migrant.
Excellent. Well, but now I can, well, so we know that the definition, well, I did specify to all my speakers that starting point is the definition of vulnerability within the SIA system. Why? Because when we go a little bit wider, we can talk about disability, how it is construed within the EU law or within UN Convention on Disability. Now, the issue that the SIA system provides some elements into what does it mean position of vulnerability, but it's not completely, well, we can say it's not an exhaustive list, so we can say this, and this your idea, and we have those specifications: the elderly, women, if they have specific, well, if they are pregnant, or the elderly, and so on. So here the question would be to discuss, is a smuggling person in the position of vulnerability? And this is your argument, that your argument is that yes, it is, but I think that it's very interesting for an article. So why do you think that the position, and this is what your talk was about, that why a smuggling person is in the position of vulnerability within the definition? Or we might say that it's not within the definition of EU law, but this is form of vulnerability that should be considered. So this is what I said to Professor Jones, that it's not really what is in the definition, but what it's not. So this is what is more important. Any questions for Dr. Romeo? If we don't, maybe we can consider the one question of Benedetta for Dottoressa Bellassai, because otherwise, so where is Benedetta? Ah, Benedetta is here. Okay.
Okay, so if I remember, the question was about our collaboration with other stakeholders to enhance the protection of people we assist. So we can say that the Italian Red Cross works on two levels of collaboration, because the first one, and I think the most, let me say, important for us, or at least impactful for our intervene, is for sure the network. Because each person we work for can receive support from different components of our international movement. I mean, if a person starts his journey from a little place from Africa, that person can meet one person from the Red Cross. So the protection approach starts from the first stage of the journey, the migration in this case, till the last place of arrival, in this sense, Italy. But in the sense of institutional collaboration, of course, we are working a lot also on the advocacy, but it's not the classical advocacy when the people speak louder to speak about the rights of person, but through real action. For example, also the collaboration that we have with sometimes at local level with some non-detention in Italian is oh my God, places like centri di oh my God, the carceri. So I don't know in English because the difference is
alternative detention, I think.
Yeah, alternative detention, yes. For example, to maintain the contacts of all the people in detention situation, or for example, also on the missing person, we have this collaboration also with the authorities for missing person in Italy. So the Italian Red Cross is like to focus the attention through institutional collaboration also to these important topics. Of course, in the tracing process, we do, for example, to restore or to trace some people who is missing, we collaborate with the Ministry of Interior just to understand if the person, for example, is still in the territory or not. So, of course, this is a kind of alternative way to do advocacy on these themes and on these topics. I also would like to add something related to the previous topics, that was the family reunification and alternative schemes to support the unity right of family members, because also in these topics the Italian Red Cross is present. Because just some months ago we are starting a project to the alternative schemes in the family reunification, and this is in line with our view and our vision to family unity, that is not strictly linked with the family reunification concept at we can say at institutional level, but with a sense, a meaning of family reunification larger than the institutional point of view. So also in this, I would like just to add something. I don't know, Benedetta, if I gave an answer to your question, or if you want to know something else on our response on this.
Benedetta, we can't hear you.
Yeah.
Okay. We can't hear you. Okay, guys, Benedetta, if you could maybe send the questions maybe in chat, and we could maybe, because we can't hear you at the moment.
Yeah.
And
you can write.
I have to first, so we can maybe address this a little bit later on. The next would be Professor Martin Johnston from the questions that remain. But first of all, I would like to thank very much Dottore Giuseppi. I really like this. Dottore Giuseppi, it's very interesting. It had a real argument, and I really need to think a little bit about this argument. Anybody has a question? Well, why don't you reflect on the question for Dr. Giuseppe, and I will go ahead with the conference because we are just a little bit late. So I said that the EU law cannot be seen in isolation from international law. It's absolutely impossible, and they are really connected. In the same way, I just wanted to say that the conference is very interdisciplinary. It's very interdisciplinary for the purpose that, again, we cannot see vulnerability only from the legal point of view or political point of view, but we need history, we need sociology, we need other disciplines to be able to understand what the content of vulnerability. So here in Pavia, we have a group, a very active group that works on migration, and we have researchers and Professoressa, Dottoressa Fusari.
Dottoressa, va benissimo anche solo il nome.
Valentina Fusari will give us a different account, a different view or insight into vulnerability, and her talk, and she is from Pavia, she's from our team in Pavia, and she will be talking about the portrait of vulnerability from hidden populations to positive discrimination. So thank you, the floor is yours.
Thank you, Professor Gromer, for your invitation. And yes, what I would like to do today is to share with you some of my reflections that come, let's say, from the fieldwork. I'm an anthropologist, and my research are focused mainly in the Horn of Africa and in Eritrea. So when I'm there and during my, let's say, my research, I am mostly in touch with people that, in the eyes of Europeans, can have a high probability to be a vulnerable group once they migrate, as Eritrea is one of the main refugee producers in the Horn of Africa or in the sub-Saharan African countries. So what I would like to do is to make a step back and try to understand if the definition used or commonly known about vulnerability is something that works also out of the European or the legal framework. And what I try to do is just to put them in a different context, because in my opinion, vulnerability and vulnerable group are context dependent. So we have a lot of definition that can help us in stipulated guidelines to treat and to grant protection to specific vulnerable population. But the concept of vulnerability and also the criteria to design vulnerable population, in my opinion, they are a little bit vague. So we have vulnerability, that is a kind of abstract concept, a kind of fluid concept, but that has concrete effects on not only on the people that can be labeled as vulnerable, but also for the one that need to treat, or the one that need to be in touch with this group and to protect this group, but also for researchers. So I just start from the simple definition that the Oxford Dictionary provides for vulnerable people, that are those exposed to the possibility of being attacked or harmed, either physically or emotionally. So let's say that vulnerability has intrinsic factors related to individuals, but also external factors that are more linked to the community or the environment. So vulnerability is a multidimensional construct, and because of that, we can be exposed as human beings to different kind of risk. And these different kind of risks not only determine our level of
vulnerability, but they determine our status. And the status is something that is usually socially constructed within a society. It's a category. So if this is a category, we should make an effort to think that also vulnerability, it is a socially constructed and content-dependent concept. And when I say content dependent, it doesn't mean only a physical or a cultural or a sociocultural or economic environment, but also, for example, a legal environment. In the case of the Charter of Justice of the European Union, we can consider this one as the environment, as the framework that is able to socialize people that are vulnerable and people are going to work with vulnerable groups. So just I consider in my presentation vulnerability as a buzzword, as a notion that is able to account for a lot of situations that people are facing or that people had faced in their country of origin, if you're speaking about migrants. But at the same time, I would like to consider it also a positive situation in the sense that it creates the condition to move out of a marginal situation as well as disadvantaged situation. So my communication is threefold. First of all, I would like to stress the content-related nature of vulnerability. Then I would like to understand how it relates with different forms of powers and how a bottom-up agency can emerge, can engender from the situation, from a disadvantaged situation. And then I would like to outline some challenges that I've experienced during research with vulnerable groups. So the first point is that if we assume that vulnerability is a universal and constitutive condition of the human being, it means that at every time we are at risk of something. Nevertheless, we consider someone vulnerable only in a situational content-dependent situation. So at the, let's say, theoretical level is something that concerns the full population, is something that concerns every human being. But at the situational level, at the individual or group level, it's something that is characterized by particularity and uniqueness. So it means that there are some social devices and some social processes that are able to make people vulnerable and to lead these people to marginalization or exclusion or oppression. And the most of the time we are looking for one simple situation that can determine the status of the people. Instead, as the intersectionality says, there are an overlapping, say, level that can determine a specific status. So usually I try to summarize this situation when I read the title of our seminar, I thought, okay, thinking about the Eritrean migrants. Are they vulnerable because they are migrant, or are they migrant because they are vulnerable in their own countries? And this changes perspective can change their status of vulnerable people under, let's say, a strong and strictly regime, or are they vulnerable because they face specific oppression during their travel from out of Eritrea to Europe, let's say, for example, in Libya. So on the basis of these questions, I think that the important criteria to define a vulnerable people is that it's to something. So when as social scientist, I try to approach a vulnerable group, I should first of all define their vulnerability. So I should first of all define to what are their vulnerable, what determine their condition. And also I have to understand which network can ease or help them to cope with this situation, and also how their situation can change moving out of a context. So sometimes we are not solving vulnerability, working on vulnerability, but just changing the context. But changing the context doesn't change the mind of where these people has been socialized to specific, for example, bodies difference, as well as cultural or religious or gender differences. So the most of the time we are used to approach these people as passive groups. But going now to the second point, I've seen that most of the time they are active group. Vulnerability is not per se a limiting condition. Sometimes it is the motivation. So as I'm vulnerable here, I decide to move without knowing if during my travel heading to Europe, maybe I can be even more exploited than what I am in my own country. Or maybe I have been marginalized because my sexual orientation, and it can I can be hosted in let's say a center where I experience the same offenses or the same oppression. So we have the same situation that can be approached by different actors in different ways, in different time and context. What I've seen during research with Eritreans is that the most of the time their situation as vulnerable people push them to mobilize material and immaterial resources to move out of their condition. So the risk is that if we not consider the positive side of the vulnerable group, or what vulnerability can create in this vulnerable group, the risk is that our approach is just a paternalistic approach in solving the problem or assuming to solve the problem of vulnerable people or group. How many times are we considered as perspective in the solution we put in place when we are going to solve their situation or to change their status? In another example, not in the Eritrean case, but in Jordan, for example, that in order to solve the problem of the Syrian women that reach Jordan, we create a kind of positive discrimination towards the refugees, but we decrease the services, above all in terms of education, in terms of health, in terms of water for local population. So what happened is that in order to solve the problem of a vulnerable group, we create another, let's say, self-perceived vulnerable group that start a kind of risk chain. So there are a lot of people that now is under attack, under verbal attack, under physical attack because they have been helped by international organizations, they have been helped by third-party actors, and so on. So the most of the time, the risk is that, above all outside Europe, that the intervention of European or non-local or not socialized groups can create a chain of risk instead of diminishing the vulnerability of specific groups. And the last point that I think it's a different compared to the legal system I heard until now, is that when we are working with vulnerable group in their place of origin, in their country of origin, the most of the time they are hard to reach, they are hidden population. So they are not so easy to find, they're not so easy to recruit. It's really hard to create a sample that can be representative by a statistical point of view. And it's really a risk to get in touch with this person for the researcher, but also for the people that on the one side, they will like or use or take the opportunity of the researcher to speak out about their vulnerabilities, but at the same time to speak out of their vulnerability, increase the degree of their vulnerability. And so we should put in place a long list of ethical, practical, and methodological resources in order to keep our key informant safe, to be sure that they are at least representing a group or the voices of the population, the small population they are of which they are part. And we should also consider the implication, because the researcher, after maybe 1, 2, 3, 4 months, the researcher, they can go away, but that people have to hide even more than what they haven't done before. And in an egoistic point of view, we have to say also that also the researcher, then they don't know how they can or when they can exploit the material they have collected during the fieldwork. Because if the first priority is to keep safe your informant, it means also that it's not so easy to publish what you have collected during the fieldwork. Above all, if you are speaking of a minority, or if you are speaking a vulnerable group that maybe, let's think about the Eritrean case, a political opposition group that is hidden, is not existent. Or at the same, another example for the Eritrean case are the homosexual people. Homosexuality is forbidden, and homosexual people are put in jail for at least 10 years in Eritrea. But at the same time, if you speak with Eritreans, they say in Eritrea, homosexuality doesn't exist. But if you look at the data concerning the cause of requesting protection in Europe, we've seen that a lot of Eritreans, they have used homosexuality as the motivation to ask for protection. So every time we have to cope with something that in the society doesn't exist. At the legal point of view, it's punished, and it's something that is recognized as a cause that can lead to protection. It's something that determines a vulnerable group. So as an anthropologist, what I hope for the further research is that we can really boost interdisciplinarity, because of the time, most of the time, the categories we use to design, to outline vulnerable people are not understood in the places of origin, and they can be only exploited in the, let's say, movement from one context to another context. And another point is that we can maybe try to discuss and to understand what is the meaning or the local terms used to describe and define vulnerable people. The same things happen with, for example, development. A lot of in Eritrean, we have 9 ethnic groups. 4 of them, they didn't have at that time a word to describe the word development, but international agency and donors were pushing for development. At this time, we are pushing for safeguard and treat as or at least change the status of vulnerable population. But who are these vulnerable population? Can they be self-defined? Are we considering self-defined categories as vulnerable, or to be vulnerable, these people have to fall into a predetermined category? So I've finished, and it's only, I know, a kind of sharing my reflection, because a lot of things and other case studies and example will be described this morning, but also in the afternoon. So thank you.
So thank you very much, Dottoressa Valentina. This was very interesting. Well, my idea is really very interesting and a little bit it puts us in a different context. So for instance, what I learn and what I like it really, that it's content dependent, completely agree on this. Multi-dimensional construct, absolutely. Intersectionality, that I would like you to explore on this. But what I suggest, if you are not extremely in a hurry, maybe we can get Dottoressa Dalzotto, because she has some problems with child care and so on, and then we can stay for the discussion. Just the only one thing, that this is the same that I would have this reflection to Dr. Giuseppe. I like this. So the issue is that the law needs to be precise, because the law, as I'm teaching my students what the law is. So the law triggers certain responsibilities. So saying that, yes, we have different, we have to construe vulnerability wider and so on. Yes, but we need also to have some brackets that would tell you that if you don't observe, there is a certain responsibility that would be triggered. So saying position of vulnerability without specific, but what, well, so this is the argument that we can explore more and more and more. But what I'm saying is that saying only that, yes, smuggling people are vulnerable, we have to determine certain parameters in law. But anyway, questions later on. Dottoressa Dalzotto was extremely active in migrating group, and she is she has done many projects as well on this. So I'm sure, and finally, I'm sure that she particularly liked this topic when I told her. So the floor is yours, Dottoressa Dalzotto.
Thank you to Professoressa Gromek for organizing this really interesting event. And I apologize for coming so late, but I had a baby management problem this morning for the new red zone, so I apologize. My intervention will focus on the recent changes in the Italian reception systems, on its historical limits and how they meet condition of vulnerability. The first forward is in which way we assume the concept of vulnerability. We can intend vulnerability as a universal condition. So we consider that there are no invulnerable subjects. But we can assume vulnerability also as a particularistic condition. So a prerogative of a certain group, for example, for their age. This particularistic assumption can lead to stereotyping and the victimization of this group. But at the same time, particular and contextual dimension of vulnerability allow to capture the diversified experience of the subject and their location at the crossroads of multiple potentially vulnerable and discriminating factors, just to follow the concept of intersectionality introduced by Valentina Fusari before. So vulnerability is a human condition that is both universal and particular, original and derivative. It depends from economic, political, cultural, and legal assets in which subjects are inserted. My second forward, it's related to the fact that current restrictive policies and norms regarding international migration produce vulnerabilities that are independent of war, persecution, and discrimination. At the same time, this vulnerability risks to restrict the right of asylum seekers. It seems in some cases that we have to be vulnerable to receive protection. It's not just an issue of protection, it's also an issue of reception. Under the European law, we find the concept of vulnerability both in the directive related to the status of asylum seeker, the qualification directive, and in the directive related to the reception of applicants for international protection. Let's see how it's work in Italy and the Italian reception system. In Italy, the directive on reception has been adopted through the decree 142 in 2015. And this decree pay particular attention to subjects with special needs in its article 17. The so-called vulnerable people, whose number is extended compared to the past, for which specific measures are introduced in the reception and in assistance procedure. Those special reception services are activated within the governmental centers, also ensured in collaboration with the local authority competent for the local area, which must guarantee particular assistance measures and adequate psychological support. Among all the categories of vulnerability, particular provisions are reserved for the reception of unaccompanied foreign minors. The Article 17 of this decree provides that the reception is provided taking into account the special need of asylum seekers, in particular those of vulnerable persons such as children, unaccompanied children, disabled persons, elderly people, pregnant women, single parents with minor children, persons who have been subjected to torture, rape, or other forms of psychological, physical, or sexual violence, victims of trafficking and genital mutilation, as well as persons affected by serious illness or mental disorders. The decree, in the attempt to give an organic structure to the Italian reception system, which from its birth at the end of the 90s is characterized by fragmentation and by an emergency approach, distinguishes between a first reception based on governmental centers, which also include those of extraordinary reception, and the second level of reception, the protection system for asylum seekers and holders of international protection, the so-called SPRAR. The SPRAR, in the last 2 years, has undergone profound transformations. The decree law for October 2018, number 113, renamed the SPRAR in SIPROIMI, Protection System for Holder of International Protection and for Unaccompanied Foreign Minors, and reserve access to holder of international protection, so asylum seekers are not allowed to enter in this system, unaccompanied minors, person in possession of residence permits for special cases, medical treatment, disaster in the country of origins, and act of particular civil value. Special cases are those related to a particular situation of vulnerability, like victim of trafficking, domestic violence, severe labor exploitation. I would like to highlight that this law concerned the stay permit for humanitarian reason. This permit that was residual with respect to form of international protection in the past made it possible to take into account situation of vulnerability that did not have to do with the country of origin, but which were the result of the migratory path. Anyway, this law has repealed the provision that envisaged the activation of special reception services in the sparsi proimi facilities for vulnerable people. Currently, in case vulnerable people reach to access the SIPROIMI system after the grant of a title of protection that allows the access, they could enjoy some additional services allowed by the decree 18 November 19 for disabled persons and persons affected by serious illness or mental disorders. The law clarified the need to set up specific spaces within governmental first reception center where services related to the information, legal counseling, psychological support, and receiving visitors are ensured. Where possible, adult vulnerable people are placed together with other adult family members already present in reception center. The manager of reception center shall inform the prefecture on the presence of vulnerable applicants for the possible activation of procedural safeguards allowing the presence of supporting personnel during the personal interview. Again, another change came in the last year with the law 173 of 18 December 2020 that renames SIPROIMI into SAI, the Reception and Integration System. The new law provides for the reception of applicants for international protection, as well as holders of protection, unaccompanied foreign minors, as well as foreign entrusted to the social services upon reaching the age of majority. Furthermore, holders of stay permits for special protection, for special cases, victim of disaster, migrants to whom recognized particular civil value, holder of residence permits for medical treatment. Within the system, two levels of reception service are provided. Applicants for international protection access the first level and access all the other categories listed above at the second level aimed at integration. In the last, in 2019, that is the last year for which we have complete data. So we are considering not the new SAI, but the SIPROIMI. In front of 844 projects, 47 were for people with mental and physical disabilities. 166 projects were for unaccompanied minors, and 631 were for the so-called ordinary categories. From the analysis of the annual report related to the activities carried out in 2019 by the projects, they welcome both adults and minors, a significant presence of beneficiaries in condition of vulnerability emerged. The most significant data refer to victims of torture and violence, the 8.4% of the total, a slight increase compared to that recorded in the previous year, followed by the victim of trafficking, 4.9, and the beneficiaries with mental health problem, 3.7%. If attention is focused exclusively on the last useful year, a clear gender differentiation clearly emerges. Women are for the most part victims of trafficking and torture and violence. The experience gained over the years has led to note that conditions of vulnerability are quite widespread among the population of forced migrants. This has led to the need to respond to these needs with a reception network able to guarantee an effective and widespread take-up of the various vulnerabilities through the territory, through an homogeneous increase in a reception standard and an increasingly integrated approach in the local welfare system. Taking charge of people with vulnerabilities or with special needs involve greater complexity in terms of reading needs, emergence of discomfort, building a relationship of trust, and requires strengthening networking with local, public, and private individuals, and with external professionalism and expertise able to support treatment, rehabilitation, and reintegration paths. Many steps have been taken by reception system in this direction, but critical aspects still remain at the moment. And I move to my conclusion, starting from this critical aspect still remaining. So due to the historical underdimensioning of the reception, the scarcity of resources dedicated to it, and the emergency approach that characterizes it, it happened the provision of the law for receiving vulnerable are disregarded, or that reception itself give rise to or exacerbate situation of vulnerability. The reception decree 142 in 2015 provide that asylum applicants undergo a health check since they enter the first reception center and in the temporary reception structure to assess their health condition, especially reception need. Actually, there are no legal provisions on how, when, and by whom this assessment should be carried out. The decree provides, in theory, that special services addressed to vulnerable people with special needs shall be ensured in first reception center. However, the reduction of funding and services provided in first reception center under the 20 November 18 tender specification scheme, the so-called capitolato of the Ministry of Interior, and the exclusion of psychology services from eligible cost will render the effective identification and protection of this category of people even more precarious. Again, in first reception center, no specific or standardized mechanisms are put in place to prevent the gender-based violence. Concerning the historical underdimensioning because the lack of places available in CIPROIMI in the former SPRAR, it's not always possible to transfer their families in vulnerability condition, unaccompanied minors, or unaccompanied minors asylum seekers who have become adult. At the end of 2019, the total number of unaccompanied children accommodated in Italy was 6,054. Of those, the 94.5% were accommodated in reception facilities, while 5.4% were accommodated in private housing. As of January 2020, 2,000 places were financed for unaccompanied children in 155 Sprarsi Proimi project. The number of places dedicated to unaccompanied children still fall short of current need. So 6,000 unaccompanied children present now in the reception system. For bad condition in in some cases, in first reception of unaccompanied minors lead to 5,000 unaccompanied children absconding the accommodation. For unaccompanied minors were implemented, stay in first reception center cannot exceed 30 days and must last for the strictly necessary time for identification, which must be completed within 10 days. These serve to identify and assess the age of the child and to receive any information on the right recognized to the child and on the modalities of exercise of such right, including the right to apply for international protection. Throughout the time in which the child is accommodated in the first reception center, one or more meetings with an age development psychologist are provided, where necessary, in presence of cultural mediator, in order to understand the personal condition of the child, the reason and the circumstances of departure from his or her home country, and his or her travel, as well as his or her future expectations. The permanence of minor in first reception center is extended well beyond the deadline of 30 days and continue in most cases up to the actual completion of our age, involving the lack of access to second reception project. Lack of sufficient number of centers for unaccompanied children in the border area, resulting in a lack of adequate response to the needs of unaccompanied children in transit at the northern border. Unaccompanied children cannot be held or detained in governmental reception center for adult NCPR. However, through 2017 and 18, both due to the problems related to age assessment and to the unavailability of places in dedicated shelter, there have been reported cases of children accommodating in adult reception center. All these, and concluding, all these examples confirm that if we consider vulnerability as something situational, we should remember that sometimes vulnerability arises not related to the starting condition of migrants, but to the travel. Humanitarian stay permit took this into account. And NGOs denounced that in the last 2 years, due to the withdrawal of the humanitarians from the SPRAR, the inclusion paths of many vulnerable people who had received this permit were interrupted. We can say the same for the time after the arrival in Italy. The waiting, the uncertainty in reception facility can lead in some cases to a psychopathological risk. So again, vulnerability can arise. Adequate resources are needed to avoid this phenomena. A reception system for asylum seekers and holders of protection, structured and appropriate to the current dimension of the phenomenon of forced migration, could help to offer adequate hospitality to those arriving in vulnerable condition and avoid the emergence of new situations. Thank you.
Thank you very much. Thank you. It was very, very, very interesting. And finally, Emanuela said that she's not a lawyer, but she addressed everything like a lawyer, because, well, so this is what the lawyers also do. Thank you. There are many, many issues that I want to thank you for. First of all, you provided the definition, because I missed, well, at the beginning I was so stressed, and I thought that I can't be late with different participants, so I didn't provide the definition, which should have been a starting point for the discussion later on. So what do we consider and how we can enlarge, or what we don't consider, and so on. And then you concentrated on Italian law, especially on those problems with, okay, we have a definition, but for instance, assessment of vulnerability, we don't know, you said, when, under which conditions, who should provide them. So all this really interesting. The problems that, for instance, they might not, disability might not have arisen from the beginning, but might be during the journey, and also so many issues. I open floor for discussion, for both. Where is Valentina? Valentina is here. I hope Valentina didn't go.
Yes, I'm here.
Right. And I also would like to know Alice. Alice is not here because we had some questions to Professor Jones, but he had written something, and I don't know if he's going to be back. He's not back, and Alice is not back. Okay, so just for our two speakers, Valentina and Emanuela. So any questions? Hello, who we have here? Maybe I don't see the hands. If you see, just let me know. I thought that it was a very interesting construction and added value to our interdisciplinary perspective. I hope that you see this from your perspective, that the legal framework is important in your context of your research, so your research is important in our context. So any questions? Where is Benedetta? Benedetta likes to ask questions. Benedetta, no. So any questions? So as I said, I have these questions, as I did say. For instance, you said that vulnerability is not, we don't know how it should be tested, under which conditions, who is doing this. So could you expand a little bit on this? This is a very important issue. And for Valentina, I have another question, which would be, Valentina mentioned at one point that vulnerability is a push factor. It is a push factor. Well, she didn't use this as a push factor, but this is what you said, that people move because of the vulnerability. So if you both could expand on this. Who is starting? So let's start with Valentina because she was before. So
okay, yes. What I've tried to say that vulnerability usually is the push factor, not only because people move because they feel vulnerable where they are and in the relation, in the context they fall, but also is a motivation in the sense that push people to find a solution to move out of the vulnerable situation, above all when it depends from environment, from physical environment. It's really harder when it depends on the community or the social environment, because it's not just you move from, for example, the seaside to the coastal area up to the highland because of malaria or because of other environmental or climate problems. The point is harder when you are stuck in a society that don't recognize or oppress you because it is, and you have been socialized to oppress maybe someone that is in your condition. In that case, it's harder to find a solution, but it's a motivation to find a solution. As much as you feel vulnerable, this suggests to capitalize on your material and immaterial resources. In the kind of migration, it's quite clear. Usually it's not, at least in Eritrea, an individual choice. It's a family choice or a community choice. Everybody is contributing, for example, collecting money or granting contacts to move out of the country, to move out of a condition. But imagine that you are homosexual there. I just use this example because it's clearly here when we arrive, and there is an increase in the request of human protection because of this cause. In that case, you can't capitalize on your network, because your network is the one that oppresses you. So what can you do? You can put in place other kind of agency. For example, you got married, you have your own family, you try to hide your condition, and then you move out of the country as a migrant, as an economic migrant. And once out of the country, you try to solve also that aspect of your vulnerability. So in this sense, is a positive in the sense that push and don't put the people in a position of just being passive, just waiting for someone that is going to solve your situation. And the next step is that when you find someone that is able to solve your situation, the risk is that they create a new kind of dependence, because of a paternalistic approach, because of I try to grant what you need now. I'm not giving you improving your skills or improving your human capital in order to upgrade in your life or in upgrade your condition or your family condition. Just I create a dependence to my, and this is a way to go. I think it's also a means of governability. In this case, the risk is that we use weaknesses in order to govern, in order to manage with a group that is a potential risk of upset or a potential risk of, I don't say revolution, but at least a tension, social tension. So I don't know if I...
Yes, no, you did. And what I'm saying that, well, yes, we could, then you raised many questions, for instance, what is not in the definition. So, and here again, I would relate to the discussion of Dr. Romeo when he talks about the definition, but what do we say? So we specified some grounds, and the rest, it is just position of vulnerability, but it needs to be defined in some way. We can, because those people, they don't get protection. And this is exactly what Dottoressa Dal Zotto also mentioned, that yes, we have law which says you have more responsibility for those who are in position of vulnerability, but then how do we execute? So what is this follow-up? Because this follow-up might create a new vulnerability. And this is Dottoressa Dal Zotto. The questions did I already say? Yeah, I did, yeah. You need microphone.
Thank you for your question. As I said, many steps toward a better reception system have been done in the last 10 years after the emerging of forced migration phenomena in Italy in 2011. At the same time, especially in first reception center, the identification of vulnerability is still difficult. I would stress the necessity of adequate resources to professional working in this kind of facilities, in order to can count on people prepared and trained to recognize form of vulnerability, situation of vulnerability, and resources to offer them more training opportunity related to this phenomenon. So the follow-up can be this from my point of view, especially concerning first reception center, which are those more exposed to emergency situation. The problem, in my opinion, is not related to what became in the last year a well-organized system, like SPRAR, CIPROIMI on the now side, but first reception center and center of extraordinary reception.
Excellent. Well, I would have many questions, but so exactly what's the follow-up? So you said that there are many issues that should be considered, and at 3:50 we will have a guest from SPRAR that is going to talk about vulnerability. So if you could you know, connect, it would be really really good. So the problem with vulnerability detection, how it is assessed, and finally the follow-up. Any other question on this issue? We don't have, but I will send him. Did Professor Jones said that he's going to come back in the afternoon, because we would like to have this. He had many questions, but I couldn't really. I just wanted to accommodate everybody, because I don't know, people, they have different obligations or something. So I thought that we could have. Did he say that he will be back? Well, I would just, if he would be back, we would just address those issues. And then the idea of the definition that everybody said something about, but in the end we didn't somehow conclude on this, that there are many vulnerabilities with which the definition does not cover, and because the definition doesn't cover, it might be difficult for those having this kind of vulnerability to have special assistance or special follow-up or any kind of attention that this kind of vulnerability would require. For instance, Professor Jones, he mentioned this at international level, but this is the same in the CIAS system. As I said, that this is the basis of our consideration. For instance, the issue of homosexuality. Well, and then coming back, I'm just only to the definition, to how Dr. Giuseppe construed the position of vulnerability, we would say that yes, homosexuality is not included, but they would, however, come under the definition of position of vulnerability. Yes, but they might not receive the same attention, protection, and follow-up that they deserve. The same I could say about, for instance, Yazidis girls, if they were not raped or tortured. So they would be just, they would be migrant women. Well, and then you say that they still come under the position of vulnerability because well, but the definition should in somehow give them a little bit more power in some, because if they would be, they would be more. What Dr. Giuseppe wants to say?
I would like to say something about this. I think that migrants should be considered. I think that every treatment should be individualized. And what I mean by this, I mean that migrants have to be considered vulnerable per se, because they are migrants, because they undergo a journey at the risk of their own life. So the reason should be very, very, very strong if they drive them to such dangerous journey. But on the other hand, they need to obtain an individualized treatment as well, because they are maybe homosexual, or because they are children. So they need to get specific specific assessment measures because they are migrants. So in order to ensure their cooperation for procedural reason and so on. But on the other hand, they need specific and individualized measures, protection measures, because of their specific needs, because of their specific vulnerability positions that needs to be different from one person to another one.
However, Dr. Giuseppe, your idea is extremely costly. Well, it's just I think that in reality, we simply cannot afford this. And it came out in the discourse of Dottoressa Dalzotto. Finally, why we don't have it. First of all, we don't have it because we cannot afford. Also, well, there would be some political reasons and there would be some others. And that's why the categories of vulnerability are reduced. Because this follow-up and this particular treatment for each of them, don't you think that there is something right with what I'm saying?
Yes, I agree absolutely with you, but we have two different points of view. The point of view of who deserves or not a specific,
yes, of course.
And the point of view of the effective, how can I say, implementation of those of these assistance. Of course, these are two completely different points of view, and I fully understand that yours. That it is really there are a lot of costs, but maybe as Miss Na said before, by implementing maybe alternative measures to detention, we can maybe spend less than what we are spending now with the detention centers, which are much more costful. And maybe what was earned in this way can be spent by ensuring a specific means of assistance to those people, because at the end we can see how useless it is to provide for maybe a criminalization of those activities of trafficking and smuggling and so on, if at the end we cannot convict the perpetrators of those crimes. So in this way, by treating in a certain way the migrants, we ensure their cooperation, and at the end we ensure the conviction of those traffickers. Maybe this allows us to seize assets that traffickers possess, and maybe devolve those assets which have been seized through the cooperation of the migrants, and devolve them to the state in order to repay all those costs.
That's very right. Anybody wants to add? Dottoressa Dalzotto, Fusari?
Yes, shall I add just a consideration on Emanuela's, let's say, hope for the future in order to train people that is able to work in this reception, and they should be a professional figure, a professional profile. And I think that sometimes we are not so keen in consider that vulnerability arises in reception centers.
Yes, this is, she said, in travel, in journey, but of course disability can.
Yes, and that's why we need really keen person, trained person, and not people that is just trying to do their best, but they are not the skills and the instrument in order to avoiding the engendering of new or different form of vulnerabilities that are also so distant from what a person can or perceive or imagine to reach in this center. And instead, concerning the proposal, let's say, or the idea of Dr. Romeo, yes, I don't know, but when we say we should do this or we should do this, what do you know about what is a smuggler or a trafficker in the eyes of the migrants? For example, the smugglers are the saviors. They are the heroes for a lot of people. So I think unless we do not consider who these figures, who these profiles are in the eyes of the migrants in this case, or in the eyes of other vulnerable peoples, it's hard to provide an approach that is able to benefit both the one that are in charge of, let's say, the hosting or the treatment of this population, and to consider, I mean, if I've been smuggled, I don't want to be considered as a vulnerable people, because there is my agency. I'm the one that is going to look for the smuggler. I'm the one that is going to collect money to pay for the smuggler. And I'm not going to tell who the smuggler is, because this can stop the opportunities for my brothers, for my sisters, and so on. Another discourse, in my opinion, should be done for the trafficker. But it's... I'm an anthropologist, and I know the legal categories and so on are important, but we are considered these categories as are not social creation. They are a lot ethnocentric, Eurocentric. I'm not so sure that can be easily accepted by a different perspective. And I'm not so sure that can be so taken for granted. What I've seen has been done is they are exploited. I have all my interest in being considering a vulnerable person. Although if I'm not a vulnerable person, but this can affect also the position, the status of other vulnerable persons. So in terms of how we can invest or spend the resources, I think we should go back to what Emanuela says, who is vulnerable and why?
But this is what you said in your discourse, multidimensional construct. So I put it this because I did like it. Just coming to Emanuela, well, finally she evidenced the failure in monitoring and supervision, because her training relates to monitoring and supervision. So we have some rules, but we are unable to enforce them for a variety of reasons. And this is Dr. Esa Balasai said, for instance, in COVID situation, in quarantine, when you separate, you need to separate. One is infected, another is not. But how do we follow this up? And you say, okay, we need preparation, but we are unable to prepare very often. And just like COVID situation shows you that we are unable, because it just happened, and we need to deal with this. We can continue, guys, this discussion, because it just leaves us only half an hour break. I hope that you would be able to come for a little bit, at least this afternoon, if you can manage. So we will start at 2. We will start at we will be looking at still in interdisciplinary perspective. There would be another element that I introduced, which is our Jean Monnet platform, which finally is about people who are doing different research, but we can still, in the area of migration, but we can still collaborate, and how. And also I will put specific attention on certain forms of disability. I just wanted to prepare the paper for this conference because there are very few that want to consider the elderly in migration. And I think that the very important point, because many years ago I was teaching labor law in the UK, and a very important point would be an access to benefits for the elderly migrants, those who are, for instance, that they are not yet registered. Well, they are registered, but they don't have any status, and so on. So how they survive, and what and who should do something for them. Anyway, this is a question for discussion. We will start at 2 p.m. Okay? Thank you very much. I think that it was very vibrant and interesting discussion, and we had lovely papers. And yes, and we will start at 2 p.m. Okay? So thank you ever so much, and see you in half an hour. Thank you.
See you later.
See you. Thank you. I just don't know how I cannot postpone this. I have to just leave this. I would prefer to postpone this, but anyway. So anyway, see you at 2. I hope that I will find a way. Sì, mi sembra che sono. Grazie, gentilissimo. Perché, grazie, grazie. Sì, penso che adesso si è sistemato, no? Sì, bravo, bravo, allora tutto a posto. Solo che non lo so se mi sente, ma mi chiede sempre avvia riunione, non devo avviare niente? Ah, non devo fare niente. Ok. Ok, grazie, grazie. Mi sentite?
Sì, professoressa, guardi, è tutto a posto, glielo confermo io.
Ah, grazie, no, perché non ci riuscivo a entrare nella riunione, allora ho chiamato a 50 persone.
Non si preoccupi, tutto a posto.
So thank you very much. Shall we just wait 2 seconds? Maybe some other people will join, because this is a very important subject, important very important issue. So maybe we should wait. I also have Professor Jones who is going to answer the questions, but I don't know where Benedetta is. So I sent her a message. I hope she would get back to us. But anyway, you know that this is on. It's going to stay on YouTube. So if you want to come back to certain parts of this conference, you will be able for some time from now. Right. So let me first start the second half. So the first half was quite general, different approaches to vulnerability, different context, interdisciplinary approach outside of Europe, some needs that we need, and obviously a very important issue that Federica Belassai, I think that you should understand how important you are in our context, because we want to know about practical implications of things that we are doing and we are considering. I see also Marco Giardino. Thank you very much for joining us. I hope that this would be, thank you very much for accepting this invitation, because I will just say a few words about what we are going to have today. So have this afternoon. So first of all, we are trying to address different sections or different categories of vulnerability. So this is, just to give you a little flavor how different categories are protected, are not protected, or what issues we might have whether when considering one category or another. And I thank you very much, Marco Giardini, because I know that he's not a lawyer, but we exactly want to approach those groups from very different perspectives. So it's all very relevant for us. And we have our Dottoressa Favalli, that we thank her so much. She's a very powerful researcher in our university, and she deals with disability as a very important group coming with the definition of vulnerability, well defined. Well, we said that there are many groups which are not defined, but this one is really well defined. So
thank you, Professor. You are so kind in this presentation.
No, absolutely. I think that this is a very important. I think that it's very important also that you wanted to deal with this issue, because disability as such has been considered in many issues. Myself, I have done a project for the EU on disability, but from labor law perspective. And your approach to disability in, that is considering people on move is important and not so well covered in the literature in general. Well, one thing, we can find something, but comparing to children, well, the subject is much less covered. So, our Dottoressa Favalli is going to consider, is from our university, and she's going to consider disability in migration, and exactly this disability in migration is less covered than disability as a general concept or a general concept in the EU. And she's focusing on asylum seekers with disability and EU legal framework. So something also that might be interesting for Professor Jones, who deals with really refugees, so to a certain extent also asylum seekers, because before they become refugees, they are asylum seekers. So yes, so the floor is yours.
Thank you. Can I share my presentation?
Yes, but you share, I think that you can easily, yes.
Okay, can you see it?
Yes, 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 yes. Maybe you need to put from the beginning. Right, yes.
Okay, okay. Thank you very much. So, thank you very much, Professor, for inviting me. As you anticipated, today I will address the intersection between disability and migration, and I will focus on the situation of asylum seekers with disabilities in the EU legal framework. For this purpose, I will first of all try to set the scene very briefly, I promise, providing a definition of disability and the importance of addressing the intersection between disability and migration. I will then try to address the international and European legal framework, which is relevant for this topic. And finally, I will focus on asylum seekers with disabilities in the EU legal framework. Just to introduce the presentation, it's when we speak about the protection of the fundamental rights of persons with disabilities, the first main topic refers to the definition of disability. As through time, the understanding of disability, the conceptualization of disability per se, changed drastically. And accordingly, it changed also the political and the legal framework, the political attitude and the legal framework related to disability. In the past, it was widespread the so-called medical model of disability. According to this understanding of disability, disability was considered an individual condition, and it was referred to basically a health situation and to a sort of individual tragedy. According to the medical model of disability, the policy intervention were mainly paternalistic, and persons with disabilities were not really considered as active citizens and was not involved in decision-making processes. This situation changed through times with the affirmation at the global level of the so-called social model of disability, according to which disability is a social construct. So, what hinder the participation in society of persons with disability are the external barriers, which might be cultural, social, and of course environmental barriers as well. According to this social model, so also legal and policy interventions gradually change at the international, European, and of course national levels. With the gradual affirmation of the social model of disabilities, we arrived to also in the affirmation of the recognition of the human rights of persons with disabilities, in particular with the conclusion in 2006, so a few years ago, if you think about that, of the United Nations Convention on the Rights of Persons with Disabilities, that in Article 1 provides a sort of definition, very wide definition of disability, according to which disability is the interaction between the impairment of the person and the various barriers which may hinder the full and effective participation in society of the person. As you can see, this is a very wide definition. It has been defined in legal doctrine, a non-definition or an open definition, as it can encompasses the situation, very different situations. After this very brief clarification, we can notice that in the last decade at the international level, the affirmation of the need to address the peculiar situation of persons with disabilities is nowadays well affirmed. However, it is not historically the need to address the peculiar situation of persons with disabilities in the context of migration. We can notice that globally, both the situation of persons with disabilities and the situation of migrants are considered vulnerable situations. For instance, also in the 2030 Agenda for Sustainable Development, just one of example, adopted in 2015, we have different mentions of the situation of persons with disabilities, refugees, internationally displaced persons as vulnerable situation. However, we have not any mention of the intersection between disability and migration as well. However, this situation is gradually changing at the international level. In particular, we can find it in the most recent soft law measures adopted by the United Nations. We can find a specific reference to the peculiar situation of persons with disabilities in the context of migration, for instance, in the 2006 New York Declaration for Refugees and Migration, and again, in the two Global Compact on Refugees and on Migration, adopted in 2018 and 2019. And finally, also in 2020, it has been published an interesting report referring to a very specific topic, which is persons with disabilities in the context of internal displacement. When now focusing on a bit more on the legal framework, and so going deeply into technicalities, when we speak about persons with disabilities and the protection of the fundamental rights of persons with disabilities, the legal benchmark, our point of reference, is always the United Nations Convention on the Rights of Persons with Disabilities. In fairness, this convention does not provide any explicit reference to migrants with disabilities or refugees with disabilities or asylum seekers with disabilities as well, of course. Anyway, this convention requires the states parties to mainstream the rights of persons with disabilities in all their policies and programs, including so also migration and asylum policies. So it does not refer to migrants with disabilities, but it could be inferred from its provisions that the rights of persons with disability might be mainstreamed also in migration and asylum policies. With peculiar reference, as I mentioned before, I will focus in particular on the situation of asylum seekers with disability in the EU legal framework. And to prepare the floor for the focus of my presentation, I will refer to some of the provision of the Convention on the Rights of Persons with Disabilities, which could be considered relevant for the situation of asylum seekers. The first one is Article 11 CRPD, which refers more generally to the situation of risk and humanitarian emergency. Of course, this article does not mention the situation of refugee or migrants or asylum seekers with disabilities, but anyway is relevant as it requires state parties to take all necessary measures to ensure the protection and safety of persons with disability in situation of risk. Which might, of course, include also the situation of refugee and asylum seekers. In addition, Article 15 of the Convention is also relevant as it protects from torture, cruel, inhuman, degrading treatment. Article 16 refers to the protection of people with disabilities from all forms of exploitation, violence, and abuse. Article 18 refers to the liberty of movement, freedom to choose their residence, and the right to have a nationality of persons with disabilities. And finally, I would like to mention also Article 31 of the CRPD, which is very peculiar of this convention, has required state parties to collect appropriate information, including statistical and research data, referring to persons with disabilities. As one of the main problems referring to the protection of persons with disability is the lack of data referring to these individuals, which render impossible to adopt adequate policy intervention. And this lack of data, as we will see, is dramatic, in particular also in the European context with reference to asylum seekers with disabilities. Going deeply into the EU legal framework, first of all, we can find again the United Nations Convention on the Rights of Persons with Disabilities, which is applicable as the European Union, along with all its member states, ratified the convention in 2010. And as an effect, the convention is an integral part of EU law, meaning that all the provisions of EU law must be interpreted in compliance with the convention, which once again is a legal benchmark for the protection of persons with disabilities. And other relevant provision refers in general to the protection of persons with disabilities are in the Charter of Fundamental Rights of the European Union, which at Article 21 and 26 sets forth the prohibition of discrimination on the ground of disability and the right of persons with disabilities to benefit from measures designed to ensure independence, integration, and participation in the life of the community. But to find provisions which refers in particular to the situation of asylum system, asylum application, we have to deal with secondary legislation and in particular common European asylum system. We can find express reference to the situation of asylum seekers with disabilities in different provisions of the Qualification Directive, the Asylum Procedure Directive, the Reception Condition Directive, and the Dublin Third Regulation, which are actually in force. I will now try to very briefly analyze in detail all these provisions and try to understand if these provisions are in compliance with the Convention on the Rights of Persons with Disabilities. Starting with the Qualification Directive, this directive lays down the standards for the qualification of third country national or stateless persons as refugees or persons eligible for subsidiary protection. This directive must recognize the vulnerability of asylum seekers with disabilities, and we can infer this recognition from different provisions. First of all, from Article 20 of the Qualification Directive, according to which member states shall take into account specific situation of different vulnerable persons which are listed, and in this list we can find also reference to disabled people and persons with mental disorder as well. In addition, in Article 30, which refers in particular to the provision of healthcare, member states are required to provide adequate healthcare, including treatment of mental disorders, to beneficiaries of international protection who are in special needs, which is another expression which is used also as vulnerability, as this includes these subjects, these individuals who have special needs, include also disabled people. On the whole, so we can notice that there is a recognition of the situation of vulnerability of asylum seekers with disabilities, even though some scholars contended that the language used might be considered a bit, can be a bit criticized, as it seems to be underpinned a bit more to the medical model of disability than to the social model, as persons with disabilities are considered basically for their health conditions. However, that's positive that we can find as well the recognition of the vulnerability of asylum seekers. Then the Asylum Procedure Directive is a directive that establishes common standards for asylum procedures. According to Article 14 of this directive, every applicant should be given the opportunity of a personal interview when considering their application, their asylum application claim. And what is interesting for the topic at stake is that there is no mention, explicit mention of the fact that the interview might be accessible for persons with disabilities, or that reasonable accommodation might be provided to render accessible to persons with disabilities the interview. However, this obligation can be anyway inferred from various provisions. I could make an example. If you can think about a person with disability, for instance, a person with an hearing impairment, you can also imagine that you have to provide sign language interpreted as well to provide effectively an accessible interview. Of course, this is not mentioned in the Asylum Procedure Directive. However, it can be inferred from Recital 29, according to which certain applicants may be in need of special procedural guarantees due to inter alia disability and mental disorders, or Article 12, according to which asylum seekers should be informed in a language which they understand or are reasonably supposed to understand. This duty of information is very important. You can think from this provision, according to legal scholar, for instance, Ferry, we can infer for instance, the obligation to provide this information also in easy to read version, in an easy to read version for person with a mental disability, for instance. Article 15 requires that member state ensure that the person who conducts the interview is competent, is able to take into account the vulnerability of persons, including disability as well, of course. And finally, Article 24 requires that member state assess within a reasonable period of time after an application whether the applicant is in need of special procedural guarantees. The Reception Conditions Directive as well provides some interesting provisions. The Reception Condition Directive more specifically lays down harmonized standards for reception condition for asylum seekers while they wait for the examination of their claim. First of all, in Article 21 of this directive, member states should take into account the specific situation of vulnerable persons, such as disabled persons or persons with mental disorder. So we have again the recognition of disability as a vulnerable situation that member states should carefully consider. In Article 22, we have that member states should assess whether the applicant is with special reception needs, and Article 17 provides that in the case the vulnerable person is detained, member states shall ensure regular monitoring and adequate support. So, in theory, we have we can say that these provisions, this directive, take into careful account of the situation of asylum seekers with disabilities as vulnerable persons. However, implementation is something different. As noted by for instance, FRA, the European Union Agency for Fundamental Rights, in 2016, implementation at the member state level tend to be grossly deficient. One of the main problems, which has been noted, is that there is not a common procedure to detect, to identify asylum seekers with disabilities. So there is a lack of harmonization between member states. We have mostly anecdotal evidence. We have not reliable data on that as well, which is another major problem to tackle with the situation of asylum seekers with disabilities. And so, in addition, as mentioned before, also in other presentation, another problem which has been detected in this report is that in reception centers, the staff in general is not trained to deal with peculiar situation of persons with disabilities. The main problem refers to persons with mental disabilities. The staff is not trained for that particular situation, which, as you imagine, is very delicate. And I would add, is not so uncommon as as mentioned before, disability is often acquired during the travel, the journey, or in the reception in detention center, as well as and is caused by the trauma or the injuries during the migration process as well. Finally, I would like to address very briefly the Dublin III regulation, which determines which EU member state is responsible for examining individual asylum application. We can find a reference to asylum seekers with disabilities, again, with reference to the personal interview which might be conducted. And here, again, like in the Asylum Procedure Directive, we have that the applicant might be, the personal interview might be in a language that the applicant understands or is reasonably supposed to understand, and which he or she is able to communicate, so that from this obligation we can infer also the obligation to provide an accommodation, a reasonable accommodation to also for persons with disabilities. Finally, according to Article 16, refers to the situation of applicant which is dependent from a relative, basically. And in this case, the regulation refers to applicants with a severe disability. Which is peculiar here is that we have not a definition of the severe disability, nor in the regulation or in other part, in other provision of EU law. So that this term is very vague and wide, and again, we have not a possibility to an harmonized application of this regulation. And I would like to end my presentation with a bit of hope. And in particular, a few days ago, 2 weeks ago, has been adopted the strategy for the rights of persons with disabilities, which will determine the EU policy referring to disability for the next decade, 2021-2030. And in the strategy, we can find express mention also of the situation of asylum seekers with disabilities, where the Commission recommends to member states to take into account the specific needs of vulnerable applicants and beneficiaries of international protection, and recommends also to facilitate the training of protection officers and interpreters dealing with asylum claims. And I thank you for your attention, and I will stop my share screen. Thank you very much.
Thank you very much, Silvia. Thank you very much for this really thorough talk. I have many issues, but I would like to tell you that I would use your slides when I come in my program to talk about the SIA system, because you're so thorough. So it's really a good explanation. So we will have some questions to, well, there are 3 issues. And I have to say, so we will have some questions for Silvia. Then we have Professor Jones, who came back. So we are very happy that he would answer the questions from this morning, because I stopped him from answering for the reason that I was afraid that we will not manage to put everybody. And just a little bit, I have my students, who is my new student, because we have hardly started teaching, and she was so kind, you know, just, and she wanted to prepare something on disability because she worked and NGOs and so on. So I hope that she wouldn't mind to wait after the question. Okay, so she says that she's okay. So the questions for Dr. Favalli. I don't know why you just because finally it ends up that only me who is talking. So I don't know if they are too shy or I don't wait enough. Martin, what do you think? Do you think that I don't wait enough for questions?
Well, no, I think you're waiting fine. I think people maybe are a bit shy, but I have a question actually.
Okay, yes, Martin, so your question.
No, I thank you very much. I mean, I apologize for missing one of the presentations this morning. I had to pop out and teach. But I mean, thank you very much for such a comprehensive kind of review of the legal frameworks and issues raised by the issue of disability, which, as I think both you and Katarzyna have pointed out, kind of has only recently drawn policy and legal attention. I guess I wanted to ask a question from outside of it, well, from both literally and metaphorically outside the EU. And you've given a good sense of where the EU is and where it needs to go in terms of disability. When you look around elsewhere, where do you see hope and where do you see better practice? And I ask this because, I mean, one of the issues obviously UNHCR struggles with, and that the legal aid NGOs with which I work, is this issue, often in contexts where there's widespread adherence, as you point out, to the Convention on the Rights of Persons with Disability. I mean, it's one of the most quickly taken up international treaties in recent years. I mean, in stark contrast to the Migrant Workers Convention, for example. But there's really a real problem, not just by refugees, obviously, but even by kind of the so-called locals in terms of accessing their rights. So where can I look, if not to the EU, for inspiration in terms of adopting more persons with disability friendly policies and practices to advocate to UNHCR for?
The disability organization in general are very powerful and are also very, I don't know if the word aggressive is appropriate, but they fight a lot. And in general, the so quick affirmation of the rights of persons with disabilities is due to this great advocacy work of these organizations. And I think that that's very important, the lobbying work of this organization at all levels. And what is interesting is that it started at the international level, so at the level of the UN. So I think that at the international level, we have a lot of this. It started from the United Nations, and then as a spillover effect, it went to the regional context, in particular the EU, but also in the African and in the American context as well, but that's another topic, and then gradually at national level. So sometimes maybe I think that we can find more the regional and international level, which are keen to mainstream disability in their policies, than the national level or the local level, as well, because it's also sometimes a cultural problem, which is very now very, very important as well. And I don't know if really I answer your question, to be honest, but I think that the real power here, the real secret is to involve disability persons organization, DPOs, and persons with disability as well, as without the active participation is impossible to meet really the requirements, to imagine as well the requirements of persons with disabilities. And DPOs are really good, are really aggressive, really fightful in that.
Yes, any other question on, I know that Sylvia needs to go, but maybe not straight away, because I have some, but let's see the audience. Any other question?
I think that will all the citing all the article and the provision, I scared all people.
No, you didn't. So I'm not going to ask the question because I'm a little bit maybe late on my schedule. So I just wanted to, well, I had many points. For instance, the issue of no data, no coordination between countries. So this is a very important issue. And well, something that I'm adding, but I'm sure that you wanted, it was incorporated in your talk. Not exchange of practices. So what I mean here, that for instance, we deal with them in this way. So maybe it's a lesson to learn, or maybe somebody else can give us a better example. So this is training lacking. So still with this failing in monitoring and supervision. Then I would add, you did say this, first of all, of detecting mental disability, and then entire process, so detecting mental disability, but then how do we deal with this? Do we have the specialists? Do we have the trained people to deal with this and to continue with this? And then your suggestion about providing, define disability on 2 levels, severe disability and I believe normal disability. Is that right, Silvia?
Oh, yes, and I forget to mention, but another major problem refers to the fact that often asylum seekers try to hide their disability condition. Sometimes disability can be invisible, and because they fear that this will have a negative impact of the asylum claim.
That's a very important point. Silvia, if you stay with us for a little bit, now I give the floor to Martin. No, it should be, did you address the Benedetta question?
Oh, I can do that quickly if you want. As I recall, the question was one about whether or not UNHCR's approach to vulnerability risks creating hierarchies within refugee populations. And the short answer is absolutely. I mean, we already, as we all know, have this kind of good versus bad refugee that's framed both in popular discourse, but also in legal frameworks, whether it's the resettled refugee who's waited in line in the, so to speak, line versus the spontaneous asylum seeker, but also, you know, the political, the acceptable political refugee versus the unacceptable political refugee. The bigger, so there's a hierarchy in access to services, different categories, and troublingly, these often reinforce existing hierarchies. So the vulnerable refugee is the Christian refugee, the Christian Chin refugee in Malaysia, as opposed to the Muslim Rohingya refugee, because coincidentally, resettlement countries would much rather have Christian refugees than Muslim refugees, even if, you know, both are at significant risk in Malaysia. So it reinforces it. Beyond that, it can actually encourage the performance of vulnerability. So you can have individuals separating from family members to be identified as a woman at risk. You can have, again, drawing on the Malaysia example, you can have women getting pregnant in order to qualify for being a vulnerable individual and therefore get registered and hopefully resettled. You can have individuals basically create and certainly perform vulnerability in a way that is dangerous. So it both reinforces existing hierarchies as well as actually produces vulnerability in order to allow refugees access to services and benefits that they need. Yeah.
Thank you so much. You were not here, but it was Valentina who raised this issue as well, that as producing new, that the process itself produces new vulnerability. Thank you, Martin. You are, thank you very much. Thank you for coming back well with us and for answering this question. Now, we were trying to incorporate everybody in this conference, and I'm terribly grateful for my students. Is she here? Because I can't see her. Ginevra, yes, she was.
Yeah, I am.
That she agreed, but not only. I was very bossy, because when I'm stressed, I'm bossy. So I do apologize, Ginevra. I hope that I haven't frightened you, but well, because just thank you very much, and I understand that it is not such an easy task at the beginning of your career, whatever career is going to be. So Ginevra is going to talk about reception conditions. So finally, that it falls within our directive on the reception conditions and disability. Why she is doing so? Because she was working with the NGOs in France, and she didn't have only disabled people, but she came across some disability in her career, if we can say, because your young age says that it can't be very long-lasting career, but anyway, for your experience. So the floor is yours.
Thank you very much, and thank you for inviting me and participating in this seminar. And I would also like to add that myself, I do have a disability, which is the reason why I did start being very interested in this topic. Anyways, without further ado, I'm gonna share the screen. Okay, can you see it?
Yes.
Okay, perfect. Okay, so as I was saying, today I will give a brief overview of the reception conditions for migrants with disabilities in Europe. So first and foremost, I am going to give some data, and I'm going to start by saying that 15% of world's population lives with disabilities. A very high number of people, or at least a significant number of people, of these people with disabilities are migrants. However, only little information is available about them. This is the point I would love to stress, exactly because as a result, or better, as a byproduct of the lack of information concerning migrants with disabilities, there is a process of invisibilization which has been put in place. By invisibilization, what I mean is that, in fact, migrants themselves are not properly identified. And by not being properly identified, invisibility makes it difficult to plan for appropriate support measures, and eventually, obviously, becomes an obstacle for their full and effective participation in society. For this reason, I would like to stress that migrants, and especially migrants with disabilities, are subject to multiple axes of oppression. And in saying so, invisibilization through the lack of data and specific effective policies towards them are but yet another layer of oppression that do correspond to the other overlapping axes that correspond to the disability in itself and their condition as migrants. However, when I do speak about disability, I do want to briefly point out to the fact that it is not the disability itself which disables these subjects in our society. It's rather the discrimination and the inaccessible environments which are the byproduct, again, of that invisibilization, which causes for them to be actually disabled in our society. So one important thing that I like to point out is that the lack of data concerning migrants with disabilities, that vulnerabilizes this subject, and hence in order to provide a politically effective response to the current condition and migration scenario, both in Europe as a whole and in the different states within Europe, we do need to have a better understanding of the causes of migration, but also, and most importantly, approach the issue of migration and especially migration and disability through the lenses of intersectionality. So giving some data reports about the European reception conditions for migrants with disabilities. Obviously, I'm not going to give such a great overview as the one that Professor Favalli gave us, but just a brief overview. We have the European Directive of 2003, which has been followed by Directive 2013-33, and eventually European Parliament resolution of the 7th of July 2016. Now, while the European Directive of 2003 gave to the national legislation the role of providing specific material reception conditions for vulnerable people, while also recognizing that disabled as part of these vulnerable groups, the Article 21 of Directive 2013 recognized both refugees with disability as vulnerable groups and also asked for a series of standards for reception of asylum seekers. Now, while looking at European Parliament resolution of the 7th July 2016, we do look at Article 58 when it says that vulnerable members of society are further marginalized if they have a disability. And I would like for you to keep this well in mind, because I will come back to this in a moment. Also, this resolution does ask to European institutions and member states to increase and double their efforts in accommodating the provision of the people with disabilities. However, in doing so, it does by asking it individually. So putting the pressure of taking care of the reception conditions for migrants on the single states. And one problem that has been highly pointed out in the literature of the European Union, especially with concerns to migration, is that this led to an uneven application of the law, which eventually also has been coupled by the lack of cooperation in between the different systems, which obviously does but make it even more difficult for the people with disabilities to get their rights be recognized, even more if migrants. As I said before, it was good to remember that the people with disabilities as for the European Parliament resolution of 2016, are recognized as even more marginalized because of their condition of disability. This is but linked with a medical approach, which is a kind of outdated approach to disability. Why am I saying this? Because even with the new Pact on Migration and Asylum of 2020, which also uses a language which reflects this medical approach to disability, once again proves to be a missed opportunity to actually tackle the needs and rights for people with disabilities. And the reason is that, as I said before, disability itself isn't a condition which prevents from people to enjoy life in society, but rather it becomes so when there are discriminatory and inaccessible environments that do block them from fully and effective participating in society. Another reason why the new Pact on Migration did fail to miss also the provision of the EU Disability Rights Strategy from 2021 and 2030 is also that it seems that health and vulnerability assessment are going to be done by third countries, which means that eventually there are going to be pre-entry screening processes, which are but going to put even more burden on the disabled people themselves, because as Professor Favalli was saying before as well, unfortunately, disability is also a cultural issue. And in some countries, it is not that easy to be recognized as disability as such. Also, it failed to respond to the CRPD committee's recommendations and key demands for the disability movement, including, and here, once again, I underline this, the collection of data concerning asylum seekers and migrants with disabilities. So when looking at Italy, I want to give some data. So as for the projects for asylum policies and services financed by National Fund for Vulnerable People, we have 52 projects against the 681 projects for ordinary categories. All of this to say that only 734 are specialized reception centers for vulnerable refugees against over 2,000 migrants recognized to having disabilities on the territories, of which only 2.3% with mental disorders, which is once again another kind of disability, have adequate assistance. And this is a very important point to stress, because eventually Italy as well did miss an opportunity to protect migrants with disabilities, and most importantly, to meet their needs and to protect and support their human rights. This is also due to a lack of appropriate mapping, lack of monitoring of the number of migrants with disabilities on the territory, lack of understanding how many different disabilities affect the population with disabilities within the migrant population in Italy, because again, we need to think of diversification, and so diversity. So obviously there is not just one size fits all when we talk about disability, and also a lack of special reception centers. All of this resulting in people with special needs, including torture victims, to often be accommodated in general reception centers or even forced to live in the streets or in squats. And regarding to this, I'd like to point out to one experience I had during my work in France. So I was responsible for the integration project supporting the social and human rights and cultural rights of asylum seekers and refugees in distress in the region of Loire-Atlantique, and specifically Nantes. And sorry?
No, it just,
okay.
Somebody mute the...
Sorry.
It's all right.
It's a...
It's all right. So yeah, as I was saying, the problem is that this one thing stuck in my head, and it's this time whether I was with this person. Obviously, I'm not going to disclose his identity. He was 24 and he did have all of the different symptoms which looked like being multiple sclerosis, which is an invisible chronic disease. However, because he was not being properly identified, and so the state did not know that he did have a disability, he was forced to live in between squats and the streets, which eventually was just worsening his condition day by day. So what do we need to remember is that here we're not talking about just numbers, but we're talking about people. But to really manage to meet the needs of these people, first and foremost, we need to address the data challenge. So one solution has been provided by the AMID project, so access to services for migrants with disabilities, which provided through an NAT questionnaire, which was given to different NGOs and on-place actors, which were working with people with migrants with disabilities, the possibility of creating a local, then regional, and then national database, which was based in Italy. And after 2016 meetings in Brussels, is now right now expanding its project to other European countries, with the eventual objective to create a European database on migrants with disabilities. As I said, this is fundamental because in the end of the day, what we need to do is to use this database to create strategic coordination plans between countries to provide assistance and protections with migrants with disabilities. Another really important issue is to create a standardized identification procedures for the whole perimeter of Europe. Also, provide durable solutions for migrants with disabilities so that they can be actually inserted by the host countries in different protection systems, but also create an information system that is able to register and identify the needs of the different and specific disabilities of the individuals in the territory, which can allow for us to design specific and ad hoc public policies aimed truly at protecting migrants with disabilities. However, and here I conclude, my most important point is that, unfortunately, in policies, we often forget that the policies we make for people need to take those very people who are invested by these laws in account. So until we will incorporate the participation of the migrant population with disability in policy decision-making places, I know, and unfortunately I need to state this, we will never be able to fully meet their needs and actually create effective policies that will not invisibilize and vulnerabilize these people, but will actually empower them and allow for them to truly live their life and effectively participating in society. Thank you. I hope this was interesting for you and that sparkled somehow some interesting or critical perspective on this issue. And I'm going to interrupt the sharing for now.
Ginevra, I'm impressed. So I was so bossy, but I'm impressed, I should say, because, you know, just like I was just sort of putting on her certain pressure, but I'm really impressed. Very quick question. I have many comments, but I can do it at any time. So because we are 15 minutes late and we have some time constraints because we have somebody from SPRA that has a doctor appointment and so on afterwards. So any very quick question? Anybody? No?
If I can just intervene,
Yes,
I would like to make my congratulations for this really interesting presentation. I really enjoy it, and also for your work on the field, if I correctly understood, and your interest. So that's just my very positive feedback.
Thank you very much.
If she can stay, maybe we can come back to this, because at this time, I'm just a little bit concerned about time that people who, well, they teach, they do something different, so I can't really delay. But if you stay, we can come back and have a longer discussion, because the topic really deserves a longer discussion. Right. So, Simone, where is Simone? Simon. Simone.
Yeah.
Right. So here there is another opportunity, which what I wanted to tell you, that different groups were incorporated into this conference. I would like really to say that thank you very much for this really good response, because one of the why, because what I was trying to do, so we are holders of the grant, European Commission grant, Jean Monnet grant, in different sections, module, chair, and so on. And this is an opportunity to know each other better and to establish a platform which could be a very different one. So I completely understand that we have different areas, and nobody, well, and so that's why it's absolutely not expected that you provide a legal analysis, legal analysis, and that but you approach the topic from your perspective, from the perspective of maybe your ground and or something that is well, similar, because obviously we were awarded in different groups for different projects and so on. So I'm really, again, I thank you so much for this, for various reasons. Exactly this positive approach, and the positive approach that I should say that being at, well, taught for many years at York exactly had very, very positive approach and respect for somebody else's work. So they were always enthusiastic. When they couldn't, they were always sending, yeah, but I can come for 15 minutes because I'm teaching or something. I think that this sort of very positive attitude I would like some sort of share with you, because you know, just sometimes we work hard, and it's important that is well received, and exactly so. I thank so much, Simone. Simone is from Pisa, am I right? Yes. And Simone is historian, also was awarded Jean Monnet, and he is exactly from this platform. So I have contacted maybe 12 or 13 people, and finally here we are 3. So I really should thank to those people. I understand they have different focus, different project, but for being together and trying to work together, it's very important. However, the event lasts all day, so everybody could come for just a little bit, and this is Thank you so much. So we are going to consider another little category of vulnerable groups. The very important one, they are children. So Simone is going to talk about migration and the child's best interest, all and new experiences in Europe. So thank you, Simone, for being with us, and thank you for your positive attitude, and the floor is yours.
Okay, thank you, Katarzyna. Thank you to you. It's an honor and a pleasure for me to be here, and it's a great opportunity also to know you and to know the colleagues of mine, even if, as you said, we come from very different disciplines and we use a plurality of approaches and methodologies. The paper that I'm going to present is based indeed on a larger project, which culminated in an international conference held in 2017 at the University of Padua, titled Children on the Move from the 20th to the 21st Century, a Biopolitics Perspective. And 3 years later, in a collective volume titled Child Migration and Biopolitics, Old and New Experiences in Europe, recently published by Routledge. Credited with the professor in European history at the Dublin City University, Beatrice Scutaro, this book brought together contributions from 12 scholars representing a wide range of disciplines: ethnography, history, law, political science, ecology, sociology, and social work. Focusing on the 20th and 21st centuries, the volume covered a wide geographical area within Europe, both West, Belgium, France, Germany, and East, Romania, Russia, Ukraine, South, Italy, Portugal, and Turkey, and North, Sweden. The aim was to gain a better grasp not only of the evolution of child migration, but also of the forces that shape children's lives and social experience. On the basis of this research, in the short time at my disposal, I will give you an account of the concept of child's best interest and the main contradictions and challenges facing its application in the entire post-war period. This issue will be examined through the lens of migrant children. Migration enables to better apprehend how the formulation of children's interest evolved over time and space. Migration, moreover, helps to better perceive that not all children were and are treated equally. Ideology, religion, gender, and class have historically influenced who and how is to be protected. Migration finally enables to better understand how children's best interest can at times conflict with other considerations and values. As an historian, I will follow a chronological order. It is well known that the World War II strongly affected children in all European countries involved. Many were killed, injured, displaced, or interned in concentration camps. Some were even victims of medical experiments. Many witnessed bombing raids and firestorms, or played an active role in conflicts. Suffering continued even after the war had ended. In the aftermath of the conflict, children were those that most suffered from diseases and deprivation. A significant number of them found themselves orphaned by one or both parents. Against this backdrop, unsurprisingly, involvement in child rearing reached unprecedented levels, giving a great level of autonomy and the poor conditions experienced by many children. There was increasing concern about the rise of juvenile delinquency. There was therefore the urgent need to provide care to all the children forced into vagrancy. Meanwhile, given the destruction caused by the war, children were seen as Europe's best hope of recovering and prospering. This, however, does not mean that treatment was equal for all. As a proof of this, despite its philanthropic mandate, the United Nations Relief and Rehabilitation Administration selected beneficiaries in displaced persons camps on the basis of strict eligibility criteria, which excluded displaced adults and children who did not belong to a United Nations member state. UNRWA, accordingly, did not provide humanitarian aid to German children. They were outside its scope. They were the children of the enemy. At the same time that the interests of German children were deliberately ignored, the interest of another category of children became a bone of contention between the United Nations agencies and Jewish organizations. We are talking about the Hebrew children. With an aim to stabilize Europe, UN agencies identified the unification of families and the renationalization through repatriation as pillars of the best interest of the child. In order to take back their children, on the other hand, local and international Jewish organizations reclaimed Jewish displaced minors, at the same time as the Jewish Agencies for Israel promoted programs for resettling young Jewish survivors to Palestine. The best interest of the Jewish children, according to these organizations, was the rehabilitation of little Holocaust survivors with a view to Aliyah Bet and the establishment of a Jewish state in Eretz Israel. The outbreak of the Cold War showed that the definition of child's best interest can change if geopolitical and biopolitical considerations change. In the post-war period, as said before, UNRWA declared that its intention was to repatriate displaced children to their home countries and natural parents. This was in line with its conception of European stabilization and its idea of the best interest of the child. Accordingly, it accepted to return children from Western Ukraine and Baltic republics to the Soviet Union, which had annexed those territories in the late 30s and mid-40s, respectively. With tensions escalating between the United States and the Soviet Union, however, US and UK military authorities, together with welfare workers from UNRWA and the International Refugee Organization, questioned repatriating Ukrainian and Baltic children to the Soviet Union and discussed resettlement as an alternative. The best interest of the child was then reformulated in order to legitimize the new politically motivated approach. Colonialism and subsequent decolonization also influenced attitudes towards children and perceptions of their best interest. It became again clear by the definition of the best interest of the child when it was inextricable from political and ideological considerations. On the one hand, colonialism and later decolonization created a new kind of war. Mixed-race children were often sent to former colonial powers after the colonies had gained independence. Eurasian children born to French soldiers and Indo-Chinese women and children born in Algeria during French occupation were taken into care between the mid-50s and early 60s in France for humanitarian reasons. This decision, however, was also taken for political motives, as the French authorities were aware of the demographic potential and the interest in controlling these children. On the other hand, colonialism and later decolonization triggered third-worldist sentiments, which in turn raised awareness of children problems in developing countries and popularized the practice of inter-country and inter-ethnic adoption. This practice was usually justified on the grounds of the child's best interest. However, as clearly shown by the activities of the prominent Belgian adoption agency, Joyce Sowers, and its founder, Father Eugene René Deleuze, from the early 70s to the mid-80s, the definition of the best interest was strongly influenced by the ideology and stereotypes of adoption agencies and their leaders. Joyce Sowers and Father Deleuze decided who was the best suited to be adopted in India and identified the ideal Belgian parents for children in need of being saved. They constructed a specific parenting figure influenced by religious, colonial, and gender cliches and allowed only the parents who responded to their criteria to adopt. In the context of post-colonialism, they saw displacement of children from the south to the north, not only as a way to serve the children's interest, but also as a reparation for colonial oppression and a vehicle for the establishment of a transracial and transcultural world. Meanwhile, children's situations improved in most European countries, especially in the western part of the continent. While damaged economies recovered and grew at fast rates, the socioeconomic conditions of most families consequently got much better Against this background, children started going to school longer, and most of them stopped working. Infant mortality fell sharply, and people started having fewer children in virtually all countries in Europe. Parents started to put their hopes in their children and do their best to offer them the best possible conditions. This was followed by a massive increase in the sentimental value of children in both working and middle-class circles. These changes went hand in hand with the rise in international initiatives and regulations aimed at protecting children. The United Nations Declaration of the Rights of the Child in 1959 called upon governments and civil society to provide all children access to education, healthcare, social protection, and good nutrition. Reform movements in the late 60s and the 70s fought successfully for more and new child rights, and meanwhile, non-governmental organizations dealing with children and promoting their rights and conditions flourish and gain increasing influence. Family reunification schemes were expanded, and migrant children in Western European countries too were given more rights, also thanks to the European Community's initiatives and regulations. This, of course, did not eliminate all problems. In the 80s, in fact, new issues emerged: the change in family structure, the creation of new state control mechanisms over childhood, and the emergence and spread of new forms of poverty raised new challenges to Western Europe. At the same time, economic and social crisis and environmental deterioration in Central and Eastern Europe and the Soviet Union dramatically impacted children's lives and health conditions. The end of the Cold War paved the way to the codification for the first time of the principle of child's best interest. Immediately after the fall of the Berlin Wall in 1989, the United Nations General Assembly adopted the Convention on the Rights of the Child, which was the first children's rights instrument to obligate states to legally comply with its provisions. The Convention addressed the child's well-being and established precise rights, prohibitions, and procedural guidelines. The Convention's fundamental requirement was that, I quote, "In all actions concerning children, the best interest of the child should be a primary consideration," end of quotation. 1 year later, in 1990, the United Nations World Summit for Children took place in New York, its main aim being to improve children's conditions worldwide by 2000. Undoubtedly, this process reflected an increasing concern for children and their rights and coincided with the general improvement of their conditions. Like the aftermath of the Second World War, however, the aftermath of the Cold War took its victims, with children again in the forefront. In Russia and Eastern Europe, the difficult transition from communist to capitalist systems often resulted in a deterioration of children's conditions, or at best, a cosmetic change of old questionable practices. Romania represents a perfect example of this situation. It well illustrates through the potential instrumental use of the principle of child's best interest. During the communist era, constituting the best possible national body was the main reason why the Romanian regime favored displacing children of certain social and ethnic categories considered unfit to raise good citizens and institutionalizing them. The dominant idea was that the state would know how to best re-educate them. After the collapse of the regime, methods partially changed, but the aims remain largely the same. The post-communist state continued to encourage child abandonment, to make significant use of institutionalization, the ultimate aim being, once again, to safeguard the well-being of the Romanian nation and society. In this context, inter-country adoption offered a fraud with risk solution to overcrowded children's homes and an alternative to hopeless segregation, especially for disabled children. Meanwhile, the Yugoslav wars from 1991 to 2001 badly affected children. Conflicts in the Western Balkans were marked by barbarous violence against civilians, especially women and children. Millions of children were killed, suffering from disabilities, or were raped or displaced because of war. Many also did not have proper access to education, healthcare, water, and food supplies, both during and under the conflicts. In the meantime, the European Union acquired an increasingly important role in protecting children's rights. The Charter of Fundamental Rights of the European Union, proclaimed in 2000 and given legal force in 2009, recognized children's rights to education, protection, care, free expression of opinions and ideas, and relations and contacts with parents. It also prohibited child labor. The Charter clearly stated that, I quote, "The child's best interest must be a primary consideration," end of quotation. Significant progress was made in Europe in the 2000s and 2010s. This not least because with the inclusion into the European Union, most former communist countries in Eastern Europe recognized children's rights and freedoms that are, at least on paper, comparable, if not more advanced than those stated in Western Europe. Not everything has been fixed, however. Children's work has not entirely disappeared in Europe. In the continent's poorest areas, children's labor is still an important contribution to the family budget. Moreover, the growing number of refugees and irregular migrants in Europe has resulted in a resurgence or increase in child labor with little or no protection. The case of Afghan and Syrian minors in Turkey is paradigmatic in this sense. At the same time, the difficulty and from complete integration of second and third generations of migrants is not infrequently generating conditions of degradation in states of tension and conflict in which children are sometimes victims and sometimes perpetrators. Meanwhile, the mass arrival of accompanied and unaccompanied migrants and asylum seekers from outside Europe is putting a great strain on European finances, social structures, and education systems. It is also raising growing cultural and political resistance. Despite a sound national and international legal framework for child protection, there is a concrete danger of stigmatization, exclusion, discrimination, and human rights violations for these groups of children. There is a high risk, too, that in the name of children's interest, institutionalization and detention are misused, abused, or overused. This is a nerve which brings into play the inherently ambiguous definition of child's best interest and its complex reconciliation with other considerations and values. So, the European Union encourages member states to minimize the recourse to the detention of minors, and when necessary, to ensure that optimal conditions, there is a serious and well-documented discrepancy between the law and practice. The member states of the European Union are increasingly considering migrant children more as migrants than as children. This increases the chance of using forced custody against them. This practice can expose children to both rights violation and negative stereotyping. Moreover, it was found there is a tendency to use protection against vulnerabilities as a pretext to justify detention powers and legitimize expulsion. Sweden can provide evidence of this phenomenon. Recent studies have shown that protection of accompanied migrant children from disappearance, which is normally presented by Swedish social workers as a way to serve children's rights, is in fact often used as an instrument for facilitating expulsion of illegal migrant children. Even in a country that is widely and correctly considered as fully respectful of migrant children, therefore, the rhetoric of the child's best interest can be functional to the secularization of migration. Social workers and the so-called psychotechnocrats, in turn, can be instrumental in building and legitimizing this political discourse. While children are generally more protecting and everything seems put in place in order to create the best conditions for them to develop, therefore, European politicians and social workers are sometimes unable or unwilling to correctly identify needs and risks or undertake appropriate actions to address all categories of children. I conclude. Children on the Move offer a vantage point for analyzing and interpreting the principle of child's best interest and its application. This historical panoramic examination enables us to see that children have been a central concern for governments and societies, their lives being increasingly controlled by a variety of actors who claim to act in their best interest. That said, the formulation of this concept changed over time and space. Its enforcement was not equal for everyone, and the ideological, geopolitical, socioeconomic, and security considerations were more than often decisive in shaping its contents. What distinguished at our time is the importance of international and non-governmental organizations and the increasingly influential role played by the so-called specialists. Thanks for your attention.
Thank you, Simone. Thank you so much. Tell me how busy you are, because maybe the questions we can put a little bit later, because we quite late and Antonina is waiting. I have just 3 very small comments. So first of all, completely right, the concept of, so finally, going with the concept of best interest has changed over the time, and this we can see in law. For instance, in the law of the Council of Europe addressing the best interest. One of the earlier cases is about Zaire, the girl from Zaire who was separated and sent back, and she was very young, she was 6, and nobody really cared at that time what is in the best interest. Finally, another point, the UN Convention does not really explain what is in the best interest, although by relation with other articles, we can say that, for instance, maybe sending back in social and culture spectrum could be better than retaining this child, for instance, in Europe, but this is for discussion. And then a very important issue, that in Europe they are more migrants than children. Thank you so much. Thank you, Simone, because otherwise we want very interesting, historical. Antonina, hello. So Antonina is another one who was easy with this, with my invitation. She didn't, I didn't have to pray, and I really appreciate that for this. Juliana as well, so I will tell when Juliana is coming. But for now, because I know that Luigi is already here, and Luigi has a doctor appointment. So let's go with it. So another vulnerable groups, children again. So and Zampalon. So for those who are not here, who are somewhere else, for my students. Pleasure, Antonina. Antonina is from Messina. We met during the conference on migration, and I really liked her paper, and I invited her here. Antonina.
Thank you, dear Professor Gromek-Brock, for inviting me. And it is my pleasure to meet here at the University of Messina. And it is an honor for me to have been invited to speak on a topic of which the Professor Gromek-Brock wrote a beautiful essay in the review ordinance. In Italy, the latest monthly monitor of the status of unaccompanied foreign minors carried out by the Ministry of Labor and Social Policy show that there are many unaccompanied foreign minors. If it were possible to graduate among the vulnerabilities to which migrants are subjects, minors undoubtedly occupy a top position. tradition, I would say Simone Paoli. But in Italy, Italy is one of the few countries to have enacted a law to protect unaccompanied foreign minors. I refer to the so-called Zampa law, the law number 47 of 2017, from the name Zampa law, from the name of the deputy rapporteur for the text. This law attributes a series of rights to minor for the obvious purpose of achieving effective integration of the same through a strengthening of the existing protection and the guarantee of uniform application of the rules for reception throughout the national territory. And in the Article 1, paragraph 1, recognize the same right on equal term with minors of Italian or European Union citizenship. And this is very important. In Article 10 of this law, paragraph 1, establish that any request presented by a child or his parents in order to enter a third party or to leave it for the purpose of family reunification must be considered with a positive spirit, with humanity and diligence, specifying paragraph 2 the right to leave his country and to return to it, committing the existing states pursuant to Article 11 to take measures to prevent illegal movements. But one question we must ask together is, who is an unaccompanied foreign minor? The expression indicates the citizen of states not belonging to the European or stateless under the age of 18 who is for any reason in the national territory without assistance and legal representation. In the Italian Supreme Court, with a decision of 2019, the number 9199, has sanctioned how, based on Article 2 of the Law 47, the unaccompanied foreign minors must be without assistance and representation by parents and other legal responsible adults in accordance with the law of the Italian legal system. And the use of the conjunction hand between the words assistance and representation of service to the court indicates the necessary competition of both conditions. The first relating to the profile of material assistance, understood as the absence of subjects who have care, custody, and sure well-being of the minor. The second relating to the profile of legal representation, understood as the absence of subjects representing the minor, or for this reason they are formally responsible. A fundamental step in the identification of the is the identification of the minor. And Article 5 of Zampa law introduced homogeneous procedures in the national territory, suitable to overcome the difference of territorial practices previously existing. This represents a fundamental step, since the possibility of applying protection measures depend on the assessment of the minor age. The assessment is necessary where it is not possible to identify the parents, also through the documentation existing in the country of origin, or in the presence of reticence behavior by adults linked in various capacities with the minor. But there is a tendency, we know, for many young foreign to declare an age less than 18. And the reason is simple. This is because the protection of Zampa law stop at the age of majority. And this, for me, for all, is an aspect that reveals a limitation of the existing legislation, since many young people who, despite having passed the age of majority, are still in an uncomfortable situation, are excluded from the application. In the presence of a minor, it is necessary to evaluate which solution is most appropriate to his interest. As Article 403 of the Italian Civil Code, in fact, public intervention is mandatory, aimed at placing it in a safe place. Significant rule introduced from a procedural point of view, which aim to implement the Dublin regulation, are relating the institution at each juvenile court by the regional guarantors for children and adolescents of a list of voluntary guardians who are willing to assume the protection of an accompanied foreign minor. The voluntary guardian is an important support figure in the process of reception and the progressive integration of the minor, as he assigned, according in the case, the task of assisting or replacing the minor in all those activities aimed at making a full exercise effective of the rights. The dialogue between the minor and the institution put in place by the guardian allow, for example, to facilitate the activation of family investigations without prejudice to the recognition of the right to the possible appointment of a trusted lawyer, making use of free legal aid at the expense of the state in each state and degree of the procedure pursuant to Article 16 of Zampa law. Now, let's see in particular what are the rights recognized to migrant minors by Zampa law. It is about the right to health care, education, and listening that constitute tangible proof of the integration process started in Italy. The first is the right to health care, is achieved through the extension of the registration in to the National Health Service, with the previous legislation considered mandatory only for minors with a residence permit, also pending the issue of this permit. The second is the right to education, that is incentivized through the adoption of specific measures by educational institutions and training institutions suitable to facilitate the fulfillment of compulsory education by minors. And the third is the right to listen. It is very important because in the administrative and the judicial procedure involving the minor, even in the absence of the guardian, however, is not always fully realized and yet nevertheless perform a basic function for understanding the effective needs of the minor and activating the consequent protection. In this regard, one can't fail to underline how, for the accomplished exercise, the role of the guardian or the manager of the reception center is central, which must have the sensitivity to understand precisely by listening if the minor needs possible emotional and psychological assistance, to which also entitled pursuant to Article 15 of Zampa law. But among the right guarantee also to the foreign minor on an equal footing with the Italian minor is to be mentioned above all that of growing up and being educated within a family and possible their own. Although, as previously pointed out, there is an objective divergence between the notion of state of abandonment used in adoption Italian law and the situation of an accompanied foreign minor. Also, in this latest case, the legislator expressed a preference compared to being placed in a host community to our custody within a family or in a family type community. This is because it's based on the objective data according to which the family environment constitutes a privileged location for a balanced and harmonious psychophysical development of the minor. Article 7 of Zampa law, modifying the Italian law adoption, Article 2, which provided for a family custody for the minor temporarily without an autonomous family custody, provide that without further burdens for public finance, local authorities can promote the awareness and the training of carers to encourage the family custody of unaccompanied foreign minors as a priority comparing to be admitted to a reception facility. And in this sense, in implementation of the directive on reception conditions, as far possible, we tend to keep the broader together, limiting the change of residence to the indispensable. And these provisions are inserted in the furrow of the Italian law number 173 of 2015, that also modifying the law about adoption, provides that for the rights of the effective continuity of children, and therefore the possible transition to adoption in the presence of a minor orphan or of the parents by person joined to the minor by kinship up to the 6th degree, or by a pre-existing stable relationship and lasting also accrued in the context of assignment procedures. Similarly to the Italian minor placed in a custody situation, the optimal solution could be that of an adoption by the foster children if the needs which led to the separation from the biological family, even if not in a completely radical way, subsequently they may seem to be temporary. A possible interruption of the educational and emotional relationship with the carers may not be responsive to the actual interests of the minor. The implementation of this principle with the law 47 of 2017 has that allowed the European Commission to affirm that Italy guarantee an accompanied foreign minor adequate legal protection, both at an organizational, administrative, legal, and to legislative level, and to file an infringement procedures against Italy launched by European Union in 2013. The Italian Zampa law had the merit of introducing the integration measures in a long-term perspective for the new adult in order to guarantee him support in view of achieving autonomy. So the Convention of the Right of the Child was implemented, which placed the interest of the minor at the center. It also recognized itself the Charter of Fundamental Rights of European Union, how say Simone, in addition to the general principle of equality pursuant to Article 21, prohibits any form of discrimination based on birth, and in Article 24 indicates in paragraph 1 among the rights of the child that to receive care and protection functional to his well-being, and in paragraph 2 state that in all acts with concern minor, whether they are carried out by public authorities or private institutions, the best interest of the same must be considered paramount. The legislative decree of 28, number 113 on immigration and security, converted into law and wanted by Salvini, the Minister of the Interior, has cancelled the protection for humanitarian reasons, which has been widely used in recent years, but had fortunately maintained the protection reserved for minors in consideration of their vulnerability. In this sense, the text of law of 2020, number 130, which present a series of important innovations, including the repeal of the security decree, should be considered an important step forward in terms of immigration. But now the COVID pandemic has further accentuated the numerous problems affecting unaccompanied foreign minors. In the lockdown period, young people, mostly adolescents, who must be able to learn a new language, train themselves, become independent from a working and housing point of view, once they come of age, are the witness, helplessly, the sudden interruption of their inclusion with the suspension of work or training placement, finding themselves without financial resource and with difficulties in renewing or converting residence permits. A setback that occurred in an already very difficult period due to an ever greater closure of borders and European and national policies ranging from a pushback along the Eastern European border to the closure of the Mediterranean port. Allora, now I start to conclude. I think that is necessary that the migration phenomenon be addressed through our political direction, that regardless of the specificities of the individual European countries, translate into organic legislation. In fact, in the European resolution of April 2016 on the situation in the Mediterranean, the need for an approach by European migration policy emerges. If from a market point of view, and therefore depending on the achievement of substantially economic interest, the Union has managed to adopt homogeneous legislation which guarantee on the one hand the free movement of goods, service, capital, and on the other hand, the protection of weak contractors such as the consumer, server, when there are interests at stake, which pertain to an exquisitely non-patrimonial sphere as a measure for the phenomenon of migrants. On the other hand, exists an objective difficulty in finding an overall picture that allow effective policies to be implemented. Furthermore, it's also necessary to stem the migration phenomenon through policies to support the poorest countries. And the European Union has committed itself to the 2030 Agenda for Sustainable Development, a program aimed at providing support to migrants, countries of origin and transit, to strengthen regional cooperation on the protection of minors, which support activities of the West African Network for the protection of minors. A series of funding has been provided for the education of refugees children, with the creation of a special fund for refugees in Turkey on the European Union Trust Fund in response to the Syrian crisis. And Pope Francis in the Angelus on Sunday, February 8th, said expressly, I would like to make an appeal in favor of unaccompanied foreign minors. Are so many. Unfortunately, I was informed, he said, on the dramatic situation of those on the so-called Balkan route, but there are some in all routes. Let's make sure that these fragile and defenseless creatures do not lack proper care and preferential humanitarian channels. And the mind goes back to January 2019, when the body of a child with the school report soon inside a jacket pocket was found at the sea. It's reported the school grids of the children, written in French and Arabic. A car kept with pride and love in the hope of a new life. The school report as a proof of merit that every human person must have, regardless of school grades, gender, race, and religion, respecting the highest juridical value at stake, which is human dignity. I thank you.
Thank you very much. Thank you very much, Antonina. I have many comments, but maybe I just don't know, because I know that Dr. Vanella has a doctor appointment, and before we have another talk, just only few things that I would like to say. Well, what sort of protection in asylum procedure, custody, then a very important right to education in the situation of pandemic now. So what sort of right of education? So those would be my my questions, but maybe we can do a little bit. I don't know if Professor Morone is in a hurry.
Yes.
No problem.
No, what I'm saying that maybe before Professor Morone, because Dr. Vanella has a doctor appointment. So let's first, so we have now in our program Marco Gardini, and am I pronouncing right? It should be Giardini, no, Gardini. Gardini, so I'm okay. And I'm really grateful because nobody wants to look after aging population in migration. So obviously, Marco Gardini is not a lawyer. He would approach this from a different perspective, but this is a very important subject in relation to vulnerable groups, the elderly. And as I said, that if I would have time, I would have done something about access to benefits for the elderly migrants. Antonina, great, but let's really thank you. No, don't go. Before Professor Morone, maybe we can come back to some questions, and the same for Simone. So, Dr. Gardini, can we know something about aging in diaspora? But this is a very important topic also for my students, because they have just considered diaspora in their class last week. So we tackled 3 things at one go. So thank you very much.
Thank you very much for having organized this important opportunity of reflection and exchange. My contribution today is an effort to explore a couple of problematic questions that I think are important to ask when, as an anthropologist, I look at the topic of vulnerability, and that both Valentina and Emanuela have already stressed this morning. The first question is vulnerability from what? Which is a question that invites us to consider the multiple social, economic, political, and gender dimensions that intersect in producing what we call the vulnerability of certain groups or individuals. And the second question is how the concept of vulnerability is socially and culturally elaborated, which stress the fact that often vulnerability can mean different things for different people in different times and contexts. And a good analytical tool, I think, to answer the first question is, of course, intersectionality, as it has been already stressed many times today, which is a concept that explore how multiple forms of social differentiations, such as gender, class, age, skin color, origin, status, religion, can variously overlap to produce and reproduce social and political subjection, economic inequalities, and dynamics of exploitation. While the analysis of life histories and life trajectories can be a good way to address the second issue, or at least these methodological tools have been useful to me when I started to focus on elderly women of the Eritrean diaspora in Italy, in particular in Milan. Many of these women have been vulnerable under many points of view, because of the endemic racism of European societies toward people coming from former colonies, because Italian laws were far from being able to guarantee them the rights normally guaranteed to citizens, because they were women, because they came from poor rural background, and because they have been exploited as domestic workers by rich Italian families for the great part of their life, a condition that prevented them to increase their economic and social capital. And yet, despite these multifaceted forms of vulnerability, they started to perceive themselves as vulnerable only after retirement, when age intersected with all these factors. And the reason for that was that age made somehow evident for them the fact that their migratory experience was not successful at all, at least according to the criteria of other members of the diaspora. And here lies, I think, a little paradox that I think is worth considering. These women started to perceive themselves as vulnerable precisely at the moment when they disappeared from, let's say, the radar that the public and forensic discourse creates when applying the framework of vulnerability only to migrants of recent arrival. Indeed, when aging and migration are evoked together in the public and political discourses, it is generally inside a narrative that frames an European population getting increasingly old and a young exploited migrant labor force coming in. This narrative, of course, is not false or untrue at all. However, it can hide the historicity of the African diaspora in Europe and does not take into account that there are many so-called migrants who have lived for more than 30, 40 years in Italy, and now they are approaching or have reached retirement. I say so-called migrants because, in fact, they are not migrants anymore. Many of them managed to become Italian citizens or have permanent residential permits. They have built a family in Italy. They have children born there and have spent more years in Europe than the years they spent in their country of origin. For sure, members of the aging diaspora cannot be reduced to homogeneous social categories, given the variety of their life trajectories, the plurality of their social and economic condition, and the different strength of their local and transnational social networks. Of course, aging can be a period of changes and innovation, and not only of vulnerability, even if this positive picture of aging can be easily criticized when compared to the life histories of those who were not able to achieve the socially and culturally constructed markers of a successful aging. However, it is certainly true that elder members of the diaspora are often quite active in renegotiating their social position toward the kinship networks and play an important role in the activities of migrant associations, for example, in the host country, but also being a guide for those who arrived later and the main sources of remittances for those who stayed back. Even if their needs are to some extent similar to those of the aging native population, ethnographic research have uncovered the specific challenges of aging in a foreign country. In other terms, a focus on the aging diaspora allows us to explore many other topics, care system, for example, but also the topic of return and how the meanings of aging are renegotiated in a diasporic context. Indeed, beside psychological challenges, return trajectories are fraught often with social, political, and economic difficulties that made unrealizable what seems easier in an earlier stage of life. The choice of spending what is left of a diasporic trajectory here in Europe or there in Africa depends on a number of factors: the success or not of the diasporic trajectories, the family networks they have maintained back home and those they created anew in Italy, with the corresponding responsibilities, of course, their health condition, and also the political context of the country of origin. Of course, these same factors influence also what does constitute, in local terms, vulnerability and marginalization. The case I present here concern people of Eritrean origin who have spent most of their life in Italy, now are more than 60 years old and are approaching retirement or are already retired. Many of them were women who worked, as I said, as a domestic workers, but there were also men, some of which had had a successful trajectory and now owns the many Eritrean restaurants concentrated in the central and rich neighborhood of Porta Venezia. In other terms, it is a highly differentiated community where you can find elders that experience very different conditions and elaborate very different meanings of aging and vulnerability. Many old women I met who have worked for years as domestic workers were among those who did not achieve, as I said, the socially accepted markers of a successful aging and struggled a lot to make ends meet. I quote the example of Marianne. She was born in 1944 near the border with Sudan. Her parents worked in the cultivation of cotton for the Italians during colonial period. Thanks to her father's contacts with some Italians, she managed to emigrate in Italy in the 70s and worked as a maid for a rich family in Milan for 15 years. But without a formal and legal contract, then she changed employers and continued to work until retirement in 2010. She was not married, she had no children, and she lives alone with a pension of around 900 euros, since her first employers didn't pay her social security contribution. When I asked her about the meanings of vulnerability, she answered, and I quote, "It means being alone and not having children and grandchildren who love you and help you. When you are young, you have other things to think about, and you think you will be fine when you will be old. You think you can rest, and instead you never rest if you are alone. If I could go back, I would marry, but I used to say, I have to work, and then it was too late. And now I have no one with me." Marian had lost many of his family connections in Eritrea. Given her salary, she was not able to send remittances, and she had serious health problems. Going back even for a period for her was not an option. Indeed, the last time she visited Eritrea was 20 years ago. Miriam was not able to achieve the models of a successful aging, and her condition is shared by many of the former housemates I met and who have not been able to marry and have children. Miriam blamed their past working condition and the fact of having been exploited by her Italian employers, by the Eritrean government, and also by her family networks in Eritrea that continued to consider her only as a source of remittances. As other elderly women I met, she complained that all these actors forgot them once they were not more productive. And this fear of being forgotten was a substantial part of their narrative of aging and vulnerability, as it was the deep sense of loneliness and social exclusion. Their much hated loneliness was for them a silent space filled with regrets and bittersweet memories. But it was also a space in which to reconsider critically the social, economical, and political forces that led them into exploitation, a condition that they actively tried to overcome by forging new social relations and by reframing what it means to become an elder in the diaspora. Many of them, Mariam included, cultivated a network of few but important friendly relations among themselves and also with lonely Italian retired women living in similar conditions. They helped each other to go shopping, for example, to do medical visits, to spend the long hours of empty days. As Mariam said, luckily I have this friend living nearby. She's Italian, she has my age, and she's alone like me. We check every day if you are still alive. It is our loneliness that made us friends. We discovered to have much in common, even if I come from Eritrea and she comes from Italy. Loneliness made us similar under many points of view, and we spend our time discussing the many reasons why we found ourselves in this condition. I felt that these words were important as long as they testified not only the agency of these women, but also because they framed their condition of isolation as a platform over which it was potentially possible to forge new links and new social relations and elaborate powerful criticism against the power structures that informed their life trajectories. I conclude by saying that intersectionality and the analysis of different life trajectories allow us to explore how important social capital is for elder members of the diaspora, but not only, in order to try to overcome vulnerability. But also how this social capital strongly depends on the labor condition you experienced during your own migratory trajectory. And the case of former domestic workers like Mariam is a good example of that. Vulnerability for them was a synonym of loneliness and isolation, immobility and regret, condition that they faced trying to create new relations and elaborating strong criticism toward the political and economic dynamics that intersected to produce and reproduce the social marginalization, a condition that is often shared by other non-migrant elders, and that is often forgotten in the constant state of emergency that shapes the current narrative of migration. Thank you very much.
Professor Gardini, excellent, thank you so much. I just like, very quickly, if you can you stay a little bit longer? Because we have this urgency.
Yes, of course.
Yeah. So just few ideas. So you stressed many times on intersectionality, and then you pointed at one point on the care system, marginalization, social exclusion, and loneliness, and all this that we can say that they are elements of this vulnerability. We will come to the questions, but Dr. Vanella is really in a hurry, so thank you very much. I just, he also, thank you very much for your presentation. Thank you very much, Dr. Vanella, for accepting my invitation. I know that it's a very short time, and I really appreciate, because we do want to have people who who know something about how it works in practice. So Dr. Vanella is from Pavia Sprar. Yes, Pavia Sprar, and is going to talk about hidden vulnerability.
Yeah.
So the floor is yours.
Thank you very much, and good afternoon, everyone. And many thanks for the invitation. May I share my screen?
Sure, absolutely. You can, you know how.
Yeah. Okay.
It will come.
Okay. Today I will talk about the hidden vulnerabilities in the Italian reception system, and in particular, I will describe the situation of the reception centers in which I have been working for several years as a legal advisor. We will talk about these hidden vulnerabilities, and you will understand why hidden. One city, two different reception systems. The city obviously is Pavia, and the reception systems are CAS, acronym for Extraordinary Reception Center. The system was created by Article 11 of Legislative Decree number 142/2015. The system is reserved for asylum seekers who mainly receive material reception. We could say board and lodging. They were created to provide for the lack of places in the ordinary reception facilities in the event of large and close arrivals of asylum seekers. These structures are identified by the prefectures in agreement with cooperatives, associations, and the hotel structures. The stay should be limited to the time strictly necessary for the transfer to the second reception facilities, but in most cases, this transfer never takes place. The second reception system is SPRAR. You know, there are many names for this system because we have so many governments in these years, and everyone gave his name to this system. But this is the acronym for Reception and Integration System, also said second reception. The system was created by law number 100 and 89 in 2002, better known as the Bossi-Fini law. The system is reserved for two categories of migrants. Asylum seekers, and they have material reception, health and social care, Italian language courses, linguistic cultural mediation, orientation and orientation to local services, and legal orientation. That's my job. The second category is a foreigner holding a residence permit for international or national protection. They have access to all previous services, but in plus we have job orientation and professional training. Second reception, the so-called second reception is structured in the three categories of reception centers, which offer their services to MSNA, acronym for unaccompanied foreign minors, vulnerable subject, and ordinary subject. The structure in which I work hosts only ordinary subject, but only on paper. And now I will explain why only on paper and why we are talking about hidden vulnerabilities. Analyzing the last 4 years, 2017 to 2020, we can see that 165 people were hosted, and among these, the vulnerable case were 35. In these years, we met every kind of vulnerability: disabled people, elderly people, pregnant women, single parents with minor children, persons who have been subjected to torture, rape, or other serious form of psychological, physical, or sexual violence. The data I am about to list all concern cases of vulnerabilities certified by our health authorities. So you need to consider that there is really a world under this level. What I'm going to tell is what is certified, but what is not certified is a very big C. So that's these are the data. Minors with certified disabilities, 5. Women with psychiatric disorders, 3. Men with psychiatric disorders, 10. Women with other vulnerabilities, and we have more or less all the vulnerability that I was talking about. Pregnant women, single parents with minor children, persons who have been subjected to torture, rape, or serious form of psychological, physical, or sexual violence. 5 women of this category. Elderly and disabled men, 1. Disabled men, 2. Men with health problem, 8. In these problems, we find disability, HIV, or diabetes. We are doing our best, but over the past 7 years, Italy has had 5 governments, and at times we have had the feeling that the aim was to destroy the reception system. Minniti Decree number 13, 2017, Salvini Decree number 113, 2018. Now that for the moment the resources are back, we can do a better job for reception and integration, but it's still too difficult to direct vulnerable subjects to the centers dedicated to them. In any case, 6 or 7 years of reception would make anyone vulnerable. Also considering the timing of justice. For example, court hearings scheduled for 2025. It's a very, very long time. Anyone is going to go crazy in a place where your life never starts. You are waiting for something and you really go crazy. I would like to end my speech talking about the third reception. I'm so happy that about 1 year ago, I found with some friend that works in the same field that I work for, the Pavia office of Refugees Welcome International. So we have Refugees Welcome International was born in 2014. In Italy was born in 2015, and in Pavia we were born in 2020. Refugees Welcome is an international organization born in Berlin in 2014 and now active in 15 countries that offers a new model of reception. Hospitality in the family can be a very important moment for the refugee to achieve full autonomy. Time is running out, so I invite everyone interested in our initiatives to visit the official website or to contact me personally. Thank you very much.
Thank you very much. Well, this was exactly, as I said, 10 or 15 minutes. Thank you very much, Luigi, for being with us, that you accepted. I really underline this willingness of people who want to contribute, that they don't make this difficult. So you are very precious for us in the sense that we will contact you certainly. There is maybe, but I can't promise at this moment, but it might be a possibility in the future that we will do a collective contribution as a publication. I don't promise, because I have piles of things that I have to do before. So, but it would be a very interesting thing, and I hope that at one point I will be able to collect this from you, but then I will write to you as well. And please stay with in touch, because we are very much interested in your work, in all kinds of. Maybe next time the topic would be different, but we will still want to have you here. So thank you again.
Thank you very much. I'm so happy to be here.
Could, at one point, to give us your PowerPoint, if you can.
Yeah, of course.
Okay. So thank you so much. Any questions to just before you go? Any questions to Luigi? Sorry if I can, to Dr. Vanella. Any questions to Dr. Vanella? Everybody is shy. I don't know, because we have a little bit a different audience this afternoon, and they start at the beginning, they were shy in the morning, and then they have become talkative. But okay, so Luigi, thank you very much. It was interesting, and we want you in this work and in this platform. Thank you so much. So yes, so questions. So where is Antonina and Simone? Do we have any questions about children best interest, about Zampa law? I did say the very shortly those comments where I have this.
Yes.
I would have.
Can respond.
Right. So so for Simone, I would see. I would ask him. So, what sort of reforms should we undergo at the in the European level in the European Union to change this perception from child more conceived as a migrant, so in head of somebody, an adult, rather than emphasizing that this is a child and needs to be addressed in the completely different way. Was I clear enough?
Mm-hmm.
Yeah.
Clear, Katarzyna, but unfortunately or fortunately, I don't know, I'm not a politician, and normally historians tend also to stay away from questions concerning the present times. So I do not have indeed an answer to your question. I don't know how the European Union could improve its legislation in order to consider child migrants more as children than as migrants. I know, however, that in the history of the European Union and in the history of Europe, especially after the 70s, when the member states of the European communities decided to stop labor immigration and to strengthen reunification of migrant families, the question of children became one of the most important issues concerning the European Union. And until the numbers were quite small, and until, more importantly, the children were essentially the children of the workers that had immigrated, this was a problem that was quite manageable for the member states of the European community and later the European Union. Starting from the 90s, this question became more and more difficult to be addressed, because the phenomenon, as also Antonina said, the phenomenon of unaccompanied children, of course, is posing a challenge to the European Union and its members. Because at the moment in time, the question is no longer to provide services to people that has already a family, but to provide services, benefits, rights to people that have no families, and to people that is arriving in large numbers. So nowadays the problem is to find a compromise, and in this sense, probably the concept of child best interest has to be rethought. There is the need to find a sort of reconciliation, a sort of combination between many interests, many considerations, and many values. Because the phenomenon is assuming a size, a proportion, and also a political relevance that need to be addressed and in a broader context that bring together many interests and many considerations. So I do not know how the European Union has to deal with it, but I'm sure that only at European level this question can be addressed, and that the question of children, the question of the best interest of the children has to be solved in a broader political context that takes into account many variables, many factors.
Right. So what I say, thank you very much for this, and really important, because, you know, well, I would say that exactly, you said that it was since 1990 is exactly when the European Union has become a union and not economic community. So EU well, European community wanted to become a political union. So if it wanted to become political union, it should assume, well, whatever the sort of the goals might be for political union. I think that here children, and in the same time, I can say that as an example of people in pandemic, well, they should be protected within this political union, if you want to become a political union. Because, as I said, just in relation to pandemic, we can say that we have heard for many years that European citizenship is a fundamental status of every citizen in the EU. Well, but what does it mean? Does it mean that it's also to be within the EU is also, well, to die sooner because we don't have vaccines, we are delayed, and this is a provocation, but I'm not going any further. But it's a little bit about this. We become political union, so we should protect children, and we should know what it entails. Okay, Antonina, my questions were, anybody wants the question? What protection in asylum? What protection in custody? Okay, and how about right to education? All this within Zampa law. You need microphone. Can she hear me? Microphone. Microphone. We can't hear you.
Ah, okay.
Okay, now.
In between, I can share this slide with us that I prepare for. Do you see?
Yeah, we do.
Is a monitoring of Ministry of Labor and Social Policies. And they show that in Italy is the door of Mediterranean ports, and especially Sicily. And Italy have a politic very important for instruction of minors. And but the problem is that the other countries don't do what necessary for migrant, and Italian people is alone in this situation. During the crisis, in this period, also many Italian minors are in period of very difficult, because many Italian minors are without adequate instruction, and this period many politics like Salvini come si dice come si I don't
what do you want to say? I might not know, but if I know, what's Italian word? What's the Italian?
Exploit this desperation of many Italian to put against Italian with the migrants, and so it is a difficult period, because also Italian children are without adequate instruction, because there is a difficulty to with internet to do adequate instruction, education to minors, and so also diciamo migrant minors are reason of this period of crisis. but Italy is one of a few countries of Europe to have a law for minor for their vulnerability. But in Europe there aren't policies that offer to minors adequate legal protection as like Italy. For me, and so I think that Italy have a good policy in this sense for minor.
Yes, absolutely. The example law is is exemplary, we can say, but we should look at implementation and the cost of this, how much it's going to cost, and if Italy is able to implement this in the right way. So this is a different issue. Thank you very much. Thank you very much, Antonina. Really kind of you. Shall we just, Professor Morone, are we still okay with the question to Professor Gardini?
I'm fine, no question.
Is it okay?
Yeah.
So,
yeah, okay, you can follow. Yeah, of course.
Yes. So, Antonina, you if you can just finish with the slides, because like this I can see.
Yes.
Thank you so much.
And allora, this is the last monthly monitoring on the status of an accompanied foreign minor, and show that in Italian soil there are many accompanied foreign minors, and especially from sorry, aspetta, allora, Bangladesh, Tunisia, Albania, Egypt, and Pakistan. My region, Sicily, is the region of where there are few minor unaccompanied foreign minor, and because it's the door of a Mediterranean port. In December, you can see that in the period in the COVID crisis, there are 3,860 new reports are entering to the Italian territory, and from Tunisia, Egypt, Afghanistan. And this is the link where you can find this monitoring.
Could you share with us? Can you send me at one point your slides?
Yes, certainly.
Because I told you that I'm planning to do something with this, but I prefer not to promise before. So now if you could take these slides like this, I can see the audience, because I have the slides on this.
Okay,
you need to close this, share the screen.
Okay. Of course.
Yes, because otherwise I don't see anybody. Thank you very much. It was very, very important. So, Professor Gardini, anybody has questions for Professor Gardini, and you very much in line what we are going to do later on, because we are going to talk about women, and mainly in relation to this intersectionality, because women themselves are not protected. They need to have another, well, either being pregnant and or being elderly and so on. So anybody has a question for Professor Gardini? I find this very fascinating, but I have been teaching labor law for 16 years. So I have some sort of in my head as a labor lawyer. Any question for Professor Gardini? I want to know more about intersectionality.
Yes. I don't think that.
Can I?
Yes. Sorry.
Yes, somebody. Yes.
I was answering Professor Caterzini.
No,
I'm sorry.
I'm sitting here, not going.
No, sorry to interrupt, but sometimes during the day I was able to follow the speech, and especially Marco Gardini. I found really interesting your speech, because for our services, Restoring Family Links, sometimes also the link and the contacts with the diaspora community is really important, and this is something we would like to improve, especially with the diaspora communities in Italy, because for us, more than the institutional channels, sometimes are the right link to collect all the information on missing person. So I would like to know from your experience, from your experience, if you know something more about different diaspora community in Italy, for example, which kind of communities you know on our territory, let me say, to reach all these communities, to let them know about also the Restoring Family Links, so the possibility to receive a support also in terms of clarify sometimes the fate of the people missing, or to restore contact with family members or community of origin. So I don't know if you register something similar in your experience or in your studies in general. Thank you.
Just can I just say, if you agree, but please do send me a message if you don't, so because I can share your emails, but then send to my email that you don't agree. If you don't agree, if you don't send anything, I can exchange your emails on this platform.
Thank you.
I'm sorry for
Federica, thank you for your question. I mainly worked with the Eritrean and Senegalese diasporas in Lombardia, but I think it's relatively easy to establish connection with the diasporas, because at least the African diaspora, I don't know the other diasporas, but because there are plenty of associations which are very well organized, that works very well in the Italian territory, which are organized under different criteria. They can be regional criteria, religious criteria, and so on and so forth. And I do think that if the need is to try to establish this kind of link in order to get or facilitate the work of finding missing person, or recreating particular links, this is a good way to, and I think that, at least my experience, they will be very happy to contribute, because if it is a problem, it is a problem also for them, first and foremost, I think. And regarding intersectionality, I don't think that intersectionality must become the magic wand that solve every kind of theoretical problem we have when facing vulnerability. I think it's an important tool. I think it's a wonderful instrument in order to complexifying the issue and to understand that there is not a vulnerable group, but there are many forms of vulnerabilities, and every group that we consider is internally differentiated, which in some ways also help us to go beyond the victimizing, a victimizing perspective of this group and people, and it helps us to underline their agency. But there is one risk in every, I think, good theoretical tools. There are risks and opportunities. One risk is that it is somehow objectifying, because it means to consider the if and how people consider themselves vulnerable, and under what criteria. It is quite an objective criteria. It gives, okay, it is a woman, it is disabled, it is a migrant, he has a black skin, so it is vulnerable because he is at the intersection of different forms of social differentiation, so on and so forth, which is not the end of the research. It must be the starting point of the research. I mean, and the next step is to go and ask him, her, if and how and in what terms he feels, she feels vulnerable, and to what it feels vulnerable, and which I think it complicates further the question. I mean, at least for an anthropologist. I mean,
right. So if I can say, but obviously my point of view is a legal point of view. So for instance, I think that Europe does not really address intersectionality to the level that it is done in the US. Because I taught in the US discrimination law, and there really, well, the issue of intersectionality is really important. So the Equality Act 2010, the UK Act, addresses intersectionality only in relation to disabled people. So and the EU finally does not address intersectionality, divides this into categories, and that's it. And exactly this is what we discussed since 9 o'clock in the morning, that it's not that much important what is in the definition, but what is not. And this is a problem. Professor Morone, first of all, I should say, so I should introduce Professor Morone. Professor Morone is not is historian, but he's absolutely not the first historian, because Simone Paoli was a historian, and he said, I'm the only historian. I said, you are not. And I think that Professor Morone has a very interesting topic in relation to the current pandemic, because finally we could have had this conference on vulnerability in times of pandemic. It would be very recent and very sort of up-to-date idea. But I wanted to have this white, because when it's white, we can use those elements for many other purposes. Professor Morone, floor is yours, and I do apologize for the delay.
No problem. Thank you so much, Professor Gromek. And I would like to thank you so much for inviting me and for organizing this very beautiful conference. And above all, I would like to say my compliments because you are winning the Jean Monnet. That is very highly competitive, project in the European Union. And so I think that so I'm very proud to be here to participate in this conference, but also because this Jean Monnet will be in our department for the next 3 years. And I think that will be a very fruitful program for not for only for the staff, but also for the students. So thank you so much again. I would like just to spend a couple of words about this idea of the genealogy of the containment policies. Of course, when you look at when you are considering vulnerable groups, we have also to consider the European policies about containment of the migrants. I'm starting, so I taking for granted the starting point that the containment policies are producing vulnerable peoples. They are not solving the problem, but in actuality, they are, they make more complex all the framework. So in my field of research is above all Libya, and so Libya is in my mind when I'm speaking about containment policies. I was able to doing my field in Libya during the last more or less 10 years, and my talk is coming from my experience in Libya. In my understanding, the containments of migrants, the policies of containments of migrants is like a circle. In my understanding, we can speak about a circle of containment when this circle can be described in three different and very interconnected stages. The first stage is, of course, halting the migrants at sea when they trying to reach the Italian or European coastline. The containment policy is trying to stop the migrants at sea. Of course, and then to push back the migrants to the Libya or basically to the African coastline. But it's not just this. I think that is the most visible part of this cycle of containment. In actuality, there is also another part of this, another stage of this circle that is not visible or is less visible, and this is when the migrants are interned are getting imprisoned in Libya in many detention facilities. That is something that is very different from the dynamic of encampment or self-encampment from the side of the smugglers, of traffickers of migrants. These policies of internment are related to public institution, Libyan public institution, but also to the Italian and European public institution. And the third stage is the final attempt to deport and relocate the migrants from Libya to their home countries, in basically out of Libya, more southwards. This is something that I'm sure all the people know very well. My point is discussing the historical origin or the historical antecedent of this cycle of containment. And in this regard, I pick up just a couple of points very quickly. The first one is the point that is related to the space where the cycle of containment is working. As I already said, the containment policy is working not only at sea, but also on the ground in Libya. And working on the ground, in reality, the containment policies are dividing the Libyan space in two, and we can clearly identify a useful Libya, that is the part of Libya where the migrants are working and are relatively low contained in the strip of the coastline. So basically the strip of Libya where there is the big cities, where the migrants are useful for the informal economy of Libya. And there is another part of Libya, basically the southern region of Libya, the desert of Libya, where the most important part of migrants are put in jail. This division between useful and less useful Libya in regards of the migrants, I think that could be put in relation with the history of the Italian colonialism in Libya, when Italy was dividing the former Libyan colony in two. So the northern part that was becoming in reality part of the motherland. So the northern part of Libya became Italy, at least. and the other part of the region that was basically under the Italian military control. And if you look at this divide in the history of the Italian colony in Libya, you can see that there is a sort of phantom border that is re-emerging in nowadays Libya, between the desert, the southern part, and the northern part. And of course, the concept of phantom border is something that is linked to the history. The notion of phantom border is something that is very closely related to the history and the visibility of the history. It basically is a border that is not more legally bounding, but is something that is very important to understand the identity of people and societies. Even this border is also an internal border in the Libyan society between between the northern Libyans and the southern Libyans, and in relation with the issue of course, the racial identities of Libyans. Let me say the black and white Libyans. That is something that is very relevant in the contemporary Libyan society. But the second point that I would like to address very quickly is that this idea of contain the migrants is not something very new in the history of relation between Italy and Africa, or we also can say between Europe and Africa. In reality, the containment policies and this idea to push back migrants towards Africa is something that was already on the table when the very first African migrants came to the Italian coastline at the end of the Second World War, when the Italian colonial empire was fading down, and the new African countries was rising. So at this time, during the 40s, there was a lot of migrants, several migrants that trying to come from basically Libya and Eritrea. They tried to come to Italy, basically looking for a better life, and also to try to reshape the colonial relation between Africans and Italians. And when they come in Italy, and they come basically in an undocumented way, the reaction from the, at that time, government of Italy was more or less the same than the present policies of containment. Those Africans basically were, at the first time, were put in some containment building, basically military bases, and then at the very beginning of the 50s, they were deported in Africa. In my understanding, these policies of containment that were elaborated at the very beginning of the Italian Republic is something that was still working on the maybe in the background of the Italian society and the Italian politics. And for this reason, I think that could be interesting and important to remember that this idea to contain migrants and to push back migrants towards Africa is not something new that just come up in the last 20 years, but is something that is very rooted, not only in the history and the perception of the Italian colonial history, but is rooted in some specific policies that was already on the table, that was already working at the end of the Second World War and at the beginning of the history of the Italian Republic. Thank you so much.
Thank you very much. Thank you. I should not ask the questions historians because previously I did, and right. But what I got here, I got, well, tell me if I got it right. So I had this idea that the state actors already in migration create vulnerability by discriminating between migrants, for instance, those in jail, those somewhere else. So there is first, second category. So this is something that Emanuela and Valentina, who left, they also said that finally vulnerability is born, not always, but very often is born already in migration. And as I said about those state actors, that obviously in different, very often non-democratic regimes, this is created by the state actors. What do you think, Professor Morone?
Yes, of course. I think that, you know, I can add just one point that once again, from an historical point of view, basically we can say that also the law was something that was completely organic to the colonial plans. The law was a discipline that was very relevant in shaping the colonial world. And if you take in our mind this starting point, of course, the situation today, of course, is very different. But once again, the law is not something that is neutral. It's something that could be really, you know, debated, could be really at the center of the social conflict between people that basically they coming in Italy just for asking rights. And on the other side, the state actors, but not only in reality European state actors, but also African state actors are not welcoming so much the quest for rights from the migrants, basically African migrants above all. Thank you again.
Thank you very much. So what I got here, and this is a very important point, that the law in itself was through, well, history, discriminatory in itself. And here again, I refer to the discourse of Valentina, who said vulnerability was a push factor. So if the law was discriminatory in itself, obviously vulnerability was a push factor. Thank you very much. Very interesting, a different perspective, and really appreciate that you could make it. Now I'm coming to Professor Juliana. I'm terribly sorry that it's a little bit late for you, but you said that it didn't matter if it's late. So okay. you were staying here from the beginning. I have seen you, so thank you very much. Because
I moved a little bit because I had to do, but yes.
Yeah, I've seen you from the beginning. So first of all, as Professor Morone said about Jean Monnet, I just wanted to say that I'm absolutely not the only one to congratulate, and probably Simone was another. Where is Simone? I think that he gave his talk and he disappeared, but he's Professor Juliana and Simone from Pisa, who is a historian. They are. Well, we are three of us of Jean Monnet in different areas, we will hear in which area. And this was also an opportunity to create this platform. So as I said, I have encountered two sort of problems. First of all, I have encountered that not everybody was so willing to participate, which I feel that it's really pity, because we all have something to say from different perspectives, and it's not a problem. It's exactly like this. We can have some ideas, and if we manage to have a book out of this, you will see those different perspectives. And the second issue was also something that I didn't really expect, but I'm telling you about this because it was the language. I did not realize that many of the Jean Monnet holders, they did not speak English at all. So it was an idea, but I had an idea, and I did this with our last speaker. So there is Professor Juliana. No, we are four. I'm sorry, terribly sorry. So Professor Juliana, Simone, and Professor Zahir. I have forgotten his second name. Hadibi, I think, but this is the only word that I know in Arabic. But right. So yes, Hadibi. And Professor Hadibi could not deliver this in English. He wanted in French. He deals with migrants and access to education. So I will come when we come to him. I will just tell you more about this. But finally, we are not three; we are four, and I congratulate to those three. Simone is here. Congratulate them, because yes, sometimes it's not so it's important. I think it's important to create this platform and exchange our different ideas, because the projects are not similar. So I imagine that where is Professor Juliana? So Juliana, first of all, she was she didn't make any problems. She was enthusiastic, and this is I really want to underline, because when you try to organize a big event, is important. Yeah, we have different projects, so I perfectly understand we not perfectly fit, but we can address something, and this is very important. So Professor Juliana has a project. I imagine her project, she put it me somewhere, that it was something on women, and I forced her a little bit to lean towards, because women alone are not considered in sense of EU definition in the CS system as vulnerable groups. This is exactly when a friend to me, I said, it's about the elderly women, and he said, women is discriminatory towards men. So it's not completely about women, but if they have some other characteristics. So Professor Juliana is from University of Tirana, and she is going to talk, her Jean Monnet module is EU integration and promotion of human rights in Albania, and she's going to talk about women with some other characteristics that are vulnerable, so from trafficking to integration. So thank you very much, and the floor is yours.
Thank you. Thank you so much, Professor Gromek-Brock. Thank you for the kind invitation and the truly interesting conference you organized. Well, I wanted to speak about Albanian women immigrants and some of the challenges that they have faced during different phases striving for their full integration into the Italian society. First of all, yes, I accept what I fully understand and accept what he said. Women are not to be considered a vulnerable group. That is debatable in some cases, but of course we'll see that when we speak about Albanian women immigrants, their background and their pull factors, for example, make them extremely vulnerable groups. Then in my presentation, I will try to take account about some of the difficulties regarding the Albanian immigrant women depiction, framing, and perception in the Italian media, which made really difficult for them this road towards integration. I'm fully aware that the story about Albanian women immigrants is the least actual case among those that were depicted today. But in this case, we maybe do have the relative distancing to draw a few reflections about this experience. Well, shortly, the problem facing Albanian women integrations is in accordance with the different Albanian waves of immigration since 1990. Each of these waves represented very different pull factors towards immigration. The first wave in 1991 regarding the regime change, extreme political confrontation, and of course the extreme economic deprivation. So this was the most acute and difficult time facing women immigrants. The second one regarded the financial crisis and civil disorders of 1997 as a consequence of the financial collapse in Albania. Then there was the consequences of the 1999 Kosovo war, while since the 2000, the Albanian immigration is considered mostly a success story, even regarding women, and we will see the data backing that. The demographic features of the Albanian immigration and the Albanian female immigration do coincide with these different waves, as I explained. The first part in the mid-90s was mostly represented by young, single, and male migrant population. In this period, a very dramatic, very dramatic trafficking stories of the Albanian women began. I will speak now about that. In the 2000s, in control tendency, the gender balance gradually is achieved as a result of the periodic reunification visas policy. Then we will speak about the Italian legal system in this case. As we're speaking, the average Albanian immigrant women ages of 32 years is slightly under the average immigrant women of non-EU countries. 62% of them do hold a secondary education degree and are mostly engaged in low-paid domestic work. Albanian women are not considered even actually very among the preferential nationalities to do domestic work, but we'll explain that after. Most of them, especially those of 40 years and more, do have a good knowledge of Italian culture. that is something debatable, because that it's not always coinciding with the reality of Italian society. Albanians tend even now to have very unrealistic depiction from the media regarding Italy. The tradition of the Albanian families regarding this woman is that of a very male-dominated and patriarchal society. But on the other side, we do have a very strong tradition of religious tolerance and even cultural assimilation striving. Regarding the most vulnerable among Albanian female immigration populations, this regards especially the years between 1994 and 1998, where a number of Albanian women were exploited and sexually exploited into the Albanian trafficking model. In different studies, the Albanian trafficking model is explained as having different characteristics, for example, from the Albanian, Nigerian, or Romanian or Moldavian trafficking model. In this case, the coercion is exercised by the exploiter on the woman and is very, very strong, abusive, and violent. These women had a very low level of autonomy, even compared with women, the trafficked women of other nationalities. The Albanian women were mostly exploited, not directly. They were not abducted. Most of them were just coerced by promising them a marriage, which is very characteristic in the most patriarchal societies, like Albania was. I prefer to say was. They were mostly deceived with the promise of this marriage, and more than 60% of the trafficked girls, women, were minors, less than 18 years old. Starting from the second half of the 2000s, there has been, on the one hand, significant changes in the traditional trafficking systems, and on the other, the emergence of new national groups. Also, due to the high levels of violence exercised, this Albanian trafficking system has substantially imploded, resulting in the progressive reduction in the number of trafficked Albanian women. The Albanian criminal groups, with the connivance of local Italian groups, have therefore dedicated themselves to the recruitment with of other girls, girls of other nationalities, for example, Moldavian or Romanian or North African girls. At the same time, they have modified the methods of managing prostitution. For example, by not anymore deceiving the girls with the promise of a marriage, but by deceiving them with the promise of working contract. Albanian women, since the 2000s, because of a number of reasons, were the second group touched by the application of Article 18 in Italy, and most of them were able to gain residence permit for social protection reasons. Almost 500 girls in 2001 were able to collaborate with the Italian police forces and that represented 11 to 14% of all of the permits given for social protection measures. Another, for me, reason to regard Albanian women immigrants in the 90s, during the 90s, as a vulnerable group was their depiction and framing in the Italian media. That made impossible for them to even try to have a normal life or to integrate into the workforce or even continue their studies and social life normally. This depiction and media representation was, of course, more present in certain nationalistic and extreme right groups, but it gained force into the mainstream media even. During the mid-90s, Albania was depicted as just a corrupt country, which it was or is, but it was depicted as only source of crime and prostitution, and considered just security or moral threat in the case of the stereotype of the Albanian women as just prostitute or sex worker. For example, in 1997, during the civilian and political unrest in Albania, a very popular television program with the peak watching numbers represented Albania in a dedicated programmation of it, entitled Strishala Berisha. Well, the name maybe makes you think about humorous depiction of our political leaders, but it was not them. It was full of stereotyping and stereotypes, especially about Albanian women, represented as just sex workers, and nobody questioned the problematic of having such a transmission during that peak time in very well-known media. From the 2000s, for a number of factors, there were changes in the trafficking networks, and the stereotype began to break. First of all, we can see that in the evolving of the demographic structure. After a number of laws during the 90s and until 2002, Albanian families were able to be brought together, so the demographic structure began to be more similar of that of the Italian family structure. There were a number of intermarriages. Of course, among the intermarriages with, there are more marriages regarding an Albanian woman and an Italian man than the other way around, but the median data are less than those of other non-EU immigrant populations, for example. It's interesting that among the persons graduated in Italian universities, 18% of them were of Albanian nationality, and among the graduated numbers, 53% of those were women, young women, as a sign of this change in the data of integration. A very interesting happening in the 2000s were the rise of Islamophobia, especially after 2001 or 9/11. which you would expect to regard even the Albanian population, which is by far mostly Muslim population, but it didn't. In a certain sense, the rise of Islamophobia, though for a very irrelevant happening, helped Albanian people integrate, as they came from a society which is very, very non-religious in mostly, or has a tradition of religious coexistence and tolerance. Albanian women are not, didn't coincide in this case with the stereotype of the Muslim women, which became the target of stereotyping and bad representation in the media or by political extreme factors. Since the 2000s, also the Albania itself did sign some progress in its integration process. We gained the visa liberalization, so all these factors contributed into perceiving less stigma among the Albanian migrant female population. Regarding the occupation index, it's interesting that during the legalization process, the Albanian women were the driving force in this process by legalizing even their husbands or other members of the families, and that was especially true for those working in the care of old people or the nurses. Albania and Italy have some collaboration agreements which made possible for the Albanian graduated nurses to come legally and work in Italy. That was also a very important factor. Also, something that heavily helped Albanian women immigrants integrate or ex-traffic persons integrate in Italian or back in Albanian society were the very vivid net of women associations in Italy. Actually, as we're speaking, there are 62 associations of Albanian women in the Italian territory. Most of them work to encourage the integration of Albanian women in the Italian society, to promote and raise awareness about the two cultures, and to promote the different interaction comparison dynamics between these cultures. I must say that something that made me really reflect, also although it's an integration not for the best of reasons, is last time I checked, two Albanian nationals, both women, were campaigning for a political force that in the 90s wanted every Albanian immigrant felt. Of course, it's something we can talk about. It's kind of internalized racism in some cases, and of course it has to be searched and it has to be seen more into it. But of course, it's data regarding integration. The second case was a very successful project named for a new image of the Albanian women, which was directed and conducted very successfully in the last 5 years by two Albanian teachers, both women, operating on both sides of the Adriatic. If I had to make a few remarks, some of the factors that contributed to a rapid integration and an immigration relatively successful story, as that of the case of the Albanian immigrant and trafficked woman, had to do with of course, in some cases, intergovernmental agreements and policies, the natural progress of Albania and the Albanian different governments toward the path of EU integration, some kind of anticipatory assimilation, as we call it, and it has to do with some psychological and cultural features of Albania. Then the work of migrant organizations and grassroots organizations raised in general, and last but not least, the lessening of stigma as a consequence of new migrant group arrivals. So maybe if we question ourselves what happened, where are the Albanians, why don't we continue to see the stigma and generalized stereotypes of immigrant women in the media? Well, that's because, unfortunately, new waves of migrants group have been given that unfortunate place and role. Okay, it's just the beginning of a way of seeing this problematic. I thank you all for the attention and wish you well for the continuing of the conference.
Thank you so much. Very, very interesting. Well, not to monopolize the discussion. Any questions first from the audience, and then any Professor Forlani, are you in a hurry? Professor Forlani, he was.
I was talking, but I forgot to switch on.
No, I'm just asking
the microphone.
If you're in a hurry, or we can address few questions.
Okay. Sorry, can you repeat, because I cannot.
My question is, can we still address a few questions?
Yes, for sure. Yes, for sure. Sorry.
Sorry. I just wanted to know.
Because I'm hearing you, and I'm hearing also my kid that is screaming. And
I understand.
So
a few seconds, and we will be with you. Okay.
Okay. Sorry. Yeah.
So, any questions to Professor Giuliana Marco? Professor Giuliana Marco, how you pronounce the second part of your name?
Marco.
No, but the second, Ginko.
Ah, Ginko. It doesn't matter. It's my husband's surname. I don't care.
No, there is no problem. Any questions? Because I have two.
Okay.
But I'm just asking if somebody else may be right. So the first question concerns when you talk about rise of Islamophobia and impact on vulnerability. You mean rise of Islamophobia in Italy or in Albania?
Italy.
In Italy, okay. No, because you addressed this, but
yeah.
But do you have some statistics? Because I'm not so familiar. Yes. Statistics, what I'm saying. So how the society in Albania is divided. So so it's predominantly
Muslim. It's according to the last census, it's 58% Muslim. Then it's 10% Catholics, 5.8 Greek Orthodox, Christian Orthodox. Then there are a certain percentage of Albanian nationals which declare themselves atheistic.
And I imply, but tell me if I'm wrong, that those who come to Italy, especially for the lower range job, they are from
They are mostly from Muslim background.
This is
yes, absolutely, but it's a kind of very, very moderate Islam.
Okay. No. It's just I just wanted to understand that finally those who are coming are mostly, not all, but mostly. Yeah. Right. The second issue, which this is a discussion that because what I would not agree with something, but you can tell me that I'm wrong, because you are talking about this anticipatory assimilation.
Yes.
So first, I would like to know what you want to mean by that.
Yes, of course.
Answer. I can tell you. I can tell you that what I don't really like the idea of assimilation, because I don't think that we need to become that this is what the European Union is about, that we have to allow people to be how they are, and we should not ask them to become something different. If this is not your background, of course we have to comply with certain rules, but the word I would say, couldn't we say anticipatory integration? No?
Just a moment.
No, I'm asking you. No, this is the question.
I fully agree. I would like that. I would prefer it very much. But as a matter of fact, the Albanian assimilation paradox has been profusely studied. It's a specific case. Albanian people for 46 years, well, most of them, have lived under a totalitarian dictatorship, of course, and Italia, especially Italia, has been perceived by them as the promised land. A promised land of freedom and of well-being, wealth, etc. The Albanians do have some issues with their identity, even with their religious identity. Even they perceive themselves as borderline between two cultures. The Oriental one and the Western one. Of course, for a number of factors, they prefer, mostly the new generations, they prefer to see themselves or to perceive themselves as Western Europeans, which is not exactly the reality, but even our nationalism in 1912 has been founded on our preference for the Western identity in order to escape from the Ottoman rule and that other identity. So it's a problem that does exist within the Albanian society. And in this case, it's very, very interesting because most of Albanian families, for example, I'm speaking about those having being Muslim, do not have a problem to bring their children in Italy in catechism. So,
okay,
most of them.
Okay, so now your assimilation means something for me, and I'm not discussing. Thank you very much, Juliana. Will you stay with us?
Yes, just half an hour or so.
Oh, yes, because we might have some other questions, but I don't want to, because we're quite late and maybe Professor Forlani has something else to do. So Professor Forlani is again from the University of Pavia, and again here, it's going to be about hired from abroad, so those who are coming to Italy to do, I believe on again from the lower background that well, this is how I understand, but the title might mean maybe something different, but this is how I imply. but very important, very interesting, and really contributing to our discussion. Professor Forlani, the floor is yours.
Okay, thank you. Thank you to invite me here. It's very nice that our department won this chair, so I'm very happy to be here. Okay, I'm an economist, so I will provide some sort of economic analysis of the migration phenomena. And sorry, I'm going to, let me move, sorry, the Zoom icons. Okay, I'm going to talk in this discussion, I'm going to talk about the impact of immigration on the fertility choice of native women and the optimal allocation of time between home production and work of native women. Okay, for a sample of developed economies, or in another case for Germany. The main point is that females are more vulnerable than men in the labor market in general, also in the developed economies. So they have a lower participation rate, they are paid lower wages, it's very difficult to them to reconcile household duties and labor, they have fertility choice. Should I have a kid or should I work? I cannot reconcile. And usually these fertility choices are moved, let's say, in the first child, especially in the developed economies, is moved at older ages, both for Germany and also for Italy. I'm not going to provide evidence for Italy, but I'm going to focus more on Germany because I had some data on Germany, and we were with some colleague of mine that lived in Germany. Okay. And then the point is that sometimes these family policies in the developed world do not allow to reconcile family and work for women. So sometimes an help can come from immigrants that came from abroad, and in particular from low-skilled immigrants or female immigrants. I would say the less attractive immigrants. Why less attractive? Because usually developed economies are trying to attract skilled migration. Migrant, let's say, I would say this expression, fancy migrants with PhD, or with a higher education degree, bachelor degree, or that can be educated and be employed in sector with higher wages. So there are different policies, H1B1 visa in the US, there are blue card in Germany, or there are point-based system in UK, Australia, New Zealand, Canada, and so on. So usually, instead, in this case, migration from low-skilled immigrants or people that are used to do poor jobs in our perspective are very useful to allow women, native women, to reconcile labor and family duties. Okay, so on the other hand, the idea is that immigrants are a significant fraction of employees in sectors that provide services to the household. Services to household, I mean child care, house care, keeping, but also some healthcare services to elderly people in the household. Okay, so there are different types of services that can be provided by migrants. These migrants increase the supply of these services, and on the second order effect, reduce also their market price. So it's easier for families to afford these services and allow native women to participate to labor market or to reconcile their aspiration. I mean, I'm not claiming that women are forced to participate to labor market, but they have a choice. They can choose between they can choose freely how much time allocate in the labor market, how much time to allocate in the household activities, assuming that, and where we should use some evidence, that the men are not affected by the availability of these services. Okay, so this effect would induce women to change the decision to allocate how much time allocate in work and how much time allocate in services. And in particular, the main focus of this talk is to understand if this migration, if these services provided by migrant can affect the traditional trade-off between fertility and work. So what I mean for the traditional trade-off, I mean that in not only in developing countries, but also in developed economies, there is a negative correlation between number of kids or number of child, or the simple decision to have one kid, and the time spent at work the decision to work and how much to work. Okay, so just to move quickly, I just to skip all the literature review related to that. But what is interesting is that there is some studies on the relationship between immigration and fertility, especially for the US, because US is more able to provide, there are much more data, and there is evidence that low-skill migration. So when we talk about US, we think about low-skill immigration to the migration of Mexicans, documented and undocumented, that goes from Mexico to the US or from Central America and provides some services to the household. Okay, and so these migration flows are higher. Okay, and in the location where these migration flows are higher, there is the traditional trade-off between work and fertility is reduced. Okay, and in particular for high skill women. Okay, so for women that have a higher level of education, so these women in some sense are much more able to pursue their aspirations. So with a higher education, they're also able to, in some sense, to work more and to work more. Okay, in particular to work more. Sorry, I'm just confused. To work more, to provide more working hours. Okay. Okay, and instead in my research, we just focus on a sample of, in one case, we focus on a sample of different countries. Okay, and what we saw is that we make a cross-country comparison between US, Australia, Switzerland, Germany, and UK, and we observed that the amount of a skill migration increase the probability of women to be employed or to work longer hours. In particular, the effect is stronger in the terms of probability to be employed for unskilled women, unskilled native women. So migration, so the services provided by unskilled migrants, services for the household, increase the probability of native women, unskilled native women to be employed, while on the other hand, increase the probability of skilled women, so the women with a higher degree, bachelor degree, let's say, tertiary education, to work for a longer hour. What is very interesting is that the effect is stronger in countries with less supportive family policies. Okay, so in countries where the family policies are not very supportive, this effect of migration or this effect of hired help from abroad help more women to participate to labor market. I would skip technical details here are reported, and let me a second. I have a pencil. Okay, a pencil here just to show to you. So here, just why cannot? No, this is not a PowerPoint, but you can see. I think the end of the screen here is the effect of migration. So a positive sign next to this number means that migration helps women to work longer hour or to be, sorry, not in this case, just increase the probability of women to work, to be employed. And you may notice that the fact that these women are married or these women as some child in the household decrease their probability to be employed. So the fact that there are child in the household or the simple fact to be married, so or cohabitant or legally married, decrease their probability to be employed. Okay. And on the other hand, the fact that there are some older people in the household, so elderly than 65, increase their probability to be employed. But in this case, there are other results I'm not showing to you that in this case is the fact that this positive effect works only for young women. So we assume that these women, these young women, as in the household, young, let's say, relatively young old people, around 65, between 65 and 70. So people that may help you to reconcile work and family activities. While if you consider other women, the importance of old people in the household became from positive to negative. So the fact that there are old people in the household of relatively old women, so around, sorry if I use this term old, women is not old at the age of 45, but that's the That's the term to differentiate between 45 and 25. So I'm not claiming that a 45 years old woman is old. It's just a differentiation with 25, the age of 25. So in that case, it's very likely that there are the elderly in the household are people that that need care. Okay. So and yes, unskilled migration in services is a substitute for family bonds. But let's focus a little bit more on the fertility and in the case of Germany. Okay, we consider women why in the age of 20, 22, 35, because basically these women are out of education, more or less, they are out of the education, and so they are more likely to be employed or not. So they almost finished the education, they are in the fertile age. Okay, so we consider a trend. Usually in the literature is considered this age bound, 25, 22, 35. Okay, and so women have to choose between work, yes or not, and for how long, and or if, let's say, be to have a newborn in the house. Okay. So the idea is that the fact that the immigrants help to decrease these negative correlation between the probability to have a child and the probability to work for longer hours or the probability to be employed. Okay, differently from the previous study, from the preview for the previous research, we do not use the share of unskilled migrants, but we use the share of female immigrants in Germany. There is some evidence that most of the women that are immigrants in Germany are unskilled and works in sectors such as household care activities or care activities. So they take care of the child, so child care activity, or they take care of the old people with some sort of also health services, or they are employed in sectors such as cleaning. Okay, so housekeeping, pure housekeeping. Okay. I'm just going quickly through the statistics and I just move faster to the result. Okay, so here just to show why we focus on that, because there is a strong problem with Germany in terms here. Sorry, you can see the hand in terms of fertility. So Germany is among the European countries, at least at the time of the study. Now the situation is a little bit changed, because in Germany the family policy has changed let's say in 2009. In 2009, so the last 2 years we saw the effect. So Germany, Italy, so are the countries, Spain or Greece are countries with the lowest fertility rate. So the lower number of child per woman. In SER is not good or not bad, but maybe it's true that in Germany it's very difficult, such as in Italy, to reconcile fertility and working activities. There are no service. It's not exactly that there are no services, but it's very difficult for a woman in Germany to come back from let's say maternal leave to employment. Okay. And here is what I told you before. Here is the share of women that are employed, of immigrant women employed by production tasks. So the red bar are the women and the blue bar are the men. So, and the number 0, 1, 2, 3, 4, 5 are the production tasks, and the data refers to 2010. And in the refers obviously to Germany. You can see that most of them are in group 9 and group 5. In group 5 there are childcare or health care activities, so employed in this sector, and in group 9 there are elementary occupations such as housekeeping. The other high number is number 3, but in this case also here are included nursing activities, so professional nurse. Okay, and here is how immigrants are let's say, spread across Germany. So most of them are located in the west part of Germany. So especially in Bavaria, Baden-Württemberg, and in the cities. Here is Bremen, and here is Hamburg, and okay, clearly there is Berlin on the east part. Okay. So what is the effect of these female immigrants in terms of household labor market supply? What does it mean? So which is the effect of immigrants in the supply of services that useful for the household activity? So there is a positive effect in the sense that in regions where it's higher the share of female immigrants, where higher is the share of female immigrants, in that region is higher the supply of services such as nurse care services or home care services. Okay, and these results are positive also when we take into account some sort of, for who is confident with the statistics and econometrics, some effect of reverse causality. So that immigrants are locating in regions where there is a higher availability of these services. So this effect is, let me say, we control for this sort of effect. Okay, let's keep all these kind of technicalities and let's focus on the result. Well, so which is the effect of migration? So the effect of migration is that migration allows or increases the probability to have a child for women which has a medium skill level. So in Germany there are we can consider three different skill levels. Medium skill level is women with a professional level of education. Okay, but what is very interesting is that this effect is particularly strong for women in the age 36-35. So women that are close to the end of, sorry this terminology, but to the end of the fertile period. Okay, so they help women to, in some sense, have an additional child if they want. The effect is not I'm not reporting the result, but the effect is not on the first child. So the first child is independent on the availability of the services and so on. So the choice of the first child is related to personal preferences that may be strong or not. Okay, so but instead in this case, the probability to have a child, and in particular the second and the third child, we call it newborn, okay, is higher in regions where there is a higher availability of these services and where there is a higher share of female migrants. They may help women to have a child. But what is relevant, okay, I told you that for other women, but, and I think this is the most important result, is that the last 5 minutes, the probability to reconcile fertility and employment or labor activities is higher in regions where there are migrants. What I mean? I mean that in regions where is stronger the share of female immigrants, so in that regions is higher the probability that women has in the same period both a child and to maintain the employment status, to be or part-time employed or full-time employed, at least for 1 month. Okay, so the presence of migrants help women to, let's say, to reduce this sort of a weakness that they have in the labor market compared to men. And this effect, again, is particularly strong for women at the age of 35, 36, 45. Okay, not younger women, but women that are closer to the end of the fertile period. Okay, and this effect still is also, is another text to say that this effect is relevant for the medium skilled employed women. So migration not only had to work longer hours, does not only to help women to remain employed and at the same time to have a child, an additional child, okay, and help to the household to have an additional child, but help women also to work longer. And in particular, that's what I'm interested in, the presence of migrants reduce the time spent by women in the household activities. Okay, So in particular in the family, so in regions where there is a larger share of female immigrants, is lower the amount of time spent by women in the childcare or housework activities. Okay, so they help really to women to be native women, German women, to be to suffer less by the fact that they have child, and they have not the support for cultural reason, they have not the support from the male. Okay, and what is interesting is that the fact that there are immigrants in the region does not affect in any case the role of migrants. It's not the role of men in the family. So if there are more female migrants, men does not work anymore. They are not affected. So it suggests that native men are not affected by the fact that there are kids or not in the household, or there are any kind of household duties. They continue to work, and the presence of migrant does not change the amount of working hours that they provide, and is not going to change. Sorry, what is it? Is not going to change the fact that, or is not going to reduce. You're not going to reduce the fact that that they work less in childcare activities or housework activities. They continue to work the same amount, few amount, because I'm not reporting the table, but they work few times, much more less in household activities compared to women. And in some cases here, okay, in the last years, some underlying, no, just the 5.2. So it suggests that where there are more immigrants, it's more likely that in families with kids, medium-skilled men work for longer hours in childcare activities. Okay, so what I want to show to you is that the share of female immigrants is very likely to be employed in, let's say, in poor tasks, so in tasks where for housekeeping or childcare or some sort of care of elderly in the household, has a positive and statistical significant effect on the probability of having a child for the medium-skilled native women, and a positive and statistical effect on the probability to work and to better reconcile household to be simultaneously employed and to have a child. Okay, so in some sense, the presence of migrants is going to reduce the weakness of women, of native women, the historical weakness of women in the labor market. Okay, I think I can stop here.
Thank you very much. So I think that you were the first, I'm not quite sure, the first economist in our conference, but I hope that it would continue, because I just would like to foster this interdisciplinary research.
I hope that I did not bother you too much with this technical.
No, there are many issues that I'm really interested in. But if you can stop sharing your screen, yes, thank you very much. So I can see the others and so on. So the first of all, you were saying about that they had some problems to come back to work, but how do you reconcile this with the EU legislation that says that you cannot dismiss a woman on maternity, or pregnant woman or on maternity? And for instance, I can give you an example that in Poland, for instance, they were usually doing this at the first month that the person came to job. So unless what you are saying that they work in black. And if they work in black, you can dismiss them anytime because you are. So this is my question.
No. I mean, in this case, we're not talking about this. Unfortunately, this kind of attitude to to employ black. The reform in Germany was simply that they provide higher paid maternal leave to German women. Is going to change. So in that case, has changed in the sense that is less inconvenient to leave the job for some let's say childbearing reasoning. So you are paid higher. So the maternal leave are better paid, a little bit shorter, but are better paid. In particular for women with higher wages. Or let me rephrase: you have a double option, or you can have much more money for a short time, okay, and then you go back to work, or you may have a little bit less money, but you can stay longer. That's the first point. Then the second point is that, unfortunately, I cannot document here because there are some indicators that are provided by, I mentioned in the other research, is a German institute, SGI. They do some research, and they do every year a report on the family policies across developed economies. And for example, other policies can be to facilitate the breastfeeding in the offices. There are rooms for not for breastfeeding, but sorry, I'm not I do not know.
There is breastfeeding, but yeah.
Not breastfeeding, but the collection of milk. I don't know. Sorry, my apologies. So you can store the milk for your baby and then bring back at home. You know what?
Well, I don't know neither. Well, I don't know. Maybe somebody from the audience would know how you. But I think that there is no specific word for this. I think that what you are saying it's right.
No, I don't know if it's clear because I had the experience that, for example, for my wife it was a little bit difficult because there are no places when you work and then there is your kid at home. You need to do some. It may be very difficult, and sometimes you can wait death, or there are no services, or there are no nursery. There are no. For example, in Italy, the point is that there are very, very few services provided for kindergarten, such as kindergarten, and then there is also cultural reasons. So in some areas, it's considered deplorable to send one-year-old kid in a kindergarten. Okay, so there are also cultural elements, I would say.
So thank you very much. Any other question? I just we have one more talk. Leonardo, where is Leonardo? Do you have this talk?
I'm here, Professor.
Ah, yes, because you put it host, and then you're just like you.
Yeah. I'm starting the broadcasting.
Brilliant. No, because what I wanted to say that we have the last talk, and I really would like you to stay for this talk because within this trying to create this platform, I just realized that there is a problem of language, but I think that we have to foster this because it makes sense if we can participate, all of us, and so on. And Professor Hadibi, as I said, this is the only word that I know in Arabic. Professor Hadibi said that he could not. So, Professor Forlani, if you want to stay with us, we have just only one talk.
Yes, I hear. I just switched.
All right, okay. So thank you very much, and we really appreciate your economic perspective into this because it's important. Because finally, it could be either a push or pull factor, and well, the further research on vulnerability, who really is vulnerable within the European Union. So, telling about our last contribution. So I contacted everybody from who had got Jean Monnet grant, and this is I think either anthropologist or sociology. It is distinct from anthropology, because in some systems anthropology is linked with sociology. So I don't know. And his research is on access to education, and he prepared his talk in French, but I was very bossy and I forced him to prepare slides in English. So he did so, but he preferred to register this because he was traveling from well, somewhere, because finally he's from Algeria, he lives there, and he said that the connection is so unstable that at least if we have a recorded session. So please don't leave, because I'm really grateful that he wanted to do it, because the first answer of everybody is, oh, this is not my topic, because we wanted. So I'm really grateful to those who wanted to contribute, despite their first reflection, it's not my topic. So once they wanted to contribute, so let's give him this time and listen to the last recording, and then I will close the session. I think that well, first of all, I really would like to thank you all for your contribution, time, and for exactly not saying it's not my topic, so that you wanted it to be your topic. So thank you for this. Carissimo Damiano, where is Damiano? Yes. So let's listen. Access to education for vulnerable groups, which would be probably children.
Donc voilà, bonjour très cher Katarsina, merci pour l'invitation pour participer à cette conférence. Je m'excuse de ne pas pouvoir être en ligne demain pour des motifs de déplacement, mais je vais vous présenter ma communication à travers cette vidéo et je vous laisse mon adresse vers la fin pour recevoir vos questions avec plaisir. Donc pour commencer, notre communication porte sur l'accès à l'éducation en Algérie de migrants en position de vulnérabilité. Il s'agit d'enfants et de parents isolés. Voilà, donc sans trop tarder, pour commencer, je vous présente le plan de la communication qui s'articulera sous cette forme. En premier lieu, quelle est la politique migratoire de l'Algérie? En deuxième lieu, le profil de ces réfugiés, leur nombre, estimation et volume. Et en troisième lieu, et c'est le plus important comme axe, il s'agit de l'intégration de ces enfants en position de vulnérabilité dans le système éducatif algérien, tout en mentionnant vers la fin les difficultés et les défis qui existent en termes d'intégration dans le système éducatif. Donc, sans trop tarder, comme introduction, il s'agit de dire que la question migratoire en général a commencé à s'imposer avec acuité dans les débats académiques et politiques, notamment ces deux dernières en position de vulnérabilité, notamment les enfants et leurs parents isolés, représentent un des segments structurels de ces mouvements ou bien flux migratoires qui ont commencé à jaillir de tous les sens dans la région de l'Afrique du Nord, notamment ces dernières années. Et les populations vulnérables sont constituées en termes consacrés par la législation nationale.
I think I wanted too much and
de réfugiés, de demandeurs d'asile.
Professor, doesn't it work?
No, it works, but the volume we can't.
Okay, I manage the volume and I come back.
So let's continue how it is, because we can put the volume up on our computers.
Qui nécessite une protection particulière internationale. Donc voilà, quelle est la politique migratoire de l'Algérie? Pour commencer, il s'agit de dire que ce pays qui a été pendant de longues années, notamment après son accession à l'indépendance, un pays pourvoyeur de migrants, c'est-à-dire des migrants qui sortaient de l'Algérie pour rejoindre le Nord, l'Europe, l'Amérique, l'Asie, le Moyen-Orient, etc. Mais ces 2 dernières années, il y a une particularité, c'est que des flux migratoires commencent à arriver des autres pays, notamment les pays africains, subsahariens, etc. Donc l'Algérie, à un certain moment, était un pays pourvoyeur, mais ces dernières années, elle est un pays pourvoyeur et récepteur également. Donc c'est un pays d'émigration et d'immigration. Ça, c'est un premier point. En deuxième lieu, il est à signaler que l'Algérie n'a pas une politique globale en termes de migration adoptée aux standards internationaux. Toutefois, il y a des départements qui interviennent pour des missions bien pointues. Donc, pour parler de populations vulnérables, notamment les réfugiés, par exemple, aucune loi organique n'existe sur cette population. Toutefois, il y a ce qu'on appelle une intervention pointue de plusieurs départements qui gèrent ces flux. Bon, en premier lieu, par exemple, il y a les 2 départements les plus importants. Le ministère des Affaires étrangères qui régule l'immigration régulière et celui de l'Intérieur et des collectivités locales qui régule l'immigration irrégulière. En deuxième lieu, il y a le ministère de la Défense qui s'en charge de la sécurisation des frontières. Vous savez bien que les frontières algériennes dépassent les 6300 km, partagées avec plusieurs pays, 7 pays plus ou moins. Mais il y a également d'autres ministères qui interviennent pour gérer des flux ciblés, à savoir les étudiants, par exemple, le ministère de l'enseignement supérieur, le ministère de la formation pour ce qui est de la formation, le ministère de l'emploi et de la sécurité sociale pour ce qui est de l'intégration des étrangers dans le marché professionnel algérien. Mais il n'y a pas que des acteurs institutionnels, il y a également des acteurs de la société civile qui interviennent et qui ont un apport considérable, à l'image de Croissant Rouge algérien, le Conseil national économique et social, mais aussi des ONG ou bien des associations comme AFAD et le réseau NADA qui s'en chargent de l'intégration, de la protection des femmes, notamment étrangères, mais aussi des enfants, etc. Donc globalement, c'est ça la politique algérienne de gestion des flux migratoires. Il n'y a pas de politique commune adoptée, mais il y a des interventions de plusieurs acteurs qui gèrent ces flux. Donc, si on revient au profil des réfugiés et leurs estimations, et parmi ces réfugiés, on trouvera par la suite l'estimation des enfants, des enfants dans le système éducatif, etc. Donc, on profile de ces réfugiés dans des populations vulnérables. Il y a des données qui existent selon les institutions internationales parce qu'il n'y a pas de statistiques officielles de l'État données à ce niveau. Donc, le NDSA, par exemple, a estimé à 249 000, un peu plus de 249 000 étrangers en Algérie. Donc, 80% de ces étrangers seraient des populations en déplacement forcé ou bien des réfugiés. Et à l'intérieur de cette population, la population la plus importante, ce sont les réfugiés du Sahara occidental, qui sont au nombre de 163 000 Sahraouis, et par la suite, il y a un peu plus de 31 000 Palestiniens, 3 000 Syriens, 2 300 Libyens et 2 300 Yéménites. Ce sont des pays qui connaissent ces derniers temps des mouvements ou bien une situation sécuritaire et politique instable. Et parmi ces populations, il y a un nombre important d'enfants en situation de vulnérabilité. Donc, pour la population générale des camps de réfugiés, ce sont les camps de Tindouf avec cette population. Donc, le pays est en situation de conflit avec le Maroc.
Damiano, something happened. Damiano? Damiano? Damiano?
Non ti sente più? Eccolo qua, di nuovo.
Damiano?
E si sente basso, Caterina?
Io non sento niente.
Sì, si sente.
Damiano? Damiano? Voi sentite qualcosa?
Molto basso.
But you can hear now.
No, I don't hear nothing.
Yeah, I don't hear nothing. Damiano, Leonardo, Leonardo, Damiano.
Where you are?
Io ci sono, però non posso fare niente perché lui è lost e sta condividendo lui lo schermo.
Hello. Can we do something about it? Hello? Hello, Damiano, Leonardo. Damiano. Carissimo.
Le plan de la communication qui s'articule là, se forme en premier lieu les territoires d'origine, en deuxième lieu le profil de ces réfugiés, le nombre et les destinations évoluent, et en troisième lieu, c'est important comme axe, et c'est une intégration de ces enfants en position de vulnérabilité dans le système éducatif algérien, tout en mentionnant vers la fin les difficultés et les
Hello. So let's just please don't let him finish. There is a problem with Zoom. Can you hear me, Antonina?
Ah, yes, I listen.
You can hear me, right? So apparently there is a problem that Zoom delayed something. So please don't go. Let him, because however he prepared, he wanted to participate. It's it is very well structured, and you know, just the Cartesian way of structuring a discourse. So let's not leave yet, and let's hope that we will be able to. Yes. So shall we go? Shall we go further? Because we have seen already the structure. So we were somewhere in the end of the. I think that we were more. Yeah, this is more. I've seen this. I think here we can.
Yes. Yes. Okay.
Okay. I start.
Yes. We can't hear anything.
I hear the voice, but
you hear something because
yes, but now nothing.
Nothing.
No.
Is there? I think that for some reason. So let's.
Here I am, Professor. I need you give me the privilege to be a co-host.
So what shall I do? So tell me what I have to do. Yes, you are a host if you want. If I don't have to do anything, if I have to do, let me know what I have to do.
It's quite difficult. I tried the last time.
Okay.
et d'orientation scolaire, notamment en termes d'accès.
It works.
Voilà. Donc, on l'a dit avant de commencer la présentation que l'Algérie n'a pas une loi dédiée aux réfugiés. Toutefois, les populations, ou bien les personnes déplacées, bénéficient depuis des années de certains droits dans le cadre de la protection et l'accès à l'éducation à ce titre. À titre d'exemple, en 2012, par exemple, il y a eu des discussions du Haut Commissariat pour les réfugiés avec ses partenaires du gouvernement algérien. Ces discussions ont permis de donner accès à tous les enfants réfugiés et demandeurs d'asile aux écoles publiques. Donc, le gouvernement algérien accorde l'accès à l'éducation, mais pas seulement, à la santé également pour ces réfugiés et demandeurs d'asile sur l'ensemble du territoire national au même titre que tous les Algériens. En plus de la coopération mentionnée, dans le contexte urbain, le Haut Commissariat aux réfugiés collabore étroitement avec un bureau créé spécifiquement au niveau du ministère des Affaires étrangères et le Croissant Rouge algérien pour la gestion des populations qui commençaient à arriver à cette époque. Ils étaient des Syriens et des Maliens. Cet extrait, il fait allusion à deux nationalités, du Mali et de la Syrie, en 2012. Toutefois, tous les migrants en situation irrégulière en Algérie allaient bénéficier de l'accès aux soins et à l'éducation. Le Croissant Rouge algérien a ouvert des foyers d'accueil pour les Syriens au niveau du nord du pays et pour les Maliens au niveau du sud. Donc, au-delà des Maliens, les autres enfants en situation de vulnérabilité accèdent depuis cette époque d'une manière automatique au système éducatif. Donc, au-delà de l'apport de l'État, il y a des associations spécialisées dans ce champ, à savoir l'association NADA, qui s'occupait de la scolarisation des enfants, des réfugiés, et l'ONG Médecins du Monde intervient également dans l'aspect relatif à l'accès aux soins pour les enfants, mais pas seulement, y compris les autres catégories. Donc, selon les données opérationnelles du UNHCR 2019, il y a en Algérie plus de 39 000 enfants qui sont scolarisés au niveau primaire et plus de 8 100 au niveau préscolaire. Donc, ces données sont publiées sur le site de ces institutions internationales et qui précisent que plus de 98% de ces enfants réfugiés qui sont âgés de 6 à 13 ans ont été scolarisés dans les camps. Et les camps, ils se réfèrent aux camps de réfugiés des populations sahraouies. Donc, c'est 39 383. Et sur le financement de ces réfugiés dans leur accès à l'éducation gratuite et dans l'enseignement supérieur, c'est l'État algérien qui considère que ces réfugiés qui, comme des étudiants algériens, doivent bénéficier des mêmes droits, y compris des bourses. Donc, après un passage dans le système éducatif, s'ils parviennent à accéder à l'enseignement supérieur, ils suivent le même rythme de scolarisation que les étudiants algériens, c'est-à-dire la gratuité, mais aussi l'accès à la bourse sans aucune restriction. Voilà, mais toutefois, il y a des difficultés malgré ces acquis qui doivent être mentionnés. Des acquis comme la gratuité de l'accès automatique pour tout enfant qui se trouve sur le territoire national. Il y a des difficultés qui sont importantes et qui portent sur la qualité de l'éducation primaire qui reste en deçà des standards, notamment dans les camps des réfugiés de Tindouf, ce qui se traduit par un important échec scolaire. Selon des données de l'UNESCO, il y a, c'était en 2015 ou bien 2016, un peu plus de 50% comme taux d'échec scolaire et la qualité des infrastructures, notamment la nourriture, les classes, le transport, etc., sont à améliorer d'une manière remarquable, car il y a un manque très important à ce niveau. L'autre difficulté ou bien l'autre défi qui existe porte sur le recensement de tous les enfants étrangers en situation de vulnérabilité, car il se peut qu'il y ait des enfants qui sont en situation de vulnérabilité, qui se trouvent sur le territoire national, mais qui n'ont pas été recensés par l'administration publique parce que tout simplement, ils ne se sont pas présentés, les services n'ont pas parvenu à les trouver ou bien n'ont pas demandé une protection auprès du HCR. Donc, des enfants peuvent être délaissés de côté, ils n'accèdent pas à ce droit élémentaire qui est l'éducation. La troisième, par exemple, difficulté qui existe, à savoir la mise en place d'un mécanisme d'accompagnement spécifique aux enfants et aux parents isolés parce que ces enfants ont subi des chocs psychologiques et nécessitent une aide économique et une incitation pour accéder au marché de l'emploi avec tout le soutien psychologique nécessaire. Donc voilà, j'ai essayé en partie de vous résumer les données que j'ai rassemblées sous format de cette vidéo multimédia. Je vous laisse mon adresse électronique pour vos questions. Je répondrai tout au long de la semaine avec plaisir. Je vous remercie et je m'excuse pour le fait de ne pas pouvoir être parmi vous.
Okay, so thank you very much for those who have remained with me. I know that the day was very long. Thank you very much, Zahir, if you are listening to us. It was very interesting. My questions would be, how about, so who is financing this? What is the follow-up, for instance, for children with difficulties, that, for instance, those that they have learning difficulties, they have dyspraxia, dyslexia, are there any special means, assistance provided for them, and exactly this assistance for vulnerable groups. Very, very well structured and very comprehensive, and thank you very much. I'm sure that you are listening to us maybe on YouTube. If not, well, what I understand, it's going to stay on YouTube, so you will be able to listen to this conference from the beginning. So thank you very much to all of you. Really appreciate it. Thank you for your time. It was a very long day. I think that we have covered all possible concepts and ideas about vulnerability. And in addition to this, maybe exactly interdisciplinary, maybe sometimes a little bit outside, but it doesn't matter because we can think about it and it could provide some sort of idea into our research, publications, and so on. So thank you ever so much for being with us, with me, with us, and wanting to share your experience, your research, your dedication, and so on. So thank you so much.
Thank you.
Thank you, Antonina. You were all day here. I've seen you. So thank you so much. And thank you also to our researcher, Damiano, who finally did a lot, to our technician, Leonardo. Is Leonardo here or just left? Yes, Leonardo. Yes, Leonardo is here. So thank you very much, Leonardo. Thank you very much. As I said, our researcher, who is now me, but we are delighted that he is. Leonardo, we did, and thank you again to all participants. As I said, that you wanted it to become your topic and that you didn't dismiss and you wanted to participate and so on. I thought that it was interesting. What do you think?
Yes.
Yes?
Yes, of course. Thank you for your capacity to explain, to direct the day that was full of interesting papers.
Yes, exactly. There were a lot of interesting papers, but we are not going to do this every day. For me, I'm done for this year. So, so thank you so much. Thank you again, everybody. Thank you, Leonardo, Damiano, Leonardo. Just that I don't, thank you for all assistance, because without you, I would not be able to do anything. And before October next year, I'm not doing anything. So, so you're absolutely free. You can assist whoever you want, but you won't have to assist me. So thank you again, and good night. I can say we started with good morning. Now I'm saying good night, and thank you again.